Good afternoon. Thank you for joining us on this live webinar. Today's topic, does child custody matters need to be a fight? And if you can see on my right-hand side, there's a lady hitting a guy. I'm not trying to be gender unequal, in the sense of why is a female hitting the man. I did for a picture online and that's the one we could find. Nonetheless, it's proverbial, fight not necessarily physical. Does child custody matters need to be a fight in the sense of, must it be a battle? Must it be an argument? Must you get lawyers on board? Must you, put up guards and prepare yourself to take the other party on or to teach the other party a lesson? Must there be acrimony? That's where I'm going to. Or can the matter be amicable, friendly, settled easily? Is that possible? Or does it need to be a fight from the word go? For argument's sake, if the mother says, Father, is it fine if you do not have contact on a Sunday evening so that the minor child can come home early in order for me to prepare him for school the next day? The father says, how can you tell me that? I'm the father. I can decide when I want to bring the child back. There's this continuous acrimony, argumentation all the time. So that's the topic. Does child custody matters need to be a fight? Or can it be amicable? Can it be friendly? My advice to you is, if you want to get good results out of your child custody matter, it should not be a fight. That's where I'm going to. Once parties are no longer civil with each other, whereby the parties are now arguing with each other all the time, they're always involved in acrimony, they're no longer amicable and civil as they used to be while as they were together as husband and wife, as partners, lovers, friends, whatever the case may be. Once that is out of the window and the parties are losing respect for each other, the challenge which we as lawyers and third parties who are there to assist parties in resolving the issues have is that the door, or that one specific door that you could always use in order to resolve issues, are no longer there. That is the respect the parties have for each other. I can use a simple example. If there's a meeting taking place, there's a chairperson and there are parties to the meeting, and the meeting follows a certain procedure. When one person speaks, the other person listens, and so on. You can object if you want to, but in a very nice and proper way. However, if people start shouting at each other, they start disrespecting the chairperson starts disrespecting the participants of the meeting. What happens then? They lost respect for each other. It is virtually, not I would say impossible, but it will be extremely hard for the parties to move forward in a constructive and a workable manner. It's very hard. Therefore, the question which I am posing again, does child custody matters need to be a fight? My answer to that is simple, no. It does not have to be a fight. It has to be understandable. There needs to be understanding. The parties need to be able to be in a position to listen and ponder upon what the other party is saying, where they're coming from, where are they going to, and with the hope that the other party will understand where you're coming from and where you're going to. However, if the parties are entering into the specific arena, into this ecosystem, with the intention of battling and fighting and showing the other party a thing or two, 9 out of 10 times, the matter will not be resolved in an amicable manner. And what does it mean? It means that you have to get lawyers on board. You might not get what you are entitled to. Justice might be delayed. For argument's sake, let's say you are the father and you'd like to have contact with the child on a certain date because you took this antagonistic approach in dealing with your specific problem. The other party might be very hard-headed, make life very hard for you, causing you to incur more fees, causing you to pay lawyers a lot of money in order for them to fight your battles for you. And at the same time, should this matter come to a court, to a tribunal, the magistrate's court, the children's court, whatever the case may be, and they see these issues before them, that father and mother are very toxic with each other. In other words, whenever the mother and the father are in the same room together, They start arguing, they start fighting. And that might have an adverse effect upon which order or what type of order the court may make in the specific child custody matter. So in short, that's what this video is all about today. That child custody matters need to be a fight? The answer is no, it does not have to be a fight. It is advisable if it is not a fight. In that specific way, you will get the best possible results in the matter. I hope it assists you, and thank you for watching, and I hope you have a lovely day.
Good afternoon. My name is Mohammed Abduroaf. I'm a practicing advocate in the Western Cape, and today's short video will deal with the aspect of child maintenance. When it comes to child maintenance, the child's best interests are of paramount importance. This principle is immortalized in our Constitution and applied in our courts of law. Therefore, in relation to child maintenance matters, and specifically to child maintenance courts, the moment a parent files an application for child maintenance, the principle should apply. Before we move on a side note, it is not only child maintenance that a maintenance court deals with. A spouse may take the other spouse to the maintenance court for personal maintenance. Let's move on to parental maintenance obligations. Both parents have a duty of support towards their minor child's proper living and upbringing. This should be in accordance to their means, standard of living, station in life, and the needs of the child. This is found in our Constitution, common law, and also applies to divorced parents. According to Section 15.2 of the Maintenance Act, the duty extends to such support as a child reasonably requires for his or her proper living and upbringing, and includes the provision of food, clothing, accommodation, medical care, and education. Furthermore, the duty is not discharged when one parent earns substantially more than the other. According to Section 15.3 of the Maintenance Act, in determining the maintenance amount, the maintenance court must take into consideration the following: that the duty of supporting a child is an obligation which the parents have incurred jointly, that the parents' respective shares of such obligation are apportioned between them according to their respective means, and that the duty exists irrespective of whether a child is born in or out of wedlock, or is born of a first or subsequent marriage. Any amount so determined shall be such amount as a maintenance court may consider fair in all the circumstances of the case. Lastly, there is an onus on both the maintenance officer and the maintenance magistrate in placing evidence before the court in determining a fair maintenance amount. This is our starting point. Processing the maintenance application. When a parent approaches a maintenance court for child maintenance, it is the duty of the maintenance clerk to expeditiously process the application. In doing so, the clerk, through the other resources the maintenance court might have, should ascertain the details of the other parent and ensure that he or she is brought to the maintenance court as soon as possible for a maintenance inquiry before a maintenance officer. Therefore, for example, should the maintenance clerk not have the living or working address of the father or the mother, then he or she must enlist the assistance of the maintenance investigator to obtain it. For that, he or she can make use of search companies, tracking resources, the maintenance investigator, and furthermore banks, SARS, etc., in order to obtain the details of the other parent. Now, let's move on to the issue concerning getting the non-paying parent to the maintenance court. After the maintenance application has been processed, it is a duty of the maintenance court to ensure that the non-paying parent makes his or her way to the maintenance court as soon as possible for a maintenance inquiry. This inquiry is held before a maintenance officer. Even if the maintenance court's diary is quite full, it should still be expedited, giving both parents adequate time to make arrangements to appear at the maintenance court. Therefore, if the next available date for the maintenance inquiry is in 3 months' time, the parties can use this time to make arrangements with their work, obtain necessary information for the inquiry, or make alternative school traveling arrangements for the kids. There should therefore not be a delay in notifying the parents of the date of the maintenance inquiry. Furthermore, when notified of the court date, both parents receive a document stating what information they should bring to the maintenance inquiry. These include 3 months bank statements, salary advice, and proof of expenditure for the parents and the minor children. Giving the parties adequate time to obtain this information would be vital and in the child's best interest. The last thing we want is for the matter to be postponed to another date due to either parent not having been given adequate time to obtain such documentation, even though the mother made the application many months ago. Now let's move on to the maintenance inquiry before a maintenance officer. The maintenance inquiry is the next legal step in the process. This is where both parties appear in court. This is where things becomes a bit interesting. Sometimes at the inquiry, it is the first time the parents are in the same room together. Since the child was conceived, quite often both parents do not know how much the financial both parents do not know the current financial affairs of the other parent. The parent asked to pay the child support, furthermore, does not know how much a child costs to be maintained. Then we have the possibility of the issue of denial of paternity. What sometimes happens is that the father denies paternity. This he would either do out of spite or due to genuine doubt on his side. This would often be the case if there was a brief encounter between the parties when the child was conceived. Sometimes the father is married to someone else, and for the sake of his current marriage, he needs to deny paternity. Once the paternity tests are finalized, the parties would need to return to court again for the results. If the results are positive, in that he is the father, then the inquiry proceeds. If he is not the biological father, the application would obviously be removed from the role. Now we can move on to the role of the maintenance officer. Again, the golden standard in which the inquiry should be conducted is that of the child's best interest. This is of paramount importance. The maintenance officer should therefore ensure that all the financial information about the parties are properly disclosed. This is very important. However, at the same time, the maintenance officer should try to settle the matter, taking into consideration the child's best interest. Should the parents not be forthcoming regarding their income and expenditure and the needs of the child, then the maintenance officer must subpoena witnesses if need be and make use of the maintenance investigator, which is dealt with next. Section 7.1d of the Maintenance Act empowers the maintenance officer to require a maintenance investigator of the maintenance court concerned to perform such other functions as may be necessary or expedient to achieve the object of the Act. Section 7.2e of the Maintenance Act empowers the maintenance investigator, after being so instructed by the maintenance officer, to gather information concerning, number 1, the identification or whereabouts of any person who is legally liable to maintain the person mentioned in such complaint or is alleged so liable, the financial position of any person affected by such liability, or any other matter which may be relevant concerning the subject of the complaint, or gather such information as may be relevant concerning a request referred to in section 1c above. Now that we looked at the important role of the maintenance officer and maintenance investigator, we move on to the role of the maintenance magistrate. This is where the formal inquiry takes place. Should the parties not be able to come to an agreement regarding the amount of child maintenance to be paid at the inquiry before the maintenance officer, the matter would then have to be taken or forwarded to the maintenance magistrate for formal inquiry. Here the court has to properly consider the means and needs of the mother, the means and needs of the father, and the needs of the minor child. Therefore, make a maintenance award. There is a legal obligation upon the maintenance officer and the magistrate to conduct a thorough inquiry. The court should not play the role of an umpire. Therefore, a passive attitude should not be taken by a judicial officer in a maintenance inquiry and then give judgment. Should all go well, at the end of the inquiry, a maintenance award should be made. We thank you for watching this video, and we would appreciate it if you could share this video, and we're looking forward to you partaking in the next live video. Thank you.
Good morning. Thank you for joining our live webinar. Today's topic, child custody and child maintenance, Q&A. Good morning. I received a few questions from persons regarding this topic, and it seems to me that there is a need for a live Q&A at least once a week, whereby you can send us questions and we can deal with it live on our platform. We have a few questions. I'll get to it shortly. The way we'll be dealing with this webinar, if you wish to pose any questions, please do so on the Advocate Mohammed Abduroaf Facebook page. I'll be keeping an eye on that specific page. So if there are any comments made, I will deal with it and I shall answer it. This specific webinar will be about, I don't know, about 15 to 30 minutes maximum. Therefore, if you have a question, please pose it as soon as possible. Sometimes there's a delay from the time you press enter to when it appears on my screen. I have 4 questions which has been posed already. How often can I apply for child maintenance increase? How long must I wait until I can apply for a reduction? Interesting question. What do I do if my child does not want to visit the father? Happens often. Who has a larger say over the child's life, the mother or the father? So those are the questions I'll be dealing with. And if there are any other questions, please leave a comment on the Advocate Mohammed Abduroaf Facebook page, and I will deal with that as well. Let's head into it immediately. Okay, the first question. How often can I apply for a child maintenance increase? So let's deal with a scenario. The parties would not come to an agreement regarding child maintenance for whatever reason, and one party approached the maintenance court. The maintenance court obviously had to do an inquiry, and the parties may have agreed to it as well. It happens often whereby parties do not wish to litigate child maintenance issues. They come to an agreement, a sensible agreement, and that specific agreement is made in order of court. That could be the one scenario where the parties approach a maintenance court, or one party approaches a maintenance court, and the maintenance court makes a maintenance order. So that's a date when the maintenance order was made. The other scenario could be whereby the parties where the parties got divorced, and the divorce court, either the magistrate's court or the high court, made a divorce order with a maintenance clause in it. So there's another scenario where a maintenance order has been made. And it happens sometimes where the children's courts make parenting plans in order of court, and inside the parenting plan there's also a maintenance provision. So those are the 3 potential scenarios. Now the maintenance order is made. The question which the questioner posed was, how often can I apply for child maintenance increase? Now, looking at that specific question, there's 2 legs to it. Number 1, the maintenance order was made, the party applied for child maintenance increase sometime thereafter. The question is, when can I apply for it again? Or if you are watching this video, another scenario which I'll be dealing with is how soon after the maintenance court made a maintenance order, an increase or a first order, can you apply for an increase? The long and the short of it is there is no specific date. That's very important to note. The moment there is a change in circumstances, for either you're the applicant, the mother or the father, or in relation to the child, that justifies an application for an increase immediately. I'll give you a practical example. Let's say the child currently attends a school, and the specific school carries on from grade R right through to grade 12. Fine, the child is in that specific school. In grade 7 for argument's sake. Something happens, the parties moves out of nowhere, they have to move to a different area, and now the child needs to change schools. School fees is much higher. Although the mother applied for maintenance a month ago, because of this new circumstances that arose, which causes the child to cost much more money, automatically there's a material change in circumstances and the mother can apply, or the caregiver can apply to the maintenance court for an increase. Now, the maintenance court made an order stipulating that the father should pay more maintenance because there's a change in circumstances. They looked at his income, his expenditure, the mother as well, and the child, and they worked that amount. Okay, father, you need to pay more child maintenance because the child is attending a different school, despite you've been at my doorstep 3 months ago where I dealt with this matter for an increase, but the issue regarding the change in the school was not on the table. Let us say, for argument's sake, going forward, the child attends a new school. For some or other reason, the father loses his job. He no longer can afford to pay the child maintenance or to pay a certain amount of child maintenance. Immediately then, he can apply to the maintenance court for a reduction. But that deals with the second question, which I will be dealing with shortly. And at the same time, should the mother, for argument's sake, under these circumstances, although she applied 3 months ago for an increase, the court granted it to her because the child cost more money. Last month, she applied for another increase because the child changed school. Now, all of a sudden, a month later, COVID-19 kicked in, she lost her job. Then she can apply for another increase in child maintenance. So there is no specific time period. I think you guys figure that out based upon my discourse. Nonetheless, if there is a change in circumstances, you are welcome to approach a maintenance court and they should be able to assist you. Let us deal with the second question, which I touched on a small bit early on. How long must I wait until I can apply for a reduction? Same principle applies, a reduction or an increase. So usually the reduction would be the person who is paying the child maintenance. If his or her circumstances have changed, even if the circumstances change regarding the other parent, for argument's sake, let us say the father is paying the child maintenance and he's happy with the amount and he can afford to pay the amount, but for some good reason the mother became extremely wealthy. Now the question is, must he still pay half his salary or quarter of his salary toward child maintenance, despite the mother being extremely wealthy, whereby she only spends not even 1% of her salary towards a minor child because she came across a lot of money? Those are material circumstances that causes and allows the father to approach a maintenance court soon and immediately, stipulating there has been a material change. The mother is not providing maintenance according to her means. Her means is much, much more. And also at the same time, it's not fair that I spend a third of my salary toward child maintenance, whereby the mother is extremely wealthy and she's paying much less. So under those circumstances, the father would have a case because there's a change in circumstances regarding the other parent. You will have to deal with the matter based on almost with the same situation. Let's say there is no maintenance order in place and the mother is super wealthy, the father is not so wealthy. Obviously, the court will make a reasonable order stipulating the father should pay a smaller amount. Therefore, when the father applies for reduction based upon the fact that the mother is earning much more money, the court will have to look at this matter again, rework out the mathematics and what is a fair amount. And at the same time, should a child attend a very expensive school during primary school, for argument's sake, till grade 7, a very expensive school, and the father is paying half the school fees, but not directly to the school, a monetary amount, which is a globular figure, which is towards the maintenance of the child's school fees, clothing, food, accommodation, etc. Now the child goes to high school and she gets a bursary, whatever the case may be. The result thereof is that the child's education expenses are extremely low. She must only pay the registration fee and a small monthly fee, and that's it, compared to what they paid previously while the child was in primary school. Under those circumstances, because there is a material change in the mathematics, in the expenditure of the child, that causes the father to make an application to court for a reduction in the globular figure of maintenance which he has to pay. I hope that answered that specific question. So there is no time limit on whether or not you can make an application for an increase or a reduction in child maintenance. Please note, if you have any questions, feel free to leave a comment and I will deal with that. I shall deal with it. The next question deals with child custody. It goes as follows. What do I do if my child does not want to visit the father? Okay, there are two scenarios. Number one would be there is no court order in place, no children's court order in place, no divorce court order in place, which allows or affords the father care and contact rights to the minor child. If there is no such court order in place, that becomes a bit difficult for the father side. But let me deal with the other scenario. The other scenario will obviously be where there is a court order in place, whereby the children's court or the divorce court specifically says that the father should have contact with the minor child every second weekend, half school holidays, birthdays, Father's Days, religious days, and so on. If there is no court order in place and the child does not want to visit the father, that is quite a concerning thing, because the question is, who's sitting in front of me? Is it the mother or the father? If it's the mother sitting in front of me, then I would advise the mother, please go to a professional person, a psychologist, a social worker, to determine why does the child not want to go to the father. Not based upon what the child is telling you. I do not want to go to dad, because whenever I go to dad, dad's other children are there, his stepmother is there, and I don't like them very much. I prefer to be at home playing PlayStation, being online, etc., because there's Wi-Fi and all the good stuff is here. But my dad is no swimming pool, and I prefer being here. Those could be the child's reasons. Are they good reasons? Are they long-term sufficient reasons for a child not to have any contact with her father? Because this is life. People move on with their lives. Or is the reason, no, I do not want to go to dad because whenever I'm a dad, they scold at me, they rude at me, etc. But that's what the child is saying. We need to get a professional person, a psychologist, social worker, to speak to the child and determine why does the child not want to go to the father? Are they cogent reasons? Are they good reasons? Are they the child acting up? Child playing against both parents? Is it silly reasons? That's what needs to be determined. So the expert will have to speak to the minor child, speak to the father, speak to the mother, and try to resolve the issue. What is in the child's best interest? Is it in the child's best interest to stay by the mom, watch TV games, screen time, and have no contact with the father, and 5 years down the line, when the child is older, she moved away from her dad, and they just became, estranged from each other? Is that in the child's best interest? Or is would it be in the child's best interest if the father tweaks some of his behavior, the mother tweaks some of her behavior, the child does the same, and they try to resolve this matter? So that's a scenario whereby the parents have no order in place. The expert will hopefully try to assist the parents in trying to resolve this matter. Why does the child not want to go there? That's now where the mother is in front of me. If the expert says, no, mom, I think it's best for the child not to visit the dad because of X, Y, and Z, and this is my report, and then that report needs to be seen to the father, and the father needs to come to terms with that. And hopefully the father will work towards the recommendations in the specific report. If the expert recommends, no, child, you need to go to the dad, there's nothing cogent in what you are saying, you're just being unreasonable, like any child might be under those circumstances, and then the mother should cooperate and work towards the father having contact. If the father is in front of me and he tells me the child does not want to have contact with me, then I would also follow that specific route and stipulating, get a third party on board to investigate, to speak to the minor child and find out what the reasons are. If the child does not, if the expert, who gets on board, states that it's best for the child not have contact, or contact should be limited, or contact should be this or that or that, the father needs to take note of that, and the father needs to work towards fixing things so that contact can be regular and back to normal. If the expert stipulates that the father should have contact and the child is acting out, as I mentioned earlier on, and the mother does not agree to that, then unfortunately the father will have to take this matter to court, and the court will have to determine what is in the minor child's best interest. One step before that could be trying to mediate the matter, but in my view, usually if there's a social work involved, they speak to the parties, they try to resolve matters. That is, in any event, a type of mediation. But nonetheless, each case is different, and the tools available will apply differently to various people. But I always recommend mediation. It must be somewhere in the equation, and also getting a professional on board, an independent professional person on board, to assist the parties in trying to resolve these specific matters. Okay, I have a question, a live question goes as follows. What if the father die and he must still pay the maintenance? If the father passes away and the minor child requires maintenance, a claim can be made against the estate of the father. That gets preference over other claims. So if the father passes away and the minor child requires maintenance, you need to speak to the executor of the estate of the father, and a claim should be lodged for maintenance for the minor child from the estate. I hope that assists you, and people need to do that. People need to know that if somebody passes away, you can file a claim for child maintenance against the estate of the deceased party. That was a live question. If anybody else has additional questions, feel free to pose it and I'll try my best to answer it. I hope I answered that question correctly. And the last question from a previous three questions, put it that way. Who has a larger say over the child's life, the mother or the father? Interesting question. And a question which is sometimes difficult to answer in isolation. Sometimes you'd want to have some facts in front of you, a scenario, background information, child with a mom, child with a dad, they broke up, they're divorced, the child is 12 years old, the child lives 10 kilometers from the mom. So those are the data which I would prefer to have in answering these specific questions. But if a party has parental rights and responsibilities over a minor child, then he or she has exactly the same rights and authority and power as other parents. So the mom and dad have equal say in the minor child. I'll make it easy for you. Either parties are married, done, full stop. Both have equal rights regarding the minor child. No one has a greater say. Obviously, as human beings are, and we expect parents to be reasonable. If they have a discussion regarding what school the child should go to, they should be reasonable, and the mother might know better because she's done the research. So the parties needs to come to an agreement the same way as mom and dad who lives in the same home. Let's say they are married, and they're now having discussions regarding the child. The father doesn't say, I have a greater say over the child's life. Or the mother says, I'm the mother, I'm the biological mother, I have a greater say over the child's life over you. That doesn't work that way. You guys need to come to an agreement and work together regarding what's in the minor child's best interest. If you cannot come to that agreement, unfortunately, my advice, as I mentioned earlier on, get a professional on board to try to assist you regarding what's best for the minor child. Try to mediate this matter. If the matter is so serious, for example, which school the child should go to next year. And those are complicated matters because how does a judge know? How does a magistrate know? How do I know as a lawyer what school will be best for the minor child? I can presume, for example, if I like soccer, would that mean that school will be better for the minor child? If I do not like tennis, would it mean a school that has tennis is not as good for the minor child? Whatever the case may be. So speak to a professional, get somebody on board, try to mediate this matter. There are various factors applicable, for example, school fees, location, what the child want to become when he or she is older, the child's grades, etc. We are going to with a scenario in isolation. The parties need to discuss these matters because a mother does not have more rights over the child than a father. There can be scenarios where the mother does have rights. For example, if the father was not married to the mother and he made the mother pregnant and went missing, of course the mother has more rights over the child than the father. But if the father was involved in the child's life since birth, automatically he acquires those rights. And he has just as much rights over the child as the father, as a mother, my apologies. However, if there is a dispute and the parties cannot come to an agreement regarding what is in the child's best interest, the matter will unfortunately have to go to court, and the court will ultimately have to determine what is in the minor child's best interest. Okay, that deals with those 4 questions I have and the live question which was posed. If there are not any additional questions, I will take it as this video should come to an end. And I'll thank you for your time. I hope you have a lovely week ahead and hope to see you online soon. Thank you very much. Good morning. Welcome again to our webinar. Today's topic, a follow-up from yesterday's topic. We had many questions yesterday, and after the webinar we had some more questions which I had a look at but I could not answer, and hopefully we can elaborate upon that again. If you have any live questions as we had yesterday, feel free to pose it, and obviously I'll try my best to answer it for you. you have to post it on the Advocate Mohammed Abduroaf Facebook page. If you post it on any other page, I'll see it later on, but obviously I would not be able to answer it and engage with you with regard to that. Nonetheless, today's theme would be a bit different. I'll focus on the issue concerning child custody, child maintenance and divorce, but from a different angle, dealing with third parties, non-parents. I can't deal necessarily with that in relation to divorce. However, I can deal with that regarding child custody. For example, can an uncle have child custody, an aunt, a grandmother, stuff like that. Child maintenance. May you claim maintenance from grandparents, from uncles and aunts, and so on. So that will be the angle from where we will deal with that. And with regard to divorce, a different angle would be, what do you do if you cannot find the spouse to get divorced? You guys are married, however, separated, your spouse went missing, and now you want to get divorced. So it's a bit of a different flavor regarding that. If you want more information regarding this topic, please watch our video of yesterday. If you are watching it from Facebook, it should be on all our pages. If you are watching it from YouTube, it should be the previous video that would have been posted just before this one. Nonetheless, let us begin with this interesting topic, and I'll be keeping an eye on the Facebook page for any questions that you may have and which you would like me to answer live. And that's the only way I can answer them. On the issue concerning child custody. Now, in South African law, only mothers and fathers can have parental rights and responsibilities by default. When a child is born, grandmother has no rights, grandfather has no rights, aunt and uncle have no rights to the minor child. If the parents decides to move overseas or move away or not allow any of the parents or siblings or their siblings to have any contact with the minor child, that is it. Unfortunately, you as uncles, aunts, grandparents have no default rights to a minor child. And in the same way, by default, you have no responsibility towards that child, for example, paying child maintenance and so on. There might be a social responsibility, a cultural or religious responsibility, but from South African legal perspective, there is no obligation. The parents are responsible for that. That's a default situation. That's the point of reference. However, when dealing with matters concerning children, in child custody matters, we focus on what is in the minor child's best interest all the time. If a third party, let's say an aunt, cares for a minor child, and the parents are unable to care for the minor child, and the aunt looks after the minor child, rears the minor child, and now a few years later, the parents clean up the act and they decide, no, we're taking the child back and we're continuing caring for the minor child. That is good and well. I'm happy for that. However, now the parents decide, we had a bit of a fallout with the aunt. The aunt still keeps telling us how to care for these minor kids because she looked after them for 5 years. And we're cutting ourselves from this aunt, or from my sister or the child's aunt. What happens then? Must the aunt accept it? If the aunt wants to accept that situation, that is fine. Nothing will happen after that. Or the aunt can say, you know what, I think I want to remain in the minor children's lives, continue forming part of their lives. And if the aunt makes such a decision, the aunt can approach the court. And the court can apply its mind to the situation. And if the court believes it will be in the minor child's best interest for this aunt, this third party, to acquire parental rights and responsibilities over the child, for example, have rights to have contact with the child on a regular basis, whereby the minor child might overnight by the aunt's home every second weekend, meaning the parents would not have any actual physical contact with the minor child for those 4 days in the month, every second weekend. Then the court will make such an order because it would be in the minor child's best interest. And under these facts and circumstances, if the aunt cared for the minor child for 4 or 5 years, the minor child at some point believed the aunt was her mother or their mother or his mother. And the minor child misses his aunt and wants to see this aunt because the parents were missing. The child now knows, okay, this is my mom and dad, but you were not my mom and dad for the last 4 years. You can approach the court, and the court can apply its mind to the matter, listening to what the father has to say, the biological father, biological mother, listening to what the aunt has to say. Maybe there's an expert on board, the school teacher, family advocate's office, psychologist, counselor. See what all they have to say. And if it concludes that it is in the minor child's best interest for the third party and aunt to acquire parental rights, the court will make such an order. These third parties could be anyone. Could be a grandmother, a grandfather, could possibly be a very older sibling. That's also possible. Or totally third parties, people that just cared for the minor child. That is not a problem. Obviously, the court will look at all the circumstances and all the facts. I do not, for one, believe that if a minor child was cared for by certain persons for quite a long period of time, and now the parents decide to take back the minor child, that it would be the minor child's best interest not to have any contact with those specific persons. That would not be the minor child's best interest. In my view, if all else is equal, obviously, I can think of a scenario, which is my job, where it will not be the minor child's best interest. But generally, should it be a normal situation, it would be the minor child's best interest for the third party to have care and contact to the minor child. So that's a spin where I'm dealing with child custody from a different angle, where you focus on what is a minor child's best interest. Regarding child maintenance, we have discussed in our previous video yesterday how child maintenance is calculated. We dealt with a few scenarios, etc. But let's take it from a different spin. Let's say, for argument's sake, the parents themselves cannot afford to pay the child maintenance or to maintain the child financially. Let's say the mother earns a small amount of money and the child lives with the mom. The father, unfortunately, cannot be found, or the father cannot afford. He's a student or he's working, but he's earning very little money. But the child requires a lot of money. Not a lot, but more than what the parents can afford. The mother's parents, they are around, but they are pensioners and they also have limited monies. But the father's parents are quite wealthy. They have money. And they can afford to maintain this minor child because the father cannot maintain the minor child at all. Under those circumstances, it is possible to approach the maintenance courts, and the courts would look at all the circumstances, all the facts of the matter, calling the parents, the paternal grandparents, maybe calling the maternal grandparents as well, to verify that they cannot afford to also contribute. And the court would make a fair decision, and the court may order that the paternal grandparents of the child, despite the parents not having been married to each other, that the paternal grandparents should maintain the minor child, should pay some form of maintenance in order for the minor child to be able to live. For example, the child was fine, the child was quite young, and the mother could survive with her money to care for the child, but now the child has to go to daycare, or the minor child has to go to creche, or aftercare, whatever the case may be, or to school. And those are quite expensive. Child requires school clothing, etc. And now the mother requires more money. Father cannot afford it. His parents can afford it. If her parents can afford it, wonderful. She can approach the court to enforce them as well. But generally, the mother's parents would give their contribution, whatever it may be. So that's the one spin on child maintenance. The other spin, or the other issue that may arise, is that one parent, or at least a parent who has to pay child maintenance, no longer lives in South Africa, lives overseas, lives abroad. And now you would like to claim maintenance from that specific parent. Obviously, our courts have only jurisdiction over people living within the area of the jurisdiction, basically South Africa, or the Magistrates Court jurisdiction, or the High Court's jurisdiction, and so on. For example, the High Court in Cape Town would have it over the Western Cape. The Magistrates Court in Cape Town would have it over the Cape Town area, and so on. Johannesburg, KwaZulu-Natal, etc. That same principle applies. But a judge in Cape Town cannot direct an officer in the United States, officer, do this, force other party to pay maintenance, and so on. That's not how it works. We do not have power over other countries. And the same way, they do not have power over our citizens. There are, however, international agreements, treaties that have been signed between countries to sort out these issues. One would be, for example, the Hague Convention on Child Abductions. That's not a full term, it's quite a long term. But nonetheless, if one parent removes the child from South Africa, takes the child to a different country, to consider the other parent, that's seen as child abduction, and we can apply international legal principles, and following certain diplomatic channels, the minor child could have to be returned to South Africa. So we work with the governments are working together regarding that. But nonetheless, we're discussing child maintenance. There is an act called, a piece of legislation called the Reciprocal Enforcement of Maintenance Orders Act, South African piece of legislation dealing with the reciprocal enforcement, meaning reciprocal. South Africa has an agreement with America, for argument's sake, and they will assist each other in enforcing whatever maintenance orders that are in place in the Pacific countries. I am seeing certain questions. Thank you very much for that, and I will deal with that shortly after I've explained the scenario. So we have an agreement with the United States, certain states in the United States, South Africa has an agreement with them, whereby if the person who has to pay maintenance lives in the United States, a complaint will be made locally in South Africa, in the South African Maintenance Court. You will outline that you are the parent, the child is living with you, these are your expenditure, this is the father, he lives overseas, in my example here. And there'll be an inquiry, and the court in South Africa will come to a determination, okay, under these circumstances, the child costs X amount of money, and the mother can afford so much, and we think a reasonable amount of maintenance would be X. They would send that documentation via diplomatic channels to the state in America, to their Pacific Maintenance Court, whatever they have that side, and that maintenance court will get hold of the father, call him in, and then do an inquiry that side. And they would come to an amount, and that specific amount would be made an order of court in the United States, and obviously that details will be sent down to South Africa via diplomatic channels. So the opposite also applies. If this person who has to pay maintenance lives in South Africa, the authorities in the United States will send that specific order, maybe that's a provisional order to South Africa. We will call in the other party, look in the matter, come to a decision, and obviously make an order and send the order down to the United States. So there's a reciprocal enforcement of the maintenance orders. So that's something interesting where that is concerned. We have some questions. Wonderful. Let us deal with that. We'll copy it in quickly. This will be question live. Question 1. Thank you for that. That's the first question. I see there's a follow-up on that specific question. Same person. Let us deal with that. Let me copy that in as well. Okay, so I will definitely deal with that question. Thank you for that. But before I deal with the question, let me just finish the topic on child custody, child maintenance, and divorce. So the next theme from a different spin would be divorce. As I mentioned earlier on, please watch yesterday's video, some more details regarding this topic. Let us say the parties, they are married, and one party cannot be found, but the party remaining in South Africa wants to get divorced, or he knows where the other party is, but unfortunately cannot serve the documentation on them. So remember, this is how South African law works. In order for a divorce to take place, divorce documentation needs to be served on the other party, and in South Africa. If you want documentation to be served upon the other party in a different country, we do not have sheriffs there. So we have a sheriff in South Africa, South African border sheriffs, a member of them, and he knows his job. He knows how South African law works, and he knows how to serve summonses and documentation upon the other party. The United States, the UK, China, Finland, New Zealand, Australia, they have their own processes applicable over there. So we do not direct sheriffs that side to serve documentation. However, the parties want to get divorced. Under certain circumstances, if you cannot get hold of the party, or you know the party is overseas, let us deal with the overseas part. You approach your court locally and advise the court. I've issued divorce summons, but the other party lives in the United States. I only have an email address where this party is concerned. I do not have anything else, but the email address works. Can this documentation be served upon him via email? You will explain that to the court, and the court will say, you know what? I think this is the only way you can proceed with this matter. I hereby give you leave to serve the summons upon the other party via email. And by you get the order, the attorney would obviously email the other party the summons for scanning the summons, the email to the other party. And if the other party does nothing within 10 days, obviously the divorce can proceed on an unopposed basis. And should it proceed on an unopposed basis, the judge will look at the file. The judge will say, I don't see a return of service, but I see, okay, there's an order that was granted previously stipulating that the summons can be served upon the other party by email. Or I see an affidavit here from an attorney stipulating that the summons was served upon the other party by email. The judge will be happy, and at least that requirement would have been met. The court would be convinced that you informed the other party about the divorce. If the other party knows nothing about the matter, too bad. Wonderful, life goes on. But if the other party decides to oppose the matter, it proceeds as any opposed divorce matter. Okay, that was that was the 3 topics: child maintenance, child custody, and divorce. I have another question. Let me deal with that quickly. Copy and paste it. And that's it. If there are any other questions, I would like to deal with that as well. Question number 1. Can in-laws, the grandparents or aunt, force themselves to minor children that does not know them at all? Will the emotional not be in the best interest? Okay, I get the gist of the question. No, they cannot. They have no parental rights at all, so they cannot do that. It's your job as a parent to protect the child from any third parties. Obviously, his family, certain issues involved, complications involved, and so on. But in principle, they have no right. And for me to be blunt, if they are consistently imposing themselves, you can approach the court and get a protection order against them. Obviously, we try to avoid all of that. I only have 2 lines of question here. I'm giving you a general answer. Try to mediate, try to resolve these issues. But if someone persists, because a person does not have a right to the minor children, you can approach the domestic violence court and get a protection order against them. But ultimately, my answer is no, they do not have a right. Let's deal with the second question. Question number 2, live question. Can a judge grant a divorce if the other party does not want to sign the paperwork? There is no obligation upon the other party to sign the paperwork. The paperwork is what you want. So let's say you want to have custody and the other party wants to have custody. So there's no obligation upon him to agree to that. Ultimately, the court would have to make a decision here, evidence. So if a divorce wants to be resolved quickly, you get the party to sign documentation, so the divorce is resolved, and there's no need for us to run a full-blown trial, call witnesses, and put people on the witness stand and argue at the end of the court case. That's not necessary because the divorce has been resolved. If the divorce has not been resolved, they're not willing to sign any documentation or to agree upon anything, fine. The matter must just proceed as normal. The same way, for example, can a criminal charge, if you're somebody charging you for theft, can that go ahead without you admitting to guilt? Yes. You say you're innocent, and the proceedings must go ahead. The same way with the divorce. The party said, I'm not willing to sign it. Perfectly fine. You follow the proceedings, discovery, providing whatever documentation the other party wants. Make sure the matter is still ready. Get a date for the judge. Go on the witness stand. Prove your case. The other party will do exactly the same. At the end of the day, the court will make a decision. So regarding your question, yes, you can proceed. It will obviously take a bit longer, as the case, should the parties come to an agreement regarding the divorce. I think that is it for today. I see no other questions that are being posed. There's no one else that has any live questions. Thank you very much for your questions and for your time for watching this video. And I hope to see you online again soon. Have a lovely day. Good morning, everyone. Once again to our live webinar on Facebook Live, dealing with Q&A on child maintenance and child custody by myself, Advocate Mohammed Abduroaf. I'm a practicing advocate in Cape Town. I specialize generally in family law matters. I do other legal matters as well, as I'm called upon to do, but on family law matters, I'm quite au fait. I've been practicing it for over 15 years, and every day I learn more things. That's why it's a legal practice and not a legal perfect. Every day you're practicing the law. If you have any questions on child custody and child maintenance, feel free to pose it, but it needs to be on the Advocate Muhammad Abduroaf Facebook page, as you can see above. That's the page where you have to leave a comment, and I will answer it. I see we have one question. Let me just get to it. Let us do this. Copy it. This is question number 1. Thank you for that. If question number 1 and any other question is succeeding question number 1, want to add anything, just mention question number 1 or mention number 1 and your additional comment. It gets a bit messy on the Facebook Live page. Okay, the question is as follows, and you can all see it on your screen. I applied for maintenance against the father, and I suspect he has taken retrenchment after we served him the papers. I can't claim for future maintenance. What can I do? It's a challenging answer, because do you want me to be creative here and take the presumption that he will not pay child maintenance, and we need to now attach his pension fund, his pension payout? Or if you have a concern that he will not pay, then it could possibly mean that you'd like to get a lump sum held somewhere. But that hasn't been confirmed yet, and the court did not decide on what amount of maintenance is reasonable. Is your claim reasonable? Should you be claiming more? Should you be claiming less? What can you afford? You might have obtained a retrenchment payout, or will be receiving a retrenchment payout. What is that amount? Is it a huge amount of money? Is it required for his specific living needs? He worked for that, and he paid money every month into a retrenchment or retirement fund. I'm just being general here. And now it needs to be paid out, and he needs to use that money to look after himself. If he complies with his maintenance obligations and he pays whatever needs to be paid, then he can do whatever he wants to do with that money. It's his money. And that's my policy always, that as long as you pay your child support, your reasonable child support, what the children requires and what you can afford, and in terms of your means and so on, considering all factors, the other parties, the primary caregiver's income, expenditure as well, you can live the most lavish life you want to, because you have complied with your obligations. I would presume the same applies to tax. If you paid your tax, you can do whatever you want to do with the balance of your money. The same with child maintenance. Pay it, and that's fine. So, in answering your question, the court first needs to determine whether or not there's a claim for there's a competent claim for child maintenance, in the sense of, is the amount that you're requiring or you're claiming from the other party, is it a reasonable amount of money, and is it an amount allowed in law? When I say an amount allowed in law, I mean based upon your income, your expenditure, the father's income and his expenditure, his future income. He might be cashing in on a retrenchment package, but at the same time, he might be working elsewhere as well. Or furthermore, he might have other assets. So the long and short of it is, please finalize the maintenance matter as soon as possible. Speak to the maintenance court about the retrenchment package. Mention that he is obtaining it. Maybe the maintenance court can obtain relevant information regarding that, so you have relevant data regarding the specific retrenchment payout. And after you have obtained all that information and the maintenance order has been made, and he does not pay maintenance, then you can start looking around and say, no, we now want to start attaching the specific money that he has in his bank account, wherever it is. But I think your claim might be a bit premature now, because you made a maintenance claim against the father. He is not in violation of any order, and there's no reason to believe that he will not be paying maintenance in the future. If he does do that, he's committing a criminal offense, and then you can proceed with a different claim, either garnish your order, attachment of an amount of money, whatever the case may be. So then you'll be in a better position to deal with that. I'll go on to the question. You are questioner number 1. You're welcome to pose any additional questions upon that. I have question number 2. Let me copy and paste that into the screen. As I mentioned earlier on, if you have any, if you're watching this video, please feel free to say where you're from, where you're watching this video from. It's always nice to know that. So this will be mark number 2, and I'll delete the spot. I call this a whiteboard. I don't know if that's an appropriate term to use. Let's deal with this. Which act explains exactly how subpoena has to be served on a person? Please can you state the act? It's but difficult because then you will have the the regulations, civil procedure that would apply, the Magistrates Court Act, the Magistrates Court's rules. Then if it's a High Court, the High Court Act, the High Court rules. And then if it's in terms of maybe the maintenance laws, and the Maintenance Act might have certain regulations applicable or not. So it depends on those things, but I think that will be a bit premature for me to discuss that. The best I would say is determine that you want to obtain a subpoena. You approach the relevant court and advise the court you want to obtain a subpoena, and the court should be able to assist you with obtaining a subpoena for whatever reasons is required. The court issues a subpoena in any event. If it's a Magistrates Court matter, look at the Magistrates Court Act and the rules of the Magistrates Court. I would advise you to do that. If it's a High Court matter, look at the High Court rules and the Supreme Court Act, if I'm correct. Let's move on. An additional question 2. I'll just do this. What are the specific processes that has to be followed? Can I collect a subpoena from the court, take it to the police station, and also police officers to serve the accused? So an accused is a criminal matter. So you don't subpoena a criminal, an alleged criminal. That person gets, if the person must be subpoenaed, it will be subpoenaed by the police officer, by the criminal process. So I do not understand. Are you referring it to a maintenance matter? Possibly. I do not know. Or am I allowed to do this? Is there a specific process? As a commander of the police station was trying to convince me there is another way. Only the court can send it to the police station. I disagree, as I have personal experience of this. Thank you. I do not feel this falls under the category of child custody and child maintenance, and it's a procedural aspect. The best thing I would advise you to do is have a look at the law, speak to an attorney, say you want to obtain his services. Can he serve the specific subpoena on other party? I do not know what type of subpoena it is. It is for non-compliance with maintenance order, is a maintenance application subpoena, criminal, civil. So those are all different specific scenarios that would apply. I hope you good luck with the specific issue you have, but it doesn't really fall under the topic of today's discussion, being child maintenance and child custody issues, not necessarily civil procedure or criminal procedure, and how to bring someone to court. That would be the court's job, or alternatively an attorney, but it's a different topic. I hope that assists you, and I'm sorry I could not be of any additional assistance regarding that. Okay, I think we have question number 3. Let us copy that one quickly. Question number 2, if you have any additional comments that you're welcome to mention it, and I'll paste it and I'll answer it. My answer might be the same, it might be different, depending upon the facts. Question number 3 asks the following: what does it cost to get equal custody and time with my son? I would presume you're referring to financial cost in legal fees. It can be free, because if you approach if you approach a children's court, you can represent yourself. It can be further free if you approach the High Court. You represent yourself. There will be no cost applicable. If you want to appoint a legal representative, I cannot thumbsuck here how much it will cost. It will depend on various factors: the lawyer's hourly rate, how much time he has to spend on your case, time drafting, court appearances, and so on. Is the matter opposed? If the matter is opposed, meaning the other side wants to fight against you, then the cost can be for anything from here till there. How much petrol does a party want to throw into the car? So for every strike the other party makes, you need to defend and counterpunch, for lack of a better way of stating it. So I cannot say how much it will cost, but I do know some matters are done very speedily. Unopposed matters are quite simpler than opposed matters. Unopposed meaning the other party is not opposing the relief sought, and the court will also have to determine the case based upon what you are saying and what's best for the child based upon what you are saying. I do not want to guess. High Court, Magistrates Court, I do not want to put any figures out there. It will just be a guess, and the guy sitting next to me can be non-lawyer. His guess will be just as good as my guess. But if the matter is unopposed, it will be reasonable. You can fix the amount more or less. It's an application either in the High Court or the Magistrates Court. If the matter is opposed, the fees can just spiral. Postponement after postponement possible, or it can be done very simplistically, depending upon the court, depending upon the judge, depending upon the facts. I hope that answers question number 3. I see question number 2 posed another question or comment, sorry. Let us, for the sake of fairness for everyone, I would like to do justice to all my questioners. I do not want you to think that I don't deal with you. Yes, it's a maintenance matter. So I presume it's a criminal complaint for non-compliance with the maintenance order. It's not your job to serve the subpoena, and I don't think you should. You can serve the subpoena. A police officer should serve the subpoena under these circumstances. I honestly do not believe that you can do that under these circumstances. It sounds like a criminal matter referring to an accused, and it's not the complainant's job to serve it. And the final comment would be no problem and thank you. You are welcome. Any additional comments? If I'm incorrect, if it's a civil matter, an application for maintenance order, or subpoenaing the party, or calling the party to court for an application for reduction or an increase, let us know and we will deal with that. Yeah, question number 1 had an additional comment. Let me copy that in quickly. Let us get that into the system. Question number 1, that's him. Or her. I went to court and they said I must return on my court date on 22nd of March. So I suspect he will finish the money. He only has 2 years of service in the company. So I would advise you under those circumstances that you need to maybe approach a maintenance court and tell them your dilemma. It does not mean he will not pay maintenance afterwards. If there is that apprehension and you presume he will not be paying maintenance, then obviously you need to act upon it. I do not know the amount of money you're talking to. He only worked here for 2 years, so I presume that the maintenance amount won't be, the retrenchment amount won't be that huge. Also depends upon how much the person is earning. So it's a difficult situation to deal with because you are making the claim, the allegation that you know you will not pay maintenance and therefore need to attach this retrenchment amount because you are afraid that he will not pay the maintenance afterwards. But you have not determined whether or not there is a justified claim in the amount, and we haven't determined based upon whether or not what your portion of maintenance should be and what the other person's portion of maintenance should be. Sometimes it's a bit hard to give these webinars because you're talking to a screen, you're not seeing anyone. I think we're going to upgrade these webinars where we are allowing people to join us via voice as well, and we can incorporate that into our video. So you can call in via WhatsApp, we will get the sound into the system, and everybody would be able to hear that. And maybe going one step further, we can have those people who want to engage with us via video, we can stream them in via Zoom as well, and we can put them onto the screen. But for that, I might require some additional assistance. I hope it answers question number 1's answer. You need to get the maintenance matter done as soon as possible, and alternatively, or what you could possibly do now is go to the maintenance court and mention to them your concerns. Here's another question, question number 4. We copy it in. Therefore, if question number 1, 2, or 3 has any additional comments, you're welcome to pose it. Just mention question number 1, 2, or 3. Question number 4, the comment is the following. If I have lost contact with the father of my child and we have had a maintenance order in place, he has not paid maintenance in 3 years, and I have not gone back to court to report lack of payment, what are my next steps in terms of getting him to start paying, and what happens to the arrear amount? It's a bit of an easy question to answer, and thank you for the question. The arrear amount continues despite the court order. The court made an order, a maintenance order. It's a valid order. Done. Therefore, he has to comply with the order, and is committing a criminal offense by not complying with the order. So the arrears stands. So the arrears, I'm using a silly figure here, 1,000 per month. He didn't pay for 3 years. That will be how much? It will be 36,000 rand. He owes you that amount of money. What can you do? I would advise you, number 1, to go to the maintenance court as soon as possible. There's no time lapse for that. And lay a complaint against him. More than likely, they'll follow the criminal route and they will subpoena him to the criminal court, and more than likely, he will start paying or come to some type of an agreement, some type of an arrangement. The civil route would obviously be that they can start attaching his property, but I would actually advise you, start the process. He owes you the money and he has to pay it. First step, go to the maintenance court and they should be able to assist you. And they will assist you. The very bare minimum they should do is find out where this person is, subpoena him to court, and start the process. I hope that answers your question. You can still do something. And my advice to you is, whatever proof you have that it has not paid, so if he had to pay into your bank account, you need to come with statements to show that the court order says he had to pay into this specific bank account. Here are the details of the bank account. Here are the statements for the last 3 years. I presume you have that specific proof. If you do not have that proof and we can't get it, he can make that allegation. But I have been paying her, and he'll know that you only have evidence for the last 12 months and you have nothing else to prove. The court will obviously believe him because you, those who allege, must prove. And that's my advice to you. Make sure that you can prove to the court that he has not been paying. I hope it answers question number 4's question or comment. If there are any additional comments or questions, feel free to pose it and I'll try my best to answer it. Please remember, if you're watching this video, the Advocate Mohammed Abduroaf Facebook page. Just above there says post questions on Advocate Mohammed Abduroaf. Type that into Facebook and you should get a page, and if this, while this video is streaming, this video will appear on that specific page. We're also now allowing or making it possible for you to pose your questions before the time. If you are not available at the next webinar, I unfortunately cannot stipulate what time it will be with this COVID-19 and judges and courts having different ways of operating. You must wait for your phone call. You only find out in the morning whether or not it will be virtually done or via in person, and so on. So it's a bit challenging, but I try to do these webinars at about between 9 and 10 o'clock. And yesterday's webinar was the afternoon because I was in court the entire morning. But however, that's how it goes, and we'll try our best. But if you have a question and you're not available to watch these webinars, or you do not know what time it will be, you're welcome to message us that question on the Advocate Mohammed Abduroaf Facebook page. Message, say, question for the next webinar. You must mention that. Question for the next webinar. Otherwise, I wouldn't know. Is it a question, a general question, or is it a question for the webinar? So mention question for the next webinar. These are the facts, and at the next webinar, I will pre-post it onto the whiteboard so we can start dealing with that immediately. Then when you come back from work or wherever you are, or you have free time, watch the video, and I should have dealt with that specific question. I have another comment. Oh, the questioner says, thanks, you are welcome. The last question, question number 4. You're welcome, and I hope that answers your, sorry, did answer your specific question. If there are any additional questions, feel free to pose it. Otherwise, I think that's our webinar for today. 20 minutes of live streaming. If there aren't any, I thank you for your time, for watching this webinar, and I will see you online tomorrow morning again. It will be in the morning, most probably between 9 and 10 sometime. But if you have any questions before the time, please feel free to post it. Have a lovely day, and I'll see you online soon. Thank you very much. Good morning. Welcome to our live webinar streaming on Facebook Live. I hope you all are well. You had a lovely start to the week. It is May. We had a public holiday on a Saturday. Doesn't help many people. Some people are really not working, but those of you who have been working on Saturday, I trust that you were paid double for working on a public holiday. Unfortunately, I think I also worked on Saturday. I doubt I got paid double, but that's fine. That's the job of a lawyer, to do his work and make sure his client is happy with the results. Nonetheless, our topic today, care, contact, and guardianship rights. Is there a gender preference? Before I start with that topic, I'll give people a few moments to join us and to have the opportunity to interact if you want to. You may interact via the Advocate Muhammad Abduroaf Facebook page. It's above there. Or you can send us a message later after you watch this video. And tomorrow or Thursday, when I do my next webinar, I will refer to those specific questions and deal with them later. And I shall also leave a comment or a reply to your comment stipulating what time I will be doing my next webinar dealing with your specific question. Nonetheless, we are live now, and let us get the wheels moving. Care, contact, and guardianship rights. Is there a gender preference? What do I mean by that? Does the law prefer having a situation where the mother is a primary caregiver of the minor child as opposed to the father? Is there a stereotype that believes that mothers are better caregivers overall throughout the minor child's life than fathers? Is there a preference that fathers are better caregivers for boys as opposed to girls, and vice versa? That's what we are dealing with today, the preference. The reason why I chose this topic is because many people, especially men, they come to me for assistance with the view that they are only entitled to certain care and contact rights. For example, that they are only entitled to have contact on every second weekend and maybe midweek contact and half school holidays. They come to me with that predisposed view and understanding that the law will never consider the possibility of them being primary caregivers. And that's not how the law works, and I will be doing them a disfavor, and to all my viewers a disfavor, if I promote that specific understanding and view. What the law looks at is what is best for the minor children, despite gender. We all know that mothers work just as hard as fathers. They have jobs, full-time jobs. Fathers have full-time jobs. In a domestic relationship or situation, either by marriage or partnership, whatever the case may be, mothers and fathers go to work. The child wakes up. Both parties may, depending upon the facts, assist the minor child in getting dressed, feeding the minor child, whatever needs to be done to get the minor child to start the day. The father might be the one that takes the minor child to school, and the mother may be the one that collects the minor child. Should the minor child fall ill, depending upon how the schedule is the next day, if the father has an easy day the next day, then under those circumstances, the father will take care of the minor child the night before. If the father has a busy day or he had a busy day and the minor child is ill, then the mother will take care of the minor child, and so on. So there's an equal caring of the minor child. Now, dealing with that specific scenario, should those specific parties separate or divorce, they need to now determine what should happen to the minor child. How should care and contact arrangements be implemented? Is there automatically a default scenario situation that the minor children should now be living with the mother? The father will be moving out, the child should remain with the mother. Or the mother is leaving the matrimonial home or the family home, and the kids must go with the mom, despite it always having been that both parties cared for the minor child during the relationship. Now, unless you want to apply the stereotype or the common example, not the common example, the common view, that if a child falls ill, it's only the mother that can care for the child. If the child requires something, the mother must do everything. The job is for the father to go to work, earn a salary, and the mother stays at home and she looks after the kids, looks after the home, make sure the home is clean, food is cooked, and so on. That could have been the old stereotype, how things used to work in the past. It still applies to some certain households still. Many households follow that specific scenario. There's nothing wrong with it at all. Where the mother remains at home and she cares for the kids, she irons the father's shirts, makes sure that everything is done. So when the father comes home, he can eat and she will continue looking after the kids. Now, under those circumstances, it would make logical sense for the minor child to remain with the mother should the parties separate. And I will be honest with you, that makes sense. It makes logical sense. It won't make sense for the father under those circumstances, especially if he never really cared for the minor kids. On weekends, he spent time with the minor children. They went out to the beach together as a family and so on. However, when it comes to the caring of the minor child, when a child requires assistance with homework, who taught the child how to potty, to use a toilet? Who taught the child how to do things that a child requires someone to assist him consistently with? Obviously, the mom, not the dad. The dad was at work. He was earning a living. He was working for the family, and that's admirable. It's good. However, under those circumstances, it makes sense to follow the stereotype and stipulating. Under these circumstances, the minor child would be best cared for if the minor child remains with the mother. However, if the facts are different, if the facts are that the father cared for the minor child just as much as the mother, maybe but less is possible, depending upon the circumstances, but now they're separated and a decision has to be made. The question is, how should they continue parenting the minor children post-separation? Should it be 50-50, which I have no problem with if it's workable, where the minor child will remain with one parent for 1 week, or 5 days, or 2 days, or 1 day, depending upon the facts, depending upon the circumstances. If both parents live opposite the minor child's school, so the minor child knows, tonight, I wake up in my mom's home, I'll go to school, and on my way back, I'll be going to dad. Mom knows that the child won't be coming to her, so she can do whatever she needs to do. The next morning, child wakes up, and he goes to school, and he comes back home to mom. That's fine, it works, it's workable. I am not a judge of families. I never was, and I do not intend to be one in stipulating what would be the ideal family situation for you. But if you ask me my professional opinion, my professional answer will be what is workable. Is 1 day on, 1 day off workable? I can see problems, but if it's workable, it's workable, and that's wonderful. Is a 5 day on, a 5 day off workable? 1 week on, 1 week off workable? 1 week, 2 weeks, 2 weeks, 1 month, 1 month. If it's workable, wonderful, and it will be a happy family. That's very important. I can come with a perfect parenting plan. Spend time drafting it, well drafted, good English, good grammar. If this, if that, if this, if that. If that applies, well drafted, admirable. However, if it is not workable for this specific family, it's useless. It's a useless piece of paper. It is causing more problems for the family. However, if the parenting plan specifically states that the father can only see the child every second weekend for 1 hour, it's workable. And that's what the people want. The father travels all the time. He lives in Johannesburg. It's a fly down once a month. It's workable and understandable, and that would be the ideal parenting plan. Great. We have some questions on the screen. It's all pre-created, and I typed it out and I pasted it onto the screen for the purposes of getting some context. Let us deal with the first question. I am the mother of my child. Does the father have a right to have primary care over my child? Now, I won't give a yes or no answer because the person is asking me a subjective question, but hypothetical question applying to the general laws. Subjective question to her, I would have to ask the mother quite a few questions. Firstly, how was care and contact exercised whilst the parties were separated initially? If they have only now recently separated, I'll ask questions, for example, who cared for the minor child predominantly during your relationship, your marriage, whatever the case may be. I'll ask specific questions. If the child fell ill, who cared for the minor child? Who done this, who done that? I need to understand what are the dynamics applicable here. If the father was actively involved in the minor child's life, just as much as the mother, the dynamics are different than a situation where the father worked very hard to feed the family, to care for the family. However, the question is, post the separation, can the father also care for this minor child just as well as the mother can? Things have changed. We have to relook the matter. So my answer to my client, the mother in this circumstances, would be, it depends a lot on the history, on the past, and the capabilities of the parents. A lot of things can also happen. A mother can have a nervous breakdown. She can fall ill chronically, which can affect her capability for caring for the minor children. That could happen in a given scenario. I need to know all these specific information before I can give my opinion. It's only my opinion as to what is practical and workable under the circumstances and whether or not there's a prima facie, a first glance, it is a case. Obviously, if the mother tells me, no, the father is the one that cared for the minor child all the time. I'm the one that worked. I'm a jet setter. I'm a CEO of a company. I never did anything to the minor children. He taught him to ride bicycle. He taught him how to fasten their shoelaces. He's the one that potty trained them. He's the one that does all their homework, and so on. They are getting good grades because of him. He's the one that takes them to school and brings them back. He works himself. And he works online, and his clients are in the States, so he works at night, etc. But I'm the mom. I'm the biological mother. I give birth to these kids. Surely the mother will say, should I not have the kids now, and the father can have visitation rights? The logic is tainted. Under those circumstances, it will make logical sense and legal sense for the minor children to be placed in the care of the father, and he can continue doing what he does. And the mother can obviously have contact every second weekend, etc. Weekend contact is very important, but during the weekends, there is schoolwork, homework, routine. Unfortunately, the routine will get spoiled a bit because there's not two households. But that's the reality of people breaking up, divorcing, separating, etc. I hope that answers that fictional client's question, and let's get to the next question. Do fathers have a right to have sleepover contact if the child is still young? Very interesting question. One that gets posed to me quite often. And answering it will obviously assist if we apply the question or the comments I made early on regarding question 1. Obviously, if a child gets born, is born, comes out of the mother's tummy, the child is breastfed, it makes logical sense. The child must be with the mom. I support that view fully. I do not think a father can care for a newborn child unless there are other issues, complications, the mother is unable to care for the child, etc. But in normal circumstances, the mother can be the top CEO, the most busiest person on earth, but when she gives birth, she won't be working. She'll be dealing with a child. And it makes logical sense, in my view, for the mother to care for the child unless there are other circumstances, other facts that will persuade me otherwise. But now the child is older. The child is off the breast. The child is now eating solids. The child can, does not require someone to care for the child the entire night. The child sleeps for 4 hours on one, 6 hours on one, whatever the case may be. I do not want to specifically stipulate an age. Each case is different, each family is different. But the child is self-sufficient to a certain extent. Then the question will be, can the child be the care of the father? And can the father care for the minor child, despite the minor child being very young, on diaper still? Can the father care for the child during the evenings? Now, how do I deal with such a question? It's a factual thing. Is he capable of doing so? Does he have the insight? Does he have the knowledge on how to care for the minor child? Has he experienced contact during the day? I do not believe in the logic that the father never ever had overnight contact, therefore he should never ever have future overnight contact. We need to start phasing things in. Give the father an opportunity to develop that skill, and that skill will obviously get developed should he spend time with the minor child during the day alone. The child will take a nap during the day. The challenge will obviously be now if the child should overnight by the dad the entire evening. Yes, it's possible that the child might be missing the mom and be apprehensive and say, where's my mom? I'm not used to this bedroom. But wean it in. Let the child during the day sleep in that bed or wherever the child will be sleeping in. Keep the child a bit longer there. Maybe till later the evening, mother can collect the child. So the child can fall asleep at the dad's place, but wake up again and go back to the mom. So you create a phased-in approach, which is very important. So my answer to question 2 is, yes, it's possible for a father to have overnight contact if the child is at a young age. It's possible. Depends upon circumstances and the facts of the matter. If the father is someone that's tired during the evening, has to work early the next morning, and he's making that request based upon wanting to show the mother a thing or two, but the child won't be looked after very well, that's a different scenario, because then a very young child might not be the ideal candidate to have overnight contact by the secondary caregiver if the child is too young. If the child is a bit older, I'm going to mention age here, let's say 5 years old, just before going to grade R. Child sleeps right through the evening, child is quite big, mother and the child can have a WhatsApp video or call the evening before the poor child falls asleep, etc. No, that's a different scenario. Then the facts changes a bit. The father can be extremely busy at work, but the child overnight there, they spend some time together, the child falls asleep, has breakfast with the child, tells the child at school, that's it. So those are the scenarios which you have to look at. My guess will be just as good as your guess, but it all depends upon the facts of the matter. That is question number 2. Question number 3. My son wants to stay with me permanently. I'm the father. The mother does not agree. What can I do? Very important considerations that needs to be applied. Father wants to have primary care over the minor child. The mother does not want that to happen. We have to look at all the factors. Of course, the age of the child, the history, how often the child had contact by the dad, how often has the child had contact for half the school holidays, etc. Are we there? Are we far from that? Do we still need to get there? Do we still need to develop a strategy to get to there? For argument's sake, if the father only had contact with a minor child for 2 days per month, the case becomes a bit more harder. It will be better for the father to try to get more contact first, half the school holidays, and then work towards being the primary caregiver. Not necessarily going to 50-50 first, but 50-50 is actually a situation where both parties are primary caregiver, and I believe if 50-50 works and it has been applied, it's harder to go and make a case for primary care, but it's possible. Nonetheless, we have to look at all the circumstances, all the factors mentioned in question number 1 and question number 2, and the court will have to determine what is in the minor child's best interest. Is it in the minor child's best interest to be with the dad? Can the dad care for the minor child just as well as the mom can, and even better? Will the minor child's education, psychological, emotional needs be looked after when the minor child being cared by the dad better than the minor child needs would have been looked after with the mom, etc.? when I mention the word needs, remember, money has nothing to plays no role in the specific scenario. The father can be extremely wealthy or extremely poor. Doesn't matter. The question is what is best for the minor child. If the father is extremely wealthy and is not in the minor child's best interest to be in his care, then that's it. The father must pay more maintenance to the mom because the mom would require the maintenance if she cannot afford to pay for it. And in the same breath, if the father is extremely poor, but he believes he can care for the minor children better, and he can, actually, factually it's worked out, the mother is extremely busy working, jet setting, etc., then under those circumstances, the mother must pay child support to the dad. Thank you very much for your time, for watching this webinar. No, there were no live questions. I do not see any. But nonetheless, you're welcome to post questions before tomorrow if you're watching this webinar on Tuesday, the 4th of May. If you're watching it on Wednesday, the 5th of May, I might have had another webinar and I shall not deal with these questions again. Have a lovely day and stay safe, and thank you for watching. Good afternoon. Welcome to our webinar. Today's topic, childcare and contact, or sometimes referred to as custody and access. The new term since the Children's Act came into operation, we're using the term care and contact. So that's the way we go about that. Many people still refer or use the term access and custody. And of course, there's the issue of concerning guardianship as well, the legal rights or the legal responsibilities regarding a minor child. Nonetheless, let's deal with today's topic, childcare and contact. Generally, I'll be dealing with the issue concerning various aspects of child custody, child maintenance, guardianship, relocation, and so on. Nonetheless, we have a few questions which people posed previously in the last few days. I have changed the questions a bit to deal with it more in a more legal fashion. Sometimes when people pose these questions, they use shorthand, they type it from their phones, and sometimes you do not know exactly what the gist of the question is. But nonetheless, I tried my best to not to lose too much of what the people have typed when they send these questions to us, and hopefully I'll be able to do justice to the specific question. So I have 5 questions on the whiteboard. This must be number 5 as well. I have 5 questions on the whiteboard and I'll be dealing with those. If you have any live questions, if you are watching this video live, please make use of the Advocate Muhammad Abduroaf Facebook page. I'll be keeping an eye on that specific page, and if you do pose a question on that specific page, I will deal with it. I am seeing a question now live as well, so thank you very much for that. Anyone else have live questions, feel free to pose it. But let me first get through this question list of the people who posed these questions previously. The first question is, the mother is suffering from depression and I think she is bipolar. What can I do if I want to have custody of my child? I see him every weekend and he's 4 years old. Okay, so reading between the lines, is a father posing this question. He believes he believes that the child is not being properly cared for by the mother because of the mother suffering of depression, and he potentially believes the mother is bipolar as well. Now he wants to have custody over the minor child. So the question you'll pose to me, or someone will pose to me, is it by default if a caregiver, a primary caregiver, suffers from depression and is bipolar, does that make that specific parent unable or inadequate of caring for a minor child? And of course the answer is by default not yes. I cannot say yes, it does, because with depression, with bipolar, there is medication for that, and if it's well treated, you should not have a problem. You know, you can continue with life. And also the specific patient or the specific parent may be able to handle the depression and the bipolar very well and care for the minor child in a very good manner. And the flip side, which we're not dealing here with and which needs to be posed, is can the father in the specific example or question, can he care for the minor child just as well or better than the mother can? And the question is, what problems does he have? Does he have any challenges? He might not have bipolar, he might not be suffering from depression, but he might have other conditions or circumstances as well. So by default, you do not deal with a matter like this by stipulating, firstly, okay, the mother has depression, she suffers from bipolar, automatically the child should now go to the other parent, and we presume, without any information before us, that the child would be cared for better by the other parent, or that the other parent can care for the child just as well as a mother can. There are various aspects to look at. Firstly, the age of the child. The specific example, the child is 4 years old, so quite young. And, you know, does depression and does bipolar affect the caring capabilities of a minor child of 4 years old? But I'm looking at that from that specific angle. The other sphere we have to look at is the father. Can he care for the minor child? Why is the minor child in the first place not with him? That's very important. And the specific father does not mention that he is capable. He's not providing us with that information to substantiate that he can care for the minor child better than the minor child is being cared for by the mother, despite the depression and despite the bipolar. Or I'm not obtaining information from the father explaining to me the level of the depression. How does it negatively affect the caring of the minor child and the bipolar? Does it affect the minor child, or is the minor child very happy? Because a 4-year-old child is supposed to be happy, enjoying life, you know, going through those milestones, learning how to run, to talk well, to play, you know, to possibly spell the name and so on. So that's what the child of 4 years old has to do, not necessarily having a parent assisting him with assignments, homework, etc., and X, Y, and Z. So nonetheless, if the father in this specific question believes that he can care for the minor child better than the mother because of other reasons as well, for example, he can, you know, stay up at night to care for the minor child should the minor child be ill. His structure, his work program allows him to be a caregiver of a 4-year-old child, and he has the temperament, the patience, and the insight on knowing how to look after a 4-year-old child. Then wonderful, then maybe the playing field becomes equal on that basis, but not by reason of the mother being suffering from bipolar or depression. So I hope I answered that specific question as objectively and as properly as possible. Nonetheless, let's deal with question number 2. I have a job offer to work in Dubai. I work as a teacher currently in Gauteng. My child is 10 years old and I want to take her with me. The father's name is on the birth certificate and he does not agree with my daughter going with me. What can I do? He pays maintenance. Okay, a scenario which comes about quite often these days, the issue of relocation. Here we have a primary caregiver, a mother caring for the minor child. The father pays maintenance, and I'm certain he has contact often with a minor child, maybe in terms of a parenting plan or some type of agreement the parties may have. But that's not an issue. Things are going well. Now the mother wants to relocate to a foreign country, and in this case, Dubai, to teach. And she would like to take a child with her of 10 years old. Now, what differentiates international relocation matters with the normal run-of-the-mill care and contact matters are that generally the child in the normal circumstances would be living in the same suburb, the same province, both with the parents. And therefore the only issue is how much contact should the minor child have with the other parent, every second weekend, half school holidays, and so on. Here we're having a scenario where the minor child will relocate with the primary caregiver to a different country, to a foreign country, leaving the parent who remains in South Africa with a total different level of contact with the minor child. He might see the minor child once every 2 years physically. Yes, we know we have Skype, we have Zoom, we have FaceTime and so on. But however, that aspect of picking the minor child up from school, taking the minor child to school, extramural activities, spending weekends with the minor child, going to the park, going to the pools, going to the beach and so on, will not happen anymore. So here we're dealing with the issue concerning international relocation, which is quite complicated in the sense of the court must first determine whether or not it would be in the minor child's best interest to relocate with a parent in the first place. So we're not dealing with care and contact issues at that specific time. Then the second leg would be what type of care and contact arrangement should be in place for the specific parents should the minor child relocate with a primary caregiver. But those things are not that hard to work out because, contact would usually be unlimited at reasonable times. And reasonable times can be a bit complicated. Okay, Dubai might not be much of a problem, but let's say the minor child relocates to the United States, whereby a good time for the minor child might be in the afternoon between maybe 5 or 4 and 7 or 8 o'clock. However, that might be a total different time zone in South Africa. And that could cause certain type of complications with the parents having contact. Either the father would have to wake up extremely early, or he'll have to be awake extremely late at night in order for him to have contact. Nonetheless, under these circumstances, seeing that the father is involved in the minor child's life, his name's on the birth certificate, the Department of Home Affairs would obviously require the father's consent for the relocation. They would require that. And at the same time, for the mother to apply for a passport, the Department of Home Affairs would require the father's consent as well. In a matter like this, the mother would have to convince, and the mother is the one asking for the advice, so we are answering this question on behalf of the mother, putting on my advocate's cap for the mother. The mother would have to convince the court that she set up a situation in Dubai that will be conducive for the minor child's well-being. In the sense of she's looking after the minor child while in South Africa during the week, taking him to school, feeding him, caring for him, assisting him with his assignments and so on. But should the minor child relocate with her to Dubai, the minor child would be cared for just as well as as the minor child has been cared for in South Africa. That's the one aspect we're focusing on, the minor child. The minor child will be looked after. Secondly, the issue of relocation per se. Why does the mother want to relocate? Here is for work purposes. Does it make sense for the mother to relocate to Dubai if she'll be earning the same amount of money? This is in my example, my question I'm asking you. She'll be earning the same amount of money in Dubai as she's earning in South Africa, and there's no logical reason for her to go to Dubai other than maybe experiencing the world. But that is also a valid reason for someone to relocate, to experience the world and to, see different places. So the court would have to look at that as well. Now, after we have concluded that it will be in the minor child's best interest because the minor child will be going with a caregiver, requires to go overseas to better employment or whatever the case may be, the parent remaining in South Africa would have an argument. The parent remaining in South Africa will stipulate, no, the child should not relocate. Firstly, school, change of school, friends, family, contact with the caregiver as well. The father would not have contact with the minor child as often as he has, maybe every second year. And with COVID-19 being so difficult, we do not know what will happen in the future. He might see the minor child, after a very long time again, physically. So he would argue that. And what would his argument be? If he's very good, he would not necessarily argue on the basis that the mother cannot go overseas. He would argue that if the mother wants to go overseas, she can go overseas and she can do what she wants to do. But the minor child should not go with the mother. And with saying that, he would have to argue and present to the court that he can care for the minor child adequately in South Africa and the mother can go away. So that's a debate that has to be determined. And if you look at that specific scenario, that specific situation whereby he caring for the minor child, we have to say, is it best for the minor child to be cared for by the father who has no experience? Let's say those are the facts. He has no experience, the minor child does not know him so well. He usually only sees the minor child once every second week. He remarried, he has some step kids as well. The house is very small. Whatever the case may be, I understand to be difficult here, making his case a bit hard. But you will have to convince the court, if you consider everything, the child will be living in his environment, but at the same time, the child will be living in South Africa, remaining in his current school, friends, family, and so on. As opposed to going to Dubai, living with a mother, total new school, but the mother as primary caregiver will be looking after him. So those are the debates that will have to take place. So if you are following my argument, you need to convince the court, either father or mother, but here in our case the mother, that it will be best for the minor child, and the minor child cannot remain in South Africa because you are not there, number one, and secondly, the parent living in South Africa cannot care for him or her. So I hope I dealt with that specific question. And if I have not, you're welcome to comment a bit further. The third question, and the person that posed a question on Facebook, I shall deal with your question after question number 5, and then we can unpack it further. What do I do if my child does not want to visit his father? Our divorce agreement says he must visit every second weekend. However, my son does not like his new wife and step-brothers and sisters. He's 17 years old. Must I force him? Okay. Divorce parents, divorce order, stipulating that the child should go to the dad every second weekend. So it's an order of court, complicates matters a bit. The child does not want to go because maybe the father remarried and he does not get so well on with the stepmother and the step siblings and so on. But he's 17 years old, he's an adult soon. In the next few months' time, he'll be an adult. Now, when it comes to kids at this specific age, it becomes a bit hard because a 70-year-old is almost an adult. He'll be an adult in a few weeks' time, a few months' time. And what do? Do you force a child who basically knows what he or she wants and who is maybe in matric or grade 11, whatever the case may be? Some of them at that specific age is already a technicon. Do you force a child at that age to go to a parent? Yes, in principle, the child does not necessarily decide what's best for him or her. A child decides, the parents decides what is best for the minor child, not the child himself. However, a person has to be very sensitive and smart here. Yes, if you ask me the question, must the child go? If the order said yes, my answer is yes, so you must follow the order. But if you have a situation whereby the child does not want to go, and a parent who would be exercising contact, in this specific case, the father is adamant he wants to have contact to the minor child, and there's a court order in place stipulating that, I strongly believe under those circumstances, you need to take this matter back to the court. The court needs to resolve this issue as soon as possible, because you would not want to force a child of 17 years old to have contact with another parent if the child does not want to, without trying to mitigate the matter. And the way to mitigate the matter would be to take this matter to court, because a child of 7 years old is very vocal, and you do not want to traumatize this child. In taking the matter to court, we of course want a social worker, a psychologist, somebody to be on board to assist in assessing this matter. I mean, remember, the parents, they are not psychologists. They do not necessarily know what is best for the minor child objectively, because they are all acting subjectively. They have issues with the other parent and so on, or sometimes the minor child plays them as well. That happens often. But be that as it may, the mother in this specific scenario needs to take this matter urgently to court and have the court to reassess this matter as soon as possible. But until then, unfortunately, depending on how far she acts, the minor child would have to go to the father unless she goes to court urgently, and the court can relook this matter sooner than later. And because the minor child is 17 years old, there are a lot of variables who play. Number one could be the minor child might turn 18 years old in a month's time. And now you have to go to court, urgent litigation to be heard in a week's time, where that order will only be applicable for the next 3 weeks' time. I think parents will be silly to litigate a matter for 17-year-old on that specific basis, spending so many thousands of rands on legal fees just for the father to have contact with a minor child for the next 3 weeks. And the child will become an adult after that. Okay, so my answer, in summary, would be basically focus on what's best for the minor child. However, because there is a court order and the parties cannot come to an agreement, urgently approach the court and have the court reassess the matter and determine what is best for the minor child. That was question number 3. Let's deal with question number 4. I am in the process of getting divorced. I was told that I can ask for maintenance from the divorce court. Is it possible, or must I go to the maintenance court? The answer is yes, it is possible in a pending divorce matter to approach the divorce court itself for a order regarding child maintenance, care and contact. That's possible as well, and also a contribution towards legal cost. So that is possible. So in the High Court, for example, it will be a Rule 43 application. Usually what the parties do is you first issue the divorce summons, you serve it upon the other side, and soon thereafter you make an application in terms of Rule 43, basically stipulating I require maintenance for myself and for the minor children, X amount of money. I would like to have these interim contact arrangements in place. The minor children should remain with me if I'm the mother, and the father can have contact every second weekend, whatever the case may be. And at the same time, we like the father, if he is earning all the money or he has assets and so on, to contribute towards your legal costs. So that's how it works. So it's possible. It can also be done before the divorce and also with the divorce summons being issued as well. So that is possible. Question number 5, the last question before we deal with the live question. The father of my child is missing. He does not pay maintenance nor visit the child. The last time we had contact was in 2000. That's quite some time ago. I think that should be around, it is 2010. My apologies for that. 2000, the child would be an adult by now. I want to get a passport for my child. Home Affairs says I need a court order. How do I get it? Okay, so let's deal with this matter from the foundation. Minor child, the father and the mother are guardians over the minor child. So they both have parental rights over the minor child. I would presume these parties, maybe the child's name is on the birth certificate. I would presume the father is involved in the child, was involved in the child's life at that specific time. But now when the mother went to the Department of Home Affairs and showed him the birth certificate, they said, oh, okay, I see, there is a father, we require his consent. The mother might say the father was not involved in the child's life since 2010. They'll say, how do we know that? You could be lying, whatever the case may be. And they require the father's consent, and they'll tell you, if you cannot get the father's consent, you need to come back to us with a court order. So that's what the mother needs to do. We make those type of applications quite often, whereby parents have challenges in, number one, maybe living or assisting the child in his life, for example, enrolling to schools, extramural activities, consent. For example, let's say the child has to go for an excursion and they require the guardian's consent, or the minor child would like to go overseas on some trip because the child is very talented and the guardian is not available and hard to be found. So nonetheless, under these circumstances, I would advise the specific person to urgently approach the court and ask the court for an order that the court appoint him or her as the sole guardian of the minor child, and in this case, a mother. So basically, you approach the court, you tell the court, these are the problems I have for the last 10 years. Father is missing, he never paid any maintenance. I had problems with enrolling the minor child to primary school, to high school. I'm still having problems. I cannot get a passport for the minor child. All these problems, but the father is nowhere to be found. The High Court will assess this matter, and the court could possibly make an order that, Mom, we believe you, we accept what you are stipulating. Here is an order stipulating that you have sole guardianship rights over the minor child. Go to the Department of Home Affairs, show this order to them, and they would not ask for the father's consent. So that is possible. The court would obviously make an order like that if the court believes it would be in a minor child's best interest, but generally, if the father abandons the minor child and the family and so on, the court would make such an order. Okay, I hope that answers question number 5. If I have not, and you are watching this video, and you have posed that question to us, this usually happens this weekend, you're welcome to comment. We have now the live question. Let us deal with that. Okay, here's a live question. Hi, I'm going to the maintenance court tomorrow. I saw my ex and son at the restaurant and went to say hi to my son. He quickly called his lawyer and said it's harassment. Can he do this? I'm in Johannesburg from Durban and hardly get to see my son, but he says it's his time with the child. All I did was say hello and hug my son, etc. He was excited to see me. I do not necessarily per se, I wasn't there, so I do not know what the other dynamics are, but on the facts mentioned over here, if you were, for whatever reason, coincident at the shopping mall and you see your son, normal people, they greet each other and hug each other. So you would obviously have to prove to the court that it is harassment. What would be harassment would be that you stalked him, you came out of nowhere, you knew you're following him, and that is why you were there and you planned this from the word go to be there and to see your son and to, of course, communicate with the son and limit or in some way or another, not frustrating his contact with his son, but also, you'd prefer you not to have been there. But nonetheless, on the facts which you have mentioned to me, I do not see any form of harassment. If you were there, by the way, and it was a total coincidence, and you in no way frustrated his contact with a minor child. So that should be fine. If I did not deal with the matter properly, please tell me, and I will try my best to answer it in a different way. So nonetheless, thank you very much for your time, everybody. That was 5 questions and 1 live question. I think we dealt with it quite well in the last 25 minutes. Thank you very much for watching this video, and I hope to see you online again soon. Thank you for joining us. These type of webinars are very beneficial to people because it gives them the opportunity to pose a direct question to a legal practitioner that specializes in family law. You may come across your specific legal problem for the first time and do not know how to deal with it. Sometimes it's very useful to engage with a legal practitioner who practices or who specializes in a specific field of law, and he or she would be able to fast track your knowledge on this specific topic. Therefore, as I've always welcomed people to pose whatever questions you have. I see we have a live question. Thank you for that. Let me read it out. My daughter's father has opened her an Instagram, Facebook, and TikTok account. She's only 9 and I haven't been consulted about this. Is there anything I can do to protect her from this or do legally? It's a difficult question to deal with. It's not a criminal offense for him to open such an account unless Facebook or Instagram does not allow it, or they might allow it but with parental oversight. And some parents, for a 9-year-old child, they might find it reasonable for him or her to have a Facebook account whereby they will keep a close look out on it. So they will monitor it. Generally, parents would have to discuss these specific things. They cannot, at every point where modern technology comes in, where certain decisions regarding a minor child has to be made, they always at loggerheads. So here it is now the Facebook account, where the parties now have an issue and a problem regarding that. I'm not referring to this specific commenter. A different scenario would be where the child has to get a cell phone. Parents are now at loggerhead. Maybe if they were in the same in one relationship, living together, they would have resolved that specific issue more differently, but they do not, or they cannot. Now, this is a typical issue where the parents have to discuss, they have to work around it. Because if Facebook is lawful for a 9-year-old child to have an account with, I do not know, I have not done the research. This is the first time I have had a question like this. And if it is legal and the specific parent wants to have that, that is now obviously that parent's decision. But if you feel that it is harmful and it will cause some type of negative impact on the minor child, and it will actually happen, then the only way I can see this matter can be resolved would be for you to approach the court of law and ask the court to force the parent to stop with the action of creating social media accounts for the specific minor child. You cannot go to the police. What will the police do? It's a Facebook account. What will the charge be? Opening an account for a minor child, unless there are illegal activities taking place on the account. So therefore, please verify firstly whether or not a 9-year-old child can have a Facebook account, or is it the father's account whereby he's posting pictures of the minor child day-to-day activities. But from a point of view, parents should be able to discuss this. As I mentioned early on, tomorrow there will be a different problem, something else, and these specific parents cannot agree upon these things. If the parties were in a relationship, they would have discussed it, they would have just argued it, and they would have made a decision regarding that. So from a legal point of view, I cannot really see any recourse as, for example, going to the police station and so on. The other recourse would be to contact Facebook, to contact TikTok or Instagram and say, this is a 9-year-old child, please close the account. But I'm certain they can open up an account again on a different name and a different username, etc. The only option I could see or presume would be to approach the High Court, and the High Court will have to make a decision if it is in a child's best interest. It can be very expensive. But then tomorrow there's another problem, another issue. Co-parenting counseling, I'll say that's most probably the best thing to do, because when it comes to these type of things, the parents have to agree upon it. And if they cannot come to an agreement, what does it mean? The account shouldn't be opened, or the action should not be taken place, or if they cannot come to an agreement and the party who proposes something can go ahead with his or her suggestion, for example, giving the minor child a cell phone or not. That is where counseling and co-parenting comes in. The best of co-parents are the best of parents, and that is best for the minor child. The commenter went further and says to put a stop to it, as she was told by her dad to keep it a secret. It's clearly a family issue. It's not necessarily a legal issue. Tomorrow the child, not the specific commenter, I will never refer to anybody specifically who comments, that will be wrong upon me. But let's say tomorrow we have a scenario where the father lets a minor child wear certain type of clothing. It might be inappropriate for that specific family environment, and tell the minor child, please keep quiet. Do not tell your dad or your mom about this. So whenever the child visits the mom or the dad, the child is allowed to do certain things, or the child is allowed to do swimming or cycling or piano. The parties might be very religious at the father's home, and when the minor child is at the mother's home, they might not be so religious, or they might engage in conduct which is not allowed religiously, but it is allowed legally. From a general point of view. What do you do then? Clearly, parents need to discuss these matters, come to a resolution. And my advice, as I mentioned earlier on, are for them to actually go to a professional and to discuss these matters. If they cannot, they need to go to a court of law, and the judge will decide whether or not it was justifiable for the matter to have come before him in the first place. Let us move on. I got an additional question from someone else. The comment of earlier on, you're welcome to add additional comments, and I'll be happy to answer them. The comment is as follows. If there is a garnishing order, how do I get the yearly increase? Unless a garnishing order specifically states that the amount get increased every year, the order. So basically, there will be a maintenance order in place stipulating that the one parent should pay X amount of maintenance per month. If that specific order says there is an annual increase, either in terms of the CPI, the Consumer Price Index, alternatively an amount of 10% or 12 or 15%, whatever the parties have come to an agreement with. If there is such a clause in the maintenance order, and the order becomes enforced in a garnishy way, in the sense of the one parent is not paying the maintenance on time, and now the employer is now ordered to pay the maintenance. If there's an increase in the order, the employer will be forced to pay the annual increase. If there is not, then there needs to be an application will have to be made to the court, and you will have to ask the court for an increased amount, and at the same time try to convince the court that you require CPI to be implemented, because it cannot come to court every year, etc. The challenge I have with CPI and the annual increase of 10%, it might work should the minor child be in primary school. But as a minor child gets older, the expenses changes. He might all of a sudden eat double the amount of money, and therefore the 10% might not have been appropriate. So the ideal would be to approach a maintenance court every year based upon the current circumstances. However, that can be tiresome and obviously expensive. You'll be making use of lawyers and so on, and losing time at work. Therefore, on that note, I would always advise people, the order should specifically stipulate that the one parent should pay for the following expenditure. For argument's sake, either half the school fees or pay for the medical aid, and you work those specific things out. And the cash contribution that actually gets garnished by the employer, that only relates to generally food and maybe clothing. And if you are dealing with the issue concerning school clothing, the order will specifically stipulate that the one parent should pay half the school clothing. So although the school clothing increases every year, maybe by 20% or 30%, that is possible. Or if a minor child this year requires no school clothing, maybe only socks and a trouser, by next year he or she might require a blazer and so on, which will increase the amount greatly. The order will stipulate that he or she should contribute half of that specific expense, which makes life much, much more easier for the parties. Therefore, coming back to the questioner, unless a court ordered a garnishee amount to be increased annually, there's nothing you can do. The same way, even if there was no garnish order in place, someone has a maintenance order in place. It says that one party should pay a maintenance amount of 500 Rand per month. I'm using simple figures. And he or she does not pay, and he or she pays every month 500 Rand per month. Every year. So the years are going on. And the question will be posed, how do I get the CPI an increase? You will have to approach the maintenance court. I speak under correction, but my understanding is that the maintenance courts do not out of their own stipulate CPI or increased amounts in the order. They expect you to come back to the maintenance court. I might be wrong. I'm certain some maintenance court might have a different approach regarding that. But my understanding is that unless the parties agree on an annual increase, they will only make one amount, and if you require more money following year, you should make an application to court, and the amount the following year will not be based upon CPI or 10%, but the actual needs or the actual reasonable increase that is required. It could be 20% as well. Thank you for that. If you have any additional questions or additional comments, please feel free to pose it. As I mentioned early on, I am watching the Advocate Muhammad Abduroaf Facebook page, Facebook Live. That is where comments should be directed to, and where I will respond from. These specific videos are streaming on other Facebook pages as well, and on other Facebook groups. If you pose a question on those specific groups, I will not see it unless it's on the Advocate Muhammad Abduroaf Facebook page. Then I will definitely see it. Okay, moving on. Child custody and child maintenance, serious topics, serious issues. I have explained quite in depth yesterday how challenging these specific topics are, the challenges that me as a legal practitioner face, and the challenges that you as a parent would obviously face when dealing with these type of matters. But having said that, life is challenging, and important things are usually, worthwhile fighting for. Therefore, if you and the other parent can come to an agreement regarding child custody and child maintenance issues, I strongly advise that you guys seek professional assistance, either going to the mediator, an attorney, someone to assist you in resolving these specific issues. If you cannot resolve these specific issues, unfortunately, you will have to approach a court of law. A question which has come to my table quite often, and which I might have mentioned it previously, is what is the connection between child maintenance and child custody? Or in other words, if I'm paying child maintenance, does it automatically mean that I am entitled to have custodian rights, contact rights, etc. to the minor child? That question gets posed, and obviously that question will have to be properly answered. The quick answer would be no. Those are two separate issues. Child maintenance and child contact rights, guardianship rights are two separate issues. You can have the scenario where a parent pays no child maintenance, nothing, zero, and have contact to the minor child every single day. And also you can have a scenario where one parent cares for the minor child consistently, does not have an income. For argument's sake, the mother, she's at home, she's unemployed, she's caring for the minor child all the time, she has no money to support the minor child. The other parent is paying for all the minor child's needs, but the other parent in this scenario would be the father. He has no rights of contact. He can most probably see the minor child once a year, once a month, once a week, whatever the case may be, although he's funding the minor child's lifestyle, which he should do, because the other parent is unemployed. Because if he does not do that, what happens to the child? How does the child eat? If you have money in your pocket, the other party is not working, how does the child eat, or how does the child survive? We have to look past our egos. We have to be reasonable and focus on what is best for the child. And at the same time, a parent can say, I'll be paying more maintenance. I'm seeing the child for 1 hour a month. What if I give you now double the maintenance? I give you now 10,000 per month. Judge, I would like to have more contact because now I'm paying more. I've got a better job and I can pay more maintenance. Two separate issues. I have another question, or I think it's a further comment from the previous question regarding the garnishee order. It says the following. Will that be an original order? Where clothing is concerned, the order, he was ordered to buy X2 yearly, so it's 2 times a year, and has not increased. How to go about that as well? Yes, the original order will have to deal with the annual increase and the CPI. The garnishee order is not a new order. The garnishee order is basically a clause. So there is a current order in place for the father or the mother to pay child maintenance. That's the original order. There's an issue in place where the father or the mother does not pay the child maintenance, but there's an employer. So a second order gets drafted, ordering the employer to pay the money over to the mother in our scenario. So it's an order. You can have 4 garnishee orders in place. You can have one garnishee order against, a garnishee order against different employers if the guy or the mother works at different places. But the original order stipulates the amount. So that is the case. So if I look at a scenario, you will have to apply to the maintenance court for an increase. Look at the entire situation. Look at the issue concerning clothing and so on. He has to pay clothing. He has to purchase the clothing if the court order says that. If the court order is a bit vague and it doesn't work so well, then you have to go back to the maintenance court and say, you made an order stipulating that you should pay clothing twice a year. You must purchase a minor children twice a year. You did not stipulate how much clothing and so on. But this is what the child requires. They require a jacket, shoes, whatever the case may be, applicable to your kids. Each family is different. Some families require more, some families require less, some families does not require that specific item at all. And you say, these are the issues which I'm facing. Please, magistrate, please, court, please change the order so the order can be more workable. So the order might have to stipulate either he should give you a sum of money, which can be complicated because every year those amount changes, or this year the child requires a jacket, but jackets cost more money. Like the price of ginger and garlic, all those things have gone up and we didn't expect that. But be that as it may, look at the current situation, look at the problems you have, and make an application to the maintenance court to fix all these specific problems. Anything is possible. The court will have to decide what is best for the minor child. However, the amount and the items the party must pay will be solely based upon the needs of the minor child and what the parties can afford. I hope that answers that. You are welcome to pose additional questions and I will see it and I will try to answer it. An additional question. My ex is applying for shared custody now that I have applied for an increase in maintenance. We have a mediation now at 11 of our finances. He is going to use the pending case at Children's Court to delay the increase. Is this possible? Maybe before I answer that, the ultimate maintenance amount will obviously be based upon the movement and the life of the child. If a reasonable amount of money to be paid for child maintenance is 100 Rand, I'm using silly figures again, is 100 Rand. But that is based upon the fact that the minor child primarily resides with the mother and she buys all the food, she buys all the clothing, she pays for the school fees, and so on. That's amount. Now the matter gets re-looked at, the contract care arrangement gets looked at, and the child will have to spend half the time with the mother and with the father. Meaning that the father who used to spend only 4 days per month, 4 days per month. He saw the child every second weekend, 4 or 5 days a month. Now we'll have to see the child or care for the child 15 days per month, 10 days more. The mother, on the other hand, will not have to purchase a lot of food, so much food at least, because the children will be eating at her place 10 days less, and so on. So therefore, the caring arrangements and contact arrangements in relation to the minor child has a direct consequence on the amount of child maintenance one parent should pay towards a minor child. If all else is equal, both the mother and the father earn the same amount of money, basically the same expenditure, and they come to some type of a 50-50 shared contact arrangement, then under those circumstances, it would not make sense for the father to pay the mother any amount of maintenance because they earn the same amount of salary, they have the same expenditure regarding the minor children. Why should he now pay her? He shouldn't. It doesn't make sense. Unless, for example, she has additional personal expenses which are reasonable. Maybe her rental is a bit more, whatever the case may be. But it's a mathematical equation and you'll have to work it out. Going back to the Pacific commenter, yes, that is most probably what I would suggest my client. Before the maintenance matter gets finalized, the court cannot finalize it to finality until the finalization of the current custody matter. The court, parties can agree upon some interim arrangement. Let us say they finalize the maintenance matter, pending the outcome of a custody matter. Well, not pending, there is a pending custody matter. They finalize it today. The maintenance court says, based upon the fact that currently the father sees a minor child for 4 days and the mother cares for the minor child for the rest of those days for the month, the father should pay the mother 100 rand maintenance. 2 days later, the custody court finalizes their matter and they order that the minor child should live in both households equally, shared contact, 50-50. What happens then? Then the father will have to go 3 days later to the maintenance court and have that court order varied. The Pacific commenter mentions that they are busy with mediation regarding the maintenance. She says we have a mediation now at 11 of our finances. It doesn't seem it's a maintenance inquiry or for maintenance trial before maintenance magistrate. Mediation, even if there was no high court matter or 50-50 shared care matter pending before a court, no party is obliged to agree to the request of the other party in mediation. The same way, if the scenario, the father offers to pay a small amount of money, she is not obliged to accept it. And the same way, if the mother wants a high amount of money, the father is not obliged to accept it. Alternatively, even if the mother asks for a reasonable amount of money, the father is not obliged to accept it. He'll be silly not to, but he doesn't have to because it's a mediation session. It's an opportunity for both parties to lay the cards on the table and for everyone now to see what's what and what would be a reasonable amount of maintenance pay. If this mediation session does not work, I would say, based upon the mediation session, the party should come to some type of arrangement based upon the current arrangement. The current arrangement is that the father is not exercising 50-50 contact with the minor children, and therefore the maintenance should be reasonable based upon that. The maintenance matter should obviously be postponed until the custody matter is finalized, because then we really know how long or for how many days or where the minor child should or would reside during the Pacific month, so that we can work out the maintenance that should be payable by a party or not be paid. In other words, should there be a maintenance order in place if the parties are sharing contact and care equally, if both parents' income and expenditure are exactly the same? I hope that answers that specific question. I'm being very academic. I'm trying to be general. Obviously, the mediator will do his thing or her thing, and ultimately the maintenance court will have their own opinion based upon all the facts before them. The father will, of course, or his attorney will, of course, argue that the maintenance matter cannot proceed until the custody matter has been finalized. And obviously, you will argue that no, it should proceed to the point whereby there can be a proper interim arrangement based upon today's circumstances, because the custody matter might not be finalized soon. It might take many months for it to be finalized. And because of that, we need to come to a resolution now. And this resolution should at least be in place until the custody matter is finalized. I hope that answers that. I have a new question from a different person. I think this is now the fifth one. What is the consequences of a parenting plan that is not adhered to by the other parent? Serious consequences, but it depends. If the parenting plan was only signed by both parents, in other words, it was not made an order of court, it was not registered with the Office of the Family Advocate as provided for in Section 33 of the Children's Act. So there are two types of parenting plans, or finalization of a parenting plan. The one is it gets made an order of court. The other one is where it gets registered at the Office of the Family Advocate. If that is the case, what can I do? You guys drafted a document. Sorry, if the case is that you have not registered it or made it an order of court, it's just a piece of document basically stipulating what the parties have agreed upon, and it's regarding a minor child, so it's not really like a contract for the sense of I owe you money or I will do the following service for you for breach of contract, because minor children issues are looked at as current, as present, how it applies presently, and what is in the minor child's best interest today, not because the parties have agreed to it. If a party has signed a parenting plan and it comes before a court and the court decides no, and I don't think this is in the child's best interest, the court won't endorse it. If the parenting plan was made an order of court, obviously serious consequences can arise because you are in violation of a court order. If a parenting plan was registered with the Office of the Family Advocate and one party is refusing your contact, also serious criminal or serious legal consequences. The commenter of previous is, thank you, you are welcome, regarding the garnish order. The commenter regarding the maintenance matter, the mediation, and so on, made the following additional comment. Trial comments on the second and third of mediation if mediation does not work. So I'd imagine second or third of next month, because today is already the third. Then the matter must finalized, and then get a finality on the maintenance matter. And then the child custody matter must still proceed, because that is not dependent upon the maintenance matter, and the maintenance amount is obviously dependent upon the child custody matter. I'll give you a different scenario. Let's say the parties are now in dispute. The minor children are in the care of the mother for that 26 days. They're on the care of the father for the 4 days every second weekend. Now something happened. The mother done something bad or she's unable to care for the kids, or whatever the case may be. The father thinks, now, man, I think the children are old enough and I would like to have primary care over these specific minor children. The father now makes an application to court for him to be the primary caregiver, and the contact arrangements to swap, meaning the mother will see the minor children for a period of 4 days, and the father will see the minor children for a period of 26 days. If that is the case, and that matter is pending, and now the court makes an order and proceeds with this matter to finality, based upon the fact that the minor children are in the mother's primary care, knowing that the High Court matter will be finalized also in a few weeks' time, soon thereafter. The High Court or the Children's Court dealing with the application for primary care makes an order stipulating that the minor children should now be removed from the mother's primary care and placed in the father's primary care. What happens then? Here the father has an obligation to pay 100 rand per month to the mother, but she only cares for the minor children 4 days per month. And based upon the facts, and I'm using silly figures here, the 100 per month is way too much. It's applicable to someone who cares for the minor children for 26 days. And that's that. So therefore, I would say the sooner the maintenance matter can be, the sooner the custody matter can be finalized, the sooner the maintenance matter can be finalized. However, my argument obviously would be if the custody matter is long, it might take another few months, maybe a year, then obviously the maintenance matter needs to be finalized now. And then in a year's time, whatever happens, the parties can come back to court. Thank you for that. I hope I answered your question. If you have any additional comments or questions, please feel free to pose it and I'll try my best to answer them. We are now going into half an hour of the formal part of this video. We just passed half an hour. Yeah, but 5 minutes or so we were waiting for people to join. If you have any questions, please make use of the Advocate Mohammed Abduroaf Facebook page. If you would like to receive reminders on Facebook regarding these specific webinars and these videos, you're welcome to do so on the Advocate Mohammed Abduroaf Facebook page. I do not see any other questions, and I hope I have answered those specific questions to the persons who have posed it. I will be online again tomorrow, and this evening at 2 o'clock, I'm with an attorney. We will be discussing family law matters, and you are welcome to join therein. It will be very informative and very, very interesting as well. Please share this video if you found it interesting, and I hope to see you at our next webinar. And please follow our page. Have a lovely day. Once again, good morning to everyone to our live Q&A webinar on Facebook Live, where I answer and engage with you in relation to whatever family law related questions you may have. Although the topic is child custody or child maintenance and child custody, you are welcome to pose any questions regarding divorces, guardianship issues, passport applications. I think they fall under guardianship rights, relocation, and so on. Feel free to pose whatever questions you may have regarding that. It will be greatly appreciated, and I'll try to engage best as possible with you. Please note, it needs to be posted on the Advocate Mohammed Abduroaf Facebook page. I'm looking at that specific page. Lastly, many people have requested, and they are still doing so, can they pose a question before the time? And I will post it on our whiteboard the next day, most probably, and later on when they come from work or when they have time, they can view the video where I have dealt with a question. I have decided I will be doing that from now on, but it needs to be posted on the Advocate Mohammed Abduroaf Facebook page, in the sense of you need to send me a message on that page. Therefore, if you want to have a question answered from me on Facebook Live, for me to post that question on our screen, but for you to view the answer later on, please send me a message on the Advocate Mohammed Abduroaf Facebook page, not my personal Facebook account, however, the Advocate Mohammed Abduroaf Facebook page. Send a message stating there, please answer the specific question, and the next morning when we are preparing the specific stream, we will copy and paste that specific question onto the screen and deal with it. So when you have time and you want to view the video, I will deal with that. I hope that answers that specific query or that specific request. Here we have the first question. Thank you very much for that. Let us copy and paste it onto the whiteboard. Okay, that's question 1. It goes as follows. Where does the NPA fit into an arrears child maintenance claim? when it has been converted to a criminal trial. The NPA, I would presume, referring to the National Prosecution Authority, the prosecutors at court. So if you go to court and you're involved in a criminal matter, there will always be a prosecutor trying to find you guilty, basically. He prosecutes the case. They're not persecutors, they're prosecutors, and they have an obligation to make sure that justice prevails. You, on the other hand, will have your defense attorney or your defense advocate defending you. The prosecutor will put a charge sheet before you. The magistrate will obviously be in court to ensure that justice prevails. However, the NPA has the authority to prosecute crimes and offences within South Africa. Therefore, if a person has not complied with a maintenance order, in answering this question, it's possible for that person to be prosecuted because that person has committed a criminal offence. Under those circumstances, the complaint will be laid at the maintenance court. They will open up whatever documentation, whatever files or folders, charge sheets, dockets, and etc. necessary in order for them to proceed with a necessary complaint. And that will be sent to the prosecutor. The prosecutor, the NPA, will have a look at it and he will decide now whether or not he will proceed with that specific complaint or that specific offence for not complying with the maintenance order. That's it. That's the long and short of it. And then the prosecutor will either cause you to appear at the criminal court, and when the trial runs, he will prosecute you. He will call the complainant to court. In this case, for example, let's say the mother, she'll come on the witness stand, that he or she will be his first witness, the complainant. The complainant will stipulate in court, I appeared in the maintenance court many years ago. The court granted a maintenance order. Here's a copy of the maintenance order. The maintenance order stipulates specifically that the father should pay maintenance for this amount of money on a certain date. The father has not complied with the maintenance order, which is a criminal offence. We are here today and the father is in arrears of 10 months of maintenance. That's the long and short of it. You present all the information. If the father has to pay within a bank account, you show your bank statements. It gets presented as exhibits. The magistrate sits in the middle on nobody's side. He or she just wants to get justice to be seen. And once you are done with your specific testimony, the accused or the accused in a specific matter, for our example, the father, he will, either him or his attorney will cross-examine you. They will most probably try to say, no, there was an agreement in place that he will not be paying maintenance, there's an understanding in place, or he has been paying maintenance and he paid it to you in cash, whatever the case may be. And then that will be it, most probably examination in chief and cross-examination where you are concerned, that's all finalized. There may be re-examination by the prosecutor, the NPA, afterwards. And if there are no other witnesses, for example, maybe monies had to be paid into a different account in a different way, you might want to call those specific witnesses, all to prove that the person has not complied with the maintenance order. Once that is done, the state might close their case, and then the defense comes. And then the father will come on in our example, and he will now say, no, I have complied with the maintenance order. Here is my evidence, here's my proof. Or we came to an agreement, the mother understood that I could not afford the maintenance in the first place. There was an agreement that I should no longer pay maintenance, whatever the case may be. And whatever he says, but he will have to prove his case, and he will have to prove that he was not in violation of the maintenance order. At the end of the day, the court will make a decision. If he was in violation, they will obviously do the necessary sanctions. There's a few that they can do, but the person could get up to 3 years jail time for not complying with maintenance orders. And that's the long and the short of it, and I hope I have answered your question. That's the role of the NPA, the National Prosecuting Authority, and the prosecutors at the bottom appear in court, act on behalf of the National Prosecuting Authority. So let us move on to our next question. So that was question number 1. I think we have an addition to question number 1, and we have question number 2. Let me first add the addition. And let me type in question number 2's question so we can have a look at it and not forget to deal with it. And a reminder again, if you have any questions and you're watching this video later on either via YouTube or or on the channel, but when it replays later, you're welcome to pose any questions to be answered at our next webinar on the Advocate Mohammed Abduroaf Facebook page. You send me a message there on, and the next morning we'll look at it and we'll copy those questions into our whiteboard before the time. Let me just complete with question number one's question, and it goes further. So if you have been prosecuted, have you then been found guilty already for contravention of Section 31 of the Maintenance Act? Why then do you have another trial? There is only one trial. The person might refer to a different application. Prosecution, you can't be found guilty by prosecution. You can only be found guilty if the magistrate finalizes its trial and the magistrate makes a decision, provide a judgment that you are guilty of non-compliance or Section 31 of the Maintenance Act. That's it, full stop. So there's not two trials. They must find you guilty, and the only way they can find you guilty is through a trial. There could be an additional inquiry later on, where the criminal court refer this matter back for an inquiry at the maintenance court. That is also possible, but that's something else. I hope that answers that specific question for question number one. If you want to add anything else, just let me know in your comments that you are question number one. Okay, question number one says, thank you, you are welcome, and you're always welcome to pose any additional questions you may have later or tomorrow. Question number two, let us deal with that. Good morning, I am an unmarried mother to a 7-year-old in grade 1. So she's unmarried and she has a 7-year-old who's in grade 1. The father has seen my son about 5 times, no maintenance. Should I apply for guardianship, and will this be a high court costly matter? Reason being is he is on the birth certificate and I have no communication with the father, and he has said he will sign over the rights as he wants nothing to do with the child. I'm struggling with school documents and no further passports, etc. will continue to become a problem. Okay, I added that last comment. Yes, I would advise you to approach the court, and unfortunately, I believe only the High Court can deal with these type of guardianship issues. I speak under correction, but my understanding is only the High Court can deal with that. You are welcome to, and I advise you to double check with the Children's Court if they have the jurisdiction to take away somebody's guardianship rights or limit their guardianship rights. Nonetheless, an application will have to be made to court whereby you will basically ask the court for you to have sole guardianship rights when it comes to certain type of decisions. One would be, for example, an application of a passport for the minor child to leave the country, maybe go on holiday with you after COVID-19 comes to an end. The others would, for example, be when it comes to educational issues. The schools might say, okay, we see on the birth certificate that the father is a biological father. Where is he? You'll have the problem all the time. Then you'll have to explain, I do not know where the father is, or the father does not want to get involved in the child's life, and so on. Under those circumstances, obviously, you want to avoid having to explain yourself all the time. Then you will show the court order stipulating that you have the sole decision making when it comes to these type of guardianship rights, a minor child's education, enrollment to schools, purchasing of property, and so on. So my advice to you is approach a court. Because the father is not opposing this application, he is willing to agree to all of this, then the application should be quite straightforward. You'd obviously want to get a very well-drafted court order to avoid problems happening in the future, especially if you decide to go overseas and go on holiday somewhere else and go to the Department of Home Affairs, etc. So my advice to you is approach the court, see a good attorney that knows about these type of matters. Generally, I would make this application in the High Court. I never done in the Magistrates Court before because I do not think the Magistrates Court has jurisdiction with it regarding that. But I do not want to put my head on the block at this moment. You can obviously double check with him or look at the Children's Act. All my applications in this regard I have made to the High Court. Some of them were opposed, some of them were by agreement, and when they were by agreement, it was very easy, simple. Within a few weeks, we obtained the order. Generally, it was for relocation of the minor child, whereby should the minor child be in a different country, the father's consent would not be required regarding schooling, medical, education, I said that earlier on, whatever is required under the circumstances, or application for renewal of a passport. It should be much more easier should it not be applying to relocation in South Africa. So there it is. My advice to you is make the application to court as soon as possible. The father will not oppose it. And then for the next 13 years of the child's life until he turns 18, you do not have to deal with the father in any aspects regarding guardianship rights. I hope that answered that specific question. And I'll repeat myself one more time. If you have any questions and you're watching this video later on, please feel free to send us a question on the Advocate Muhammad Abduroaf Facebook page. Like the page, and I will deal with that question the next time I go online. And we have another question, question number 3. Let us deal with that. Let me get it onto the whiteboard. And if you are watching this video, you're welcome to say hi. Please say hi and say from where you're watching it from. It's always good to know where your audience is from. Question number 3. Good morning. Do you need the father's permission to take your child overseas or apply for a passport if he isn't listed on the child's birth certificate but has done paternity tests and pays maintenance? Yes, you require his consent if he's a co-holder of guardianship rights over the minor child. If he's a co-holder of guardianship rights, and generally many fathers are, if he was involved in the child's life and partook in the child's life and so on. I would say, besides that, the Department of Home Affairs, they will request, because they'll ask the question, where is the father? And you might say, you don't know where the father is, we do not know where the father is, or the father is not involved in the child's life, or the father does not want to be involved in the child's life, and so on. Your problem will most probably be the Department of Home Affairs. That will be your challenge. And under those circumstances, I would advise you, or you're required to obtain a court order specifically stipulating that you do not require the other party's permission any longer. The specific parent can, of course, give consent. He can go with you to the Department of Home Affairs when you apply for the passport, when you apply, or give you a letter of consent stipulating he or she is happy with you going overseas. However, to avoid problems happening in the future, especially under these circumstances, I would advise you most probably to approach the court to get an order stipulating that you are the sole guardian over the minor child, or you have sole guardianship rights over certain aspects regarding the minor child. When it comes to passport applications, going overseas, medical consent, and so on. Therefore, despite a father not being on the birth certificate, that does not give a father parental rights and responsibilities. A father can be very much involved in a child's life, extremely involved in a child's life. He could be married with a mother, involved in a child's life from the word go, but for some or other reason, his name is not on the birth certificate. Something could have happened, or the mother fell pregnant, she gave birth to the child, they got married a few months later. For some or other reason, the father's name is not on the birth certificate. It doesn't mean that the father's name is on the birth certificate, the father has rights, or his name is not on the birth certificate, he does not have rights. The birth certificate has nothing to do, or put it this way, the insertion of the father's name on the birth certificate has nothing to do with his parental rights and responsibilities. It's two separate issues. Therefore, to avoid problems happening in the future, I advise you to obtain court orders specifically dealing with guardianship rights in the future. I hope that specifically answers your question, and if you have any additional questions, feel free to pose it. And the question number 2, yes, says, thank you very much. You are welcome, and you're welcome to pose any additional questions should you have. I'm always happy to assist people and guiding them to whatever direction I can. You will notice on my screen, there's been some movement happening over there. So if you see some movement, it means somebody posed a question. You're on my right-hand side. And I'm keeping a close look on that specific screen. Moving forward. So looking at our webinar so far, we're dealing with a lot of guardianship issues. 2 issues, passport. 2 questions asked about passport, a very important issue. The Constitution of South Africa allows every citizen the right to a passport. It is a constitutional right. Therefore, if someone wants to oppose your application for a passport for a minor child, let's say the father now refuses consent because he says, no, the child is too young, the child does not require a passport, but constitutionally he or she is entitled to, but you as parents are the guardians, therefore your consent is required. Now the father refuses consent for the application for a passport. And you take it to court, the court will say, here's a constitution, the child has a constitutional right to a passport. Why would you want to avoid or limit the child's rights to have a passport? Unless there's some very, very good reason why the child should not have a passport. I do not believe the court will at any point will refuse such an application. One possible good reason could be that the child is extremely young and there's no possibility of the child going overseas in the near future. That could be a possible scenario. Alternatively, the passport has a certain lifespan, let's say 5 years, and the child intends to only go overseas in the next 4 years' time, and it makes more sense to go to apply for a passport in 4 years, so that it can be valid for the next 5 years. I'm just using random numbers here. You can verify with the Department of Home Affairs on those aspects, and you can argue that if the court grants the order now for a passport to be granted, there will be issues in 4 years' time because now the child will be overseas. Maybe the child will decide to board overseas and other complications will arise. So it makes more sense to apply for their passport in 4 years' time. But those are silly arguments in the sense of I think the court might even override it in any event. If you have a right to a passport, we can't predict what will happen in 4 years' time. I know many people who renewed their passport just before COVID-19, and a year has passed by, they couldn't go overseas. So that's how life is. Any further questions, feel free to pose it. If not, we are now streaming live for the last 19 minutes. So this might be a half an hour webinar if there are not any additional questions. Now, on this topic of consent for a passport, goes with it the consent for relocation. I touched on it a bit early on this webinar. Relocation, and that's something which kept me very busy before the lockdown, where parents have decided to relocate to a different country. The mother might come to my office and say, you know, life is hard, challenging in Cape Town. I have an opportunity to better myself, better my life for my child. I am the primary caregiver of my child. The father is involved in the child's life to a certain extent. However, I'm the one who has to deal with the day-to-day activities of the child. The child is more closely connected to me, and the father most probably only has contact every second weekend, whatever the case may be. But when I go overseas, I'll have a better life, better education for the child, etc. The downside of that would be the other party, the father, will have contact with the child much less, maybe only once a year, or at best twice a year. Once a year when the child comes visit his grandma, his uncle and nieces and uncle and cousins in South Africa, once a year. And the second time might be when the father visits the parties, let's say, for example, Canada. That's the situation, but the mother will say, you know, in South Africa I'm earning, let's say, for example, 100 Rand, but they'll earn 1,000 Rand. I'll earn much, much more. I'll be able to better my life for me and the child, and we will not have to struggle so much here in South Africa. It's a difficult argument. It's a difficult thing to deal with, because on the one hand, the child will not have any contact, regular contact with a parent in South Africa. But can a parent living in South Africa demand and say, no, mom, you need to stay in South Africa, because if you do not stay in South Africa, I will not have contact. But then again, the father, he can decide to go overseas without even consulting with the mother, even if he has to have contact every second weekend with a child. He can say, no, I'm not going to Canada. I do not have to consider anyone. So it becomes a bit of a difficult situation, where the father might not be able to support the mother as much as he would want to, or what she requires. And all these conflicting rights comes in. But it seems to me the mother will be the one that will be losing the most, because now she stays in South Africa, she continues to struggle, dad continues with his good life, and she must now struggle with the minor child. If she could have gone overseas, look after herself, better herself, but then the father will not have contact, but he will continue with his life. We have Zoom, we have Facebook, we have FaceTime, we have WhatsApp video. So those are stuff to consider. It's a difficult decision to make. I do not want to preempt what the outcome of such an application will be going to court, but the court will obviously have to determine what is best for the minor child under the circumstances. Will it be better for the minor child now to remain in South Africa? This parent that now lives in South Africa, in our example, the father, can he care for the child then? Does he have the facilities to care for the child? Maybe he remarried, maybe has his own children as well. So is he demanding and stipulating, no, the child must stay in South Africa with the mother cared for by the mother, but he's not willing or capable of caring for the child in the first place. So it places a great demand on the mother and also limiting her liberty and so on. And she has a constitutional right to travel the world and enjoy life. But the problem we have is the father, he will not see the minor child, which is also extremely important because the child needs to see both parents. So that's the conflict. It's a huge conflict. The court will determine what is best for the child, and if it's best for the child to go with the mother overseas and relocate with her, the court will make that decision. If it's best for the mother to stay in South Africa, stay struggling, and for the father to have his every weekend contact, because he wants his every weekend contact, the mother must continue struggling. The court will make that decision. I'm not preempting. I'm just giving you various scenarios and various arguments that might apply. I saw another question came in, and let's deal with that question. I'm highlighting it now. Question number 4. I have so many windows open in front of me. I must find out what window applies. We're on the whiteboard. Good day. Could you please advise if a parent's access has been removed and has not made any effort to go through mediation? How do I go about getting a passport as we have no contact as per the court ruling? If the other party does not have contact with the primary caregiver of the minor child, then you will have to go to court and get the court to give an order in relation to the passport. Basically what the court does is the court looks at the matter, and the court will now decide whether or not it's best for the minor child to obtain a passport. So if one parent does not want to give consent, or the one parent cannot be found, the order will basically stipulate that the applicant, generally the mother, may apply at the Department of Home Affairs for a passport for the minor child. They stipulate the minor child's name and ID number without the consent of the respondent, meaning the father. And that's it. If the Department of Home Affairs see that order, they will just proceed with the application. And when it comes to the father's signature, they will leave it empty because the court order says only the mother's consent is required. Therefore, if a party has no access to the minor child, if I'm reading the example now correctly, if the party has no access to the minor child, but the court order does not stipulate that one parent has sole guardianship over the minor child, under those circumstances, both parents are co-guardian and both parents' consent is required. And under those circumstances, if one parent cannot be found, who is a co-guardian, or refuses contact, you approach your court and the court will decide what's best for the minor child. That was my comment to the comment of question number 4. If you have any additional comments to add to that question number 4, please feel free to do so and I will try to deal with that. But I see we have question number 5 now. Let me deal with question number 5. Copy it onto the whiteboard. Just a bit of an interlude as I mentioned earlier on. If you have any questions and you're watching this video later on and you have specific questions, please make use of the Advocate Mohammed Abduroaf Facebook page and pose your question there. Okay, let's deal with question number 5. If we're busy with an arrear maintenance case and the father still isn't keeping up with maintenance payments, even though we have a maintenance order in place, what can happen or what am I to do? Also, if I want to get a garnishment order, what do I need to apply and how long does it take? I presume the parties are dealing with a arrear maintenance case in the criminal courts, or has an application been filed, or are we before a maintenance officer trying to resolve this matter? If a maintenance order has been made, it's a maintenance order. It's an order of court. Even though it has been made in a maintenance court or in the high court in a divorce matter or in a child custody matter, whatever the case may be, it's an order of court. A high court order has no more power than a magistrate's court order. An order of court is an order of court and it must be adhered to. If the party is not adhering to the maintenance order, you lay a criminal complaint. You go to the maintenance court and lay a criminal complaint. He has to comply with the maintenance order. If at some point a party cannot comply with the maintenance order, you need to apply to the maintenance court ASAP. If you know your salary will come to an end at the end of this month, you do not wait till the end of this month first and then apply and not pay maintenance and then apply for a reduction in the maintenance. No, you immediately go to the maintenance court and make an application for reduction. So I hope that answers your question. In summary, quickly, my answer would be the maintenance order must be adhered to and you lay criminal complaint at the maintenance court because he's not complying with the maintenance order. But I do not know what there's a real maintenance case. Is he applying for deduction already or has there been a complaint? So the court might deal with the matter in a logistical fashion in the sense that we're dealing here with an arrear case, but what about a criminal case happening as well? So I think you need to get a bit of clarity from the maintenance court. Because usually if somebody is in arrears, there's two options. One is either attach his property or lay a criminal complaint. So you'll have to get some verification from the maintenance court what's happening in your specific case. And the second part of the question regarding the garnish order. The moment a person is complying with the maintenance order, you are welcome to and you should apply to the court for a garnish order, whereby the garnish order, where the employer will be garnished or the employee will be ordered to pay the maintenance on behalf of the employee in terms of this garnish order. I cannot say how long it will take with COVID-19 and how long the courts are operating, but it shouldn't be a long process. You proceed to the court, you make the application, 1, 2, 3, because there's no dispute regarding the amount. That's very important to note. So it's not a long procedure whereby you have to show your income and expenditure. All that you have to show is there's a maintenance order in place, the party is not adhering to it, that's it. And the court should grant a maintenance order. There might take some time for them to get the specific order to the employer and for the employer to put it onto their system and make it happen. But that's some logistical issues, but it shouldn't take that long at all. That was question number 5. Thank you very much for that. I hope I answered your question. And the long and the short of it is go to the maintenance court as soon as possible. I have an additional comment on question number 4. I think it's a thank you comment, but it might say something else as well. Let's see. Thank you. You have answered my question. The court has granted no access, but I have not received sole custody. Okay. So she has not received sole custody. When it comes to passport issues, we're basically dealing with the issue concerning guardianship. Custody is a day-to-day care of the minor child, who picks the child up, weekends, and so on. Guardianship are the legal aspects regarding a minor child, like passport applications, relocation, school admissions, medical procedures, contacts with a minor child. Those are guardianship issues. So it's possible for a parent to have no contact rights at all. He's not allowed to see the child, but he has guardianship rights. So when a child wants to go overseas or get a passport, he or she must be consulted or the consent is required. So I hope that answers that specific question. And I see we're running out of time. We now past the 31-minute mark for the live stream. And I think we can cut it short unless I receive any additional comments. So in summary, regarding our format for the webinars going forward, if you are watching this video and you want to pose a question for our next live Facebook webinar, you are welcome to post a question on the Advocate Mohammed Abduroaf Facebook page. Type it in. It's a page. Send me a message, and your question will be posted onto our next webinar. It will be on the whiteboard, and it should be receiving some type of preference. Or what I do is I deal with them one by one, but I will deal with it for sure at the next video. Thank you very much for your time, and I hope you found this video useful. If you have, appreciate. Many people can benefit from this. Otherwise, I'll see you at our next webinar, which will be tomorrow. Have a lovely day. Good afternoon. My name is Mohammed Abduroaf, And those who are joining us via Zoom, thank you for joining us. And whoever comes and join us, I will just add the details. I think we're set. So today's topic is Child Custody Disputes and Battles, Part 2. How do I get the best out of my case? So if you are watching this video via Zoom, it is for half an hour. If you have any specific questions, you're welcome to type it in, and I'll be able to see it. Somebody said hello. Thank you for that. Hello back. If you have any specific questions regarding child custody, please type it in, and I'll be able to see it, and we can deal with that. If you are watching this video via Facebook Live, that's a link on top, facebook.com/ADV Mohammed Abduroaf /live. You are welcome to post any questions. I'll be monitoring that specific web platform as well. There aren't any questions yet. So let's move on. Let's deal with this topic. Previously, we dealt with this topic regarding child custody difficulties. And as we go along, we'll try to unpack certain issues. The idea behind these webinars are basically to get you to understand from a layperson's point of view how to deal with these specific problems. Many people, they look up the law, they look up the Children's Act, the Constitution, etc. And it's quite complicated pieces of documentation. Me, for one, I continuously have to look at the Children's Act, look at various sections, and sometimes I get confused because those specific sections don't make any sense to me. And then you go to court and you argue a matter, and then the judge has a certain interpretation regarding a section of the law. The advocate on the other side, or the attorney on the other side, will also have a certain, interpretation on the law. But at the end of the day, is we like to be pragmatical and, sensible and simplify matters. So how do you start this topic? How do you deal with this issue? And I think the simplest way to deal with this issue is when a couple has problems. You can either be a married couple, husband and wife. You could be a couple that was in a relationship, boyfriend, girlfriend, fiance, and so on. Or somebody that just met somebody and you were in a romantic relationship and a baby came about, and that's where we are. How do you deal with this problem? So the typical case would be a client who would contact us and they'll say, I would like to make a consultation regarding custody rights, guardianship rights, care and contact, as the case may be. So we'll meet with the client. Obviously, the client has no idea as to how the law works, how the courts deal with these type of matters, and how do you unpack and how do you specifically deal with these type of issues. It's the first time that you are dealing with it. You may be a professional person. You may be extremely good at what you do. However, when it comes to these personal issues, you have no idea and you need somebody to assist and advise you. So the first question I would generally ask a person is, what do you want? And believe me, sometimes it takes me a lot of time, sometimes 5 to 10 or 15 minutes to actually find out what this person wants. Then I have to put words in this person's mouth and ask the person, do you want to have custody? Do you want to have the child to stay in your care for the whole week and for the other party to see the child maybe for an hour or two? Then we're getting somewhere and say, no, I don't want that. I want this. Okay. So we go in circles. But at the end of the day, now I can unpack it, what this client actually wants. And many times what the client actually wants is just to have peace in his or her life, knowing that as the week can progress, as the days can progress, there won't be any type of issues and, controversy happening. So once a person knows exactly what you want, then you can go forward with a specific matter. If what you want is to make the other person's life miserable, if you want is to make the other person to how can I explain to you, to punish the other party, yes, or teach the other party a lesson for not marrying you or not, staying in this relationship, I cannot assist you, the law can't assist you, no one can assist you regarding that. But if you know what you want, so if you're a father that you come to my office and you'll tell me, I would like to have structured visitation rights to my child. I separated from the mother a few weeks ago. She doesn't want me to see the child. I can only see the child based upon her terms and conditions. While we were married, there was no issues regarding my family. The child used to visit my family every single day. They used to play with him. We used to go out a lot and so on. All of a sudden, now that I am separated from the mother, she's living with her parents again. My family is not good enough. she doesn't want to have, she wants nothing to do with my family, and she believes my family is bad. And therefore, I can only have supervised contact with my child, who I saw for the last 10 years. I can only have supervised contact with my child at her home, at her parents' home, for a period of maybe half an hour every second day. So things become complicated now, because while the parties were together, life was good. You know, things were fine. The mother would leave the child alone with the father overnight if she had to go away for work, as the case may be. But now that they are separated, problems happens. So these are the complicated matters that we have to deal with. If the parties cannot resolve these issues, they would want to fight and, teach the other party a lesson and make the other party's life miserable, and they're willing to spend a lot of money in doing that. That is fine and well, they're welcome to do that. But at the end of the day, is after that exercise has happened, they will basically get whatever they are entitled to get, or would have gotten in the first place. So the first question, as I mentioned earlier on, what do you want? If you know what you want, we can take this matter further. So now the parties will come to my office and I'll ask the question, what do you want? And they'll say, I would like to have structured visitation rights to my child, or I would like the other party to have some type of structured visitation rights to the child, or I would like the other party not to have any contact rights or any visitation rights to the child. So that's a basis where you're working from, and life becomes very easy for me. Then I'll ask him the question, how involved was the child in the how involved was the parent in the child's life? That's a very important question, and that plays a big role in taking the matter forward. If the other party was not very much involved in the child's life, then it will affect what type of contact rights he or she will have going forward, obviously. So if someone only saw the child once a month, and now he comes to my office and he was always fine with having to see the child once a month, the question is, can he now come to my office and say, I would like to see my child now every single day? It's possible, don't get me wrong, but if you only saw the child once a month for the last 10 years of the child's life, and that's how the child believes how you are involved in the child's life, and the child continues with his life for the next 29 days, knowing that I'll only see my mom or my dad, a month later. Now you come into my office and I would like to say, I would like to see my child every single day or every second weekend, or I'd like to have midweek contact, as the case may be. We can assist you, but we need to be pragmatical and, logical over here. If you want to have contact with a child, it doesn't mean it's there for the taking, for the asking. We need to determine whether or not that is firstly in the child's best interest. Is it workable? If the child lives in Hermanus and you live in Cape Town, and that arrangement for seeing the child once a month was workable because of that, but now you want to change it to every second day, where the child might have to travel now to you in Cape Town, and, that will possibly not work. So we need to be logical and we have to be pragmatical. So we need to sit down with a pen and paper. And this is what I advise many people to do. If you're watching this video and you have certain problems, and you and the other party are maybe, on talkable terms, as the case may be, sit down with a pen and paper, work out what is a pragmatical and the most logical way of dealing with your child custody problem. If you can get past that hurdle, then your results ultimately will be much more easier to obtain. So let's deal with a scenario regarding with a child living in Cape Town and the other parent living, 2-hour drive away from where the child resides. And now this parent wants to see the child every second day. Pragmatically speaking, it won't work. So how do we resolve that issue? We need to get this client. The client wants to see the child more often. He wants to be more involved in the child's life. He feels that for the last 10 years, he was limited with care and contact. We need to determine what is the other party's view on the matter. So I'll ask him or her, what does the other parent say about this? Have you discussed this with the other parent? If he or she tells me, no, I did not discuss it, then I'll say that is the next thing you must do. Before you even come to a lawyer, you need to discuss this with the other parent. If you have discussed it with the other parent and you guys cannot come to any type of, solution or agreement where the parent caring for the child believes that nothing will work, you're only entitled to see the child 12 days per year, which is too little, one day per month. If that other parent believes that is best for the child, clearly you had loggerheads. It could possibly be best for the child, but maybe not. Under those specific circumstances, I would advise a client, firstly, please see a third-party mediator. Let's not send legal letters out here. Let's not, be, how can I say, like litigate happy, be court happier. I'll give them a number of a social worker or a mediator, as the case may be, and let that mediator or social worker sit down on the table with both you and try to come to some type of a solution. I met with a client yesterday and he asked me the question, we discussed the matter, and then I suggested this mediation process to him. He didn't understand it initially, but now he agreed to it. And I said, the reason why I'm referring to mediation is because you might have something on your mind and she might have something on her mind. But at the end of the day, is nobody really listens or hears what the other party has to say. And it becomes a waste of energy because the moment you see each other, the idea is basically to talk and give words over. And the other party's mission is also not to listen to you, and he or she wants to give his words and opinion over, and nothing happens at the end of the day. It's just argumentative. So if you go to a professional, an expert dealing with these type of matters, someone that saw this thing so many times, he or she will be in a very good position to mediate the issue and let the parties come to some type of agreement on the specific topic. If that works, wonderful, you enter into a parenting plan, you come to an agreement, simple, then you go back to the lawyer, you make the agreement and order of court. If it's a parenting plan, also you can make it register with the office of the family advocate and so on. And that will basically resolve that issue. If the parties cannot come to an agreement after they have met with a mediator, or one of the parties refuse to go to a mediator, which often happens, it's not something which I don't hear of. But if one party doesn't want to go to mediator or mediation failed, then unfortunately the lawyers will have to get on board. Then the parties will have to, the party that came to a lawyer will have to work out a parenting plan. A proposal, how does he believe that the matter can be resolved? What would be best for the child? Is best for the child going a total 360 where the child is currently residing with the mother and now the father believes he must have primary care with the child where the mother will see the child 1 day per month, for example? Or is a better solution being maybe every weekend for the father to drive all the way down to Hermanus or the 2-hour drive to see the child? Or is it better for the child to come down to Cape Town if one parent lives down in Cape Town and have contact with the child? Is that a workable solution? If the situation is much less complicated, where the parties live 5-minute drive away from each other, and the father only sees the child maybe every second weekend, but he believes now that the child is maybe 13 years old, 14 years old, you need to spend more time with the child. And the mother is not willing to do that, or the other party is not willing to do that, then I would say that is a time whereby you write a letter, you attach a draft parenting plan, unpacking the whole situation as to what you believe is a workable situation in resolving this matter. I got a question over here on the Zoom chat. It says the following: if you are no longer together, can you make the other party spend time with the child? History is they never see the child. That's a very difficult question, and I will get back to that after I've explained this issue concerning taking the matter to court. Thank you for that. And if anybody else has any further Zoom questions or Facebook Live questions, you are welcome to post them. Okay, so we're dealing with the situation now. They can't come to an agreement, mediation may be failed, as the case may be. A lawyer drafted a parenting plan, a workable document, and he sent it down to the other party. The other party has an option. He or she can obviously now decide, are they going to be reasonable? And they don't have to be reasonable. I don't force anybody to agree to my parenting plan or to agree to what we have to say. There's always a judge in a court of law that can override my decision or my view. Or the other party's view. That's always the case. So you do not have to agree with what we have to say, but you are welcome to give a counter offer. So if my client feels that he wants to have, see the child maybe now every second weekend, and have maybe midweek contact because of the age of the child and the child wants it, and he feels that he can, provide a better, more quality to the child's life by seeing the child more often, and which could be the case. And the other party obviously refuses that. And that is stipulated in the draft parenting plan. The other party will not be wise if he or she just dismisses that parenting plan. The other party would be smart to look at the parenting plan drafted by his or her lawyer, and to either come with a counter parenting plan, number one, or come with some amendments. Stipulating, you want to deal with weekend contact. We did discuss this previously. He did bring it up. but I feel that weekend contact will not work because of X, Y, and Z. Wonderful, that's something we can work toward, we can work with. Now at least I know what the other party's view is. She believes that midweek contact will not work because of the child's schooling, extramural activities, the age of the child. The child might have other siblings, you might not want to break the siblings apart. So, for example, if there are step-brothers, step-sisters involved as well, that's something which the other party can mention and something for us to deal with and to consider with before we jump the gun and say you are being unreasonable. And there might be other issues as well that has to be looked at and which the other party will bring to the table. We will obviously from there onwards, try to maybe chat to the other party and say, maybe we can sit down on a roundtable meeting. Let's sit down, let's try to resolve this matter, amicably. Let us hear more what you have to say. And let my client also hear more what you have to say. And you can hear what our client also wants to say, which is very important. You will note that my entire approach from the start of this webinar is not court, let's litigate. That's what we do. That's what we make, how we make our living. But this is a family law matter. And the way to resolve these matters are not necessarily via litigation. You can actually break up a family, and I believe if a child must be exposed to social workers, counselors, courts, court-appointed lawyers, and so on, violation of the court order, then the mother goes to the police station or the father goes to the domestic violence court, I don't think that's the way a normal household should generally be. The parties at one point, they were in love with each other. They were, in the parents of the child, they were proud of having the child and live together. So when problems arises, does it automatically mean that they should now litigate these matters and third parties should now continuously get involved in the matter? They know the child better than anybody else. And I mentioned in a previous webinar also that why would you want to have a judge or a magistrate that looks at your file for 2 hours or for an hour, or if it's a judge that has a lot of files in front of him and he reads very fast, maybe for 20 minutes. Look at your entire case, listen to arguments by the mother and the father, maybe applies maybe 2-3 hours of his time to it, and make a decision regarding the rest of the child's life and your life. Why leave this whole decision of what should happen to your child and your family in the hands of a third party? That's not necessarily the most wisest thing to do. It's the last resort, yes, of course, because we need some type of normality in this world. So a judge will put down his hammer verbally and he will make an order. But why do that? The judge doesn't know you, the judge doesn't know the child, the judge doesn't know any meeting, and he discusses matter. Yes, the father might disagree fully with the mother might disagree fully with the father, but remember, if people talk, they chat, things changes. That's where the father starts giving away certain things because he now starts believing that the mother is most probably reasonable on that specific point, and the mother starts giving away certain type of rights she might have because the father comes with the logistical and logical answers. And depending upon how old the child is, we can also get what the child's view is. But let's say that doesn't work as well. And if it does work, wonderful. We enter into a parenting plan, we take it to court and we finalize the matter. But let's say that does not work as well. The mediation didn't work, letters doesn't work, the roundtable didn't work, unfortunately. Then the question is, what is the next step? In my specific view, it would be the next step would unfortunately have to be court. This is now where the parties will have a third party to adjudicate this matter. Now the challenge you have is, if the parties do not want to go for mediation, they don't want to sit together, on the same table and so on, the judge will have to make a decision. But let's go further. Let's try to deal with the topic properly. And the topic for today is, if I may quote it, Child Custody Disputes and Battles, Part 2, How Do I Get the Best Out of My Case? If you are watching this video, please share it on Facebook. It will be greatly appreciated. So how do I get the best out of my case? So we dealt with it so far, getting the best out of a case until the date of the roundtable meeting. That failed. Now you need to make an application to court. And I'll deal today with the scenario of making an application in the High Court as opposed to the Children's Court that we can leave for another day. In your application, you have to be very reasonable. You need to explain to the court in your affidavit, why do you now want to have additional contact? Why do you want to have maybe contact in the first place? Why would you like to have shared custody of a child, as the case may be? You basically stipulating whatever you would have told the court under oath should have been in the, should have met with the judge in court. You're now basically stipulating it in an affidavit, in a piece of document. Now, how do you do that? Are you going to spend the entire, let's say, I like telling clients, you got 40 pages. The first 2 pages deal with who is who in the zoo. And then you got the balance of the documentation to make your case. If you were to spend 20 of that pages bad-mouthing the other party, saying every possible bad thing you know about the other party, if you already do that, you have full right to do that, then I'm saying you're wasting your money and you're wasting your time. You should spend the balance of that documentation, that paperwork. No, explain to the court logically, I would like to have more contact with my child. These are the reasons why I would like to have more contact with my child. Before that, you deal with a bit of background. And so you can logically explain to the court that I'm not being vindictive. I'm not trying to take any of the rights away from any parents, but I've analyzed this matter, and these are the reasons why I believe it is in the child's best interest for me to have contact to the child X, Y, and Z. That needs to be unpacked. The court doesn't want to hear about the problems you had with a mother in the past, if somebody had an affair, if somebody was rude to you, in-laws, and so on. It's interesting to read. I'll be honest with you, I find it very interesting. But at the end of the day, when I go through the documentation of my opposing counsel, my opposing party, and I find out where are we dealing with the crux of this matter. And my life becomes very easy as opposing counsel is because I can basically ignore all that stuff that happened before the marriage, before the breakdown. Unless it's specifically pertinent and relevant. We're dealing with stuff like, example, drug abuse, neglect, and so on. But if it's the normal ranting, talking bad about the other party, I can basically ignore it. It's irrelevant. And if you look at the crux of the other party's 20 pages or 40 pages, only 5 or 6 paragraphs are relevant to the case. What does it leave me with? It gives me the opportunity to deal with their 5-6 paragraphs that they dealt with that's relevant to the case, and it gives me additional, let's say, 19 more pages of explaining to the court why my version of this case is more relevant and why I should be successful in my case, whatever the case may be. So, how to get the best out of my case? Firstly, don't waste your time and energy on ranting, on talking bad about the other party. There are countless amounts of consultation I had in my office, and the clients pay a lot of money for that consultation. And generally, those specific clients, in the first 2 hours, of the consultations, the client will always try to bring about or badmouth the other party. I don't know if it's the nature of how people are. At the same time, if I get phone calls, people contact me, for some advice or don't know what our service, etc. We advise them about that, but they can't stop the phone call. They need to continue and speak more badly about the other party. And it exhausts me because I got stuff to do and I know where it's going to. So please, if you are dealing with a child custody matter, focus on the facts, focus on what is relevant. I will now deal with a question that we had via the Zoom webinar, and I see there is a question coming in from the Facebook Live. Let me get to that quickly. It says the following: if you are no longer together, can you make the other party spend time with the child? History is they never see the child at all. It's a very difficult question because if a party doesn't want to see, if a parent does not want to spend time with the child, how do you force that parent to love that child? I, for one, have not yet seen any court law, or as the case may be, that forces someone to have contact with a child, to spend time with a child and to love the child. And that's something very concerning to me. You can force somebody to pay child maintenance, you can force someone to return the child because you're enforcing your rights to have contact with the child. Or you can make an application to court for you to now obviously enforce your rights. But I never saw an application, or I never done an application whereby we asking the court to force the other parent to love the child and to want to spend time with the child, to have contact with the child. And it's very dangerous because what if the other party now spends time with the child and he neglects the child? Or the other party wants nothing to do with the child, and now you force the child to have contact with him or her, and he just is rude to the child, he's cold with the child, or she's cold with the child, as the case may be. And you want to avoid that. So unfortunately, you can't do much about that. You need to take it upon yourself. I'm the primary caregiver of the child. The other party does not want to be involved with the child's life. That party has an obligation, of course, to maintain the child, take him on maintenance, take her on maintenance. But forcing that person to love the child, unfortunately, we can't do that. I think the law must develop and deal with those scenarios. Then we got another question, and the person says, apologies for going off the topic. This is on Facebook Live. What constitutes an unfit parent? Example, would leaving 2 young children alone at home for 30 minutes to drop off a stranger at 4 a.m. in the morning be seen as unfit, especially if the person is not known to the mother or the children. So for argument's sake, there's a stranger in your home and you leave the house at 4 a.m. to drop the child. You know, it's difficult to say, is that unfit parent, and does that automatically mean that the person must have less parental rights and responsibilities over the child? And at the same time, does it mean that the other party should now by default, irrespective of investigating whether or not that parent can look after the child, automatically be the primary caregiver of the child? It's difficult to make that jump. Obviously, it sounds irresponsible. I don't know what the other circumstances are. I cannot say it's an unfit parent. We don't know the circumstances, the reasons for doing that, and were the children being safe, were they being placed in neglect, as the case may be. So, for me, as a legal practitioner, as an advocate, to say yes or no will be irresponsible upon me. But at the same time, I would say a person that could possibly answer such a question would be a social worker. Maybe speak to a social worker, speak to somebody that deals with childcare issues, and they can and give them more information, telling them the children are 5 years old, 2 years old, if that is the case. It's 4 o'clock in the morning, there are strangers around, it's very dangerous, X, Y, and Z, and find out whether or not that person was being reasonable under the circumstances. If the kids are most probably, 17 years old, 16 years old, they're quite old, and the mother had to go quickly out at 4 o'clock in the morning to drop somebody out, and it's a very safe neighborhood, they have WhatsApp, they have phone call, they have phones, and so on. Obviously, the situation will be different. If it's a newborn child, a very young child, and the mothers leave the child to take the child away, that could be looked at differently. So I would say I cannot give my comment yes or no. It's a bit unfair upon me, but at the same time, the person said thank you for my answer. But at the same time, I would advise speak to a social worker, and maybe they can advise you on that specific issue. So I think we dealt now with both issues, both questions. If there are any other questions, we've got about 10 minutes left for this webinar. I'll be happy to answer it on the Facebook Live or on the Zoom webinar questions. So moving on. So you file your application, you stipulate all that's relevant. So you say, I would like to have contact with a child from Monday to Thursday after school. And in your affidavit, you give the reasons why, logically outlaid, beautifully put out. It will make the other party's life very difficult to argue against it. And if they do it, that's great. You need to give the court all the relevant information for the court to work with it. I always tell my clients, you might come to me with your version. I'll put my best foot forward. I will do as best I can to properly outline to justice your case in my documentation. I still need to hear what the other party has to say. And the judge will ultimately make a decision. If you've done that, and that specific documentation goes to court, then you are in the best position to get the best possible results out of your case. It's like this. Courts, and I work with a 40-page rule. That's in my personal practice, whereby my affidavits I draft for my clients are generally maximum between 20 pages and 40 pages of data. I think that's also what judges can most probably quickly scan through and make a decision on, for child custody matters specifically. Obviously, depends on the case. And then obviously there'll be some annexures attached to it, like birth certificates, letters from schools, from social workers, and so on. If there's abuse, there'll be some pictures applicable, as the case may be. Obviously, some lawyers will draft long, voluminous documentation, and you don't know what's happening over here. It's a same rhyme. There's no logic. There's no structure behind it. So if domestic violence is an issue, you say there's domestic violence. This is the history of the domestic violence. These are the most recent events on domestic violence. You conclude on it. Next issue, non-compliance with maintenance orders. It's not really very important regarding child custody matters, but it's something that could be relevant and pertinent. You deal with it. Court made a maintenance order. He does not pay. Let's move on to the next point, and so on. So that's how you outline your specific information. So if you do that, you're in the best position. If you focus on ranting and bad-mouthing the other party, you won't be in a good position. We have another question. Let me get to that quickly. This is on child maintenance, but I will deal with it because the person asked. The court ruled the other party earns double the salary to only financially contribute 40% of the child's needs. How do I dispute that? If a person earns double your salary, the question is, what is that specific person's expenditure as well? So regarding child maintenance, I know it's off the topic, but I think I will deal with it because the person is in our Zoom webinar and there are no other questions. I might earn 10,000 rand, the other party might earn 10,000 rand per month, but I have more expenditure because I must buy, shirts, I must buy work stuff because that's part of my attire for work, I must buy a bib, I go to court, as the case may be. So my money the money that I've left, the net income is much less. With the other parent, he or she might earn the same amount of money as me, however, has less expenses. He works for a boss, pays for all the expenditure at work, get the clothing allowance, and as the case may be. So his or her net income will obviously be much more to use. So that's what we look at. We don't necessarily look at the gross income. We look at the net income. So it's possible that a party can earn much more than you, but pay the same amount of maintenance as you, or earn the same amount of salary as you earn, but pay less maintenance because of the amount of expenditure that specific person has in order to maintain him or herself. Or for example, if a parent has a medical condition and needs to spend a lot of money on medication, that specific parent obviously at the same time can say, I earn the same amount of money like the other parent, but I have a lot of expenditure, my medical condition, and so on. Or I have to drive further to work, as the case may be. So it is possible. We had a question also on one of our registrants when they registered for this webinar. I said, yeah, I think that is exactly the same question. So sorry, my apologies for not answering that early on, that specific person. So concluding on this topic, how do I deal with my matter? My advice to anybody is watching this video, be pragmatical, be logical, step back from the situation. Don't deal with these type of matters from an emotive point of view. Yes, of course, it's extremely emotional. I mean, I have people coming to my office crying, on the phone crying, because it's emotional, it's their children. That is a factual thing. But we want to be successful in our case. So in order for us to be successful in our case, we need to be logical and pragmatical. There's no other way. I can't see any other way of doing that. Thank you very much for watching this webinar. There are no questions for the Zoom questions. There are no further Facebook Live questions. And we hope to see you at our next webinar dealing with this topic. It will be Child Custody Disputes and Battles Part 2. How do I get the best? Sorry, it will be Part 3. How do I get the best out of my case? Thank you very much. Welcome to the live Q&A on the Advocate Mohammed Abduroaf Facebook page, a platform where we try to answer and engage with you, but specifically answer questions regarding problems that you may face regarding child custody and child maintenance. We had many webinars in the past dealing with those specific topics. We feel it important to advise people and to inform people of their rights, and at the same time to empower you so that you can handle your specific child custody and child maintenance issues as easily and as stress-free as possible. Okay, the questions are coming in. Thank you for that. Please pose some more questions. And I see we have somebody from Somerset West. Welcome. Today's theme would be something which I've been thinking about for some time, and I do not really have a word to, a word to specifically not describe it, but to put it under. Basically, the phrase is toughen up. And the reason why I'm saying so is that having thought about the amount of people I have been advising for the last few months, only for the last few months, and how they have been responding to the specific problems regarding child custody and child maintenance, it seems to me that they have to toughen up a bit with respect. And this is a prelude to the conversation. I'm not referring to you. The persons that I'm referring to might not be watching this video. They may be somewhere else, but those are my experiences. And having thought about it, I've come to the conclusion that many cases, especially regarding child custody and child maintenance, are not successful for the client, or they do not receive the required desired outcomes, is solely because they are not toughing up. It's a silly phrase I'm using, and that will be the theme for the next few webinars. You need to toughen up. You need to look past the fact that you have been manipulated by the other party with respect to everyone. I'm not referring to any specific gender here. It could be the male that must toughen up. It could be the female that must toughen up. But you need to toughen up, and you need to take control and ownership over your case. Just some random advice to you. Because if you do not do that, you will have to compare yourself to someone that has toughened up, and who will get a better result? The party that is very anxious about his case, that does not want to proceed in fighting for his or her rights because he or she may believe that he or she may be successful. He or she does not want to proceed with his or her case and fight for his or her rights because they are afraid of the other party. They have been victims of domestic violence, gender-based violence throughout their relationship. Toughen up. It's easy for me to say, I know, but you need to do that. So that's just a buzzword for you to hold at the back of your mind when dealing with your matters. And I'll try to think of a theme, or maybe have a webinar specifically to deal with that. The same with me as a legal practitioner. I'm luckily for me, I have many years of experience going for 2 decades on child custody and family law and other legal matters. But if my attitude was, when I represent a client and I know there's a more senior advocate or an attorney, or there may be a senior judge who, in front of whom I'm appearing, who is giving me a hard time, I have 2 options. I can either fold. I can tell my client, you know, I'm not put out for this case. I can walk away, let someone else do the case. Or I can toughen up as an advocate, take the punches, give the punches, and give the best I can for my specific client. And that is what you must do. So today's theme, and for the next few webinars, will be toughen up and fight for your rights. We have someone from Cape Town as well. Welcome. Thank you for that. Let's deal with the first question. I was given an order by the court for maintenance. Father didn't appear, an attorney agreed on his behalf. He now refuses to accept and sign the order. What do I do? Now, it's a difficult thing because an order is an order, full stop. And the moment a party, you know, has knowledge of the order, he or she is obliged to adhere to it. The difficult thing what I mean is, it's difficult because the other party is now refusing to accept responsibility in terms of this order, although his or her attorney has agreed to that order on behalf of the client. Then you have to follow the maintenance laws. The maintenance laws specifically stipulate that if a party is not adhering to a maintenance order, it is a criminal offense, and you can have the person, you know, prosecuted for that. And you can go to prison for up to 3 years. Therefore, my advice to the specific commenter is go to the maintenance court, lay a complaint. If the person is working for a boss, you can apply for a garnish order. If the person has certain assets, depending upon the amount, you can have those specific assets attached. So, for example, if the person owes you 100,000 Rand and does not want to pay, it makes more sense to go to the maintenance court and ask for an order to attach his or her car or house, whatever the case may be. I hope that answers that. If you want to add to the comment, feel free to do so. I see the next comment says the following: agree. You have to drive this whole process and be in charge. And I think that goes with the whole issue concerning toughen up. If you do not take ownership of your case, the same way if you're studying for an exam, if you're studying for a degree, a qualification, a diploma, it is up to you to toughen up. You do not understand the work. The work is hard. The lecturer is giving you a hard time. You cannot find the specific relevant material online or in going to the university. or to the college, wherever the case may be. You need to toughen up, and start fighting. The same way if you want to lose weight. At the first sign of defeat, what do? You go to the restaurant to buy food. No, toughen up and lose those pounds. The comment of earlier on added something else. He says the following: easy to say when you are dealing with someone who refuses to abide to the law, and the maintenance officers let them get away with their behavior. Been dealing with this issue for 2 years, and now that I thought the matter was over, the father pulls a tactic and now refuses to sign documents. How much tougher do I get? I cannot take it any further. It's very unfortunate where the maintenance courts and the maintenance systems, how can I say, disappoints you. And it shouldn't be the case. I do not know how to respond to that specific question. It's clearly you had a difficult situation where the situation failed you, but I think there are more resources available. It doesn't end there. If he doesn't want to sign, the law doesn't say you must sign. So if an order gets served upon you, you must not, the law doesn't say that the person must sign acceptance therefore. There is no law that says that. The same way, if someone issues a summons against you and you refuse to sign the summons, all that the sheriff will have to do is say, I attempted to serve it upon him, he did not want to receive a service, and I place it on his door. I put it somewhere so that he can see it. That is it. So the same applies to the maintenance order. You do not have to sign for it. The sheriff will make sure that he gets it. Tell him, sir, you do not want to sign for it, that's fine, but here it is, put it down and walk away. The commenter goes further. And I'm very happy to receive these comments, and feel free to add as much as possible. His attorney is now playing the game and saying that they are waiting on direction from their client. Those are most probably usual attorney tactics, and the attorney knows how to play the game. I would say go to the maintenance court. That makes more sense to me. The maintenance court will have to deal with this matter. Was the maintenance court being conned? Has attorney really had the necessary authority to sign that agreement? Lay a complaint against this attorney if you need to be. If he says, no, I did not have the necessary consent, so you wasted your time, the maintenance court's time, the child's time, and lay a complaint at the Legal Practice Council. The old term was a law society. Do that, but go to the maintenance court and try to resolve this matter. And I think the laws, yes. I'm just finding out where are the comments coming from, connecting it to the relevant client. Okay, I have a new comment over here. My son's father was ordered by court to pay maintenance arrears, which he only paid 3,000 Rand, worth 600 Rand outstanding. Just after he got paid, he was dismissed from work due to drugs. He was told to come back when he is drug-free. What will the court do? If somebody is unemployed and the person owes you money, arrear maintenance money, that arrear maintenance money stays, it remains. It doesn't go away. Obviously, I would advise you to go to the court and explain the situation to them. If the person has assets, those specific assets must be sold, but it seems to me that specific person does not have any of those specific assets. So the real amount remains. And if the person is not paying any maintenance, despite him being unemployed, and he never made an application to the maintenance court to have the maintenance order varied or set aside, the arrears are just escalating and climbing. There seems to be nothing much you can do at this present moment because he has been dismissed based upon drug use, and he can only come back to work once he is drug-free, and that is most probably when he will start earning an income again. So where the father is concerned, it seems to me that's a bit of a waste of energy, but he may have parents who can afford to pay the maintenance on his behalf, and you may want to inquire into that as well. So my advice to you is, go to the maintenance court, explain to them the situation. They might be able to assist you in obtaining that specific money. The employer might owe you money. There might be something which you can do with regard to the employer. There might be other assets applicable that you can attach and make use of. But I would say go to the maintenance court and they will be able to assist you and advise you better on the specific issue. Let me connect the commenters. Okay, we have another comment. father has played his normal game. The father has played his normal game, has now become unemployed in order not to pay his maintenance. So now it is going back to court for review. He has sold all assets to avoid paying maintenance. Do I fight the grandparents now? If the father doesn't have any income and is unable to maintain the minor child, and those are legitimate reasons, then I would say go to the grandparents. That's the long and short of that. I cannot explain it any further because the child needs to eat and the father is not willing to do his part. The maintenance court obviously have to be reasonable. They'll have to determine, is it fair to go to the grandparents at a specific point? But however, if money cannot be taken from the father and the child needs to eat, the child needs clothing, obviously the maintenance court would be the proper forum to approach the grandparents on your behalf. Here we have another question. It goes as follows. I have been fighting my case for 2 years in the criminal court without a lawyer. The other party have a lawyer and abuse the system and delay. But now the NPA is on the case. If he is found guilty, what will the next step be if he doesn't accept the judgment? Can he appeal again and take it to the higher court? So let me explain quickly how does the maintenance criminal court work. There's no criminal maintenance court. It's a normal criminal court. If somebody does not adhere to a maintenance order, he or she is committing a criminal offense, and a criminal complaint can be laid at court with the prosecutor. The prosecutor will look at it and he will decide to prosecute you for non-compliance with the maintenance order. You will not have a lawyer? Of course not, because you will be a witness. He will have a lawyer to defend him. That's how it works. Same way, if you assault somebody at the criminal courts, the prosecutor will prosecute you, the accused person or the perpetrator. The person who is on the witness stand who has been assaulted, he or she will not have a lawyer. His or her lawyer basically will be the prosecutor, if for lack of a better way of stating it, because he will be the prosecutor's witness. Then they go on, but now the NPA is on the case. So it's possible to delay a criminal maintenance matter. Let's say you appear in court the first time, you say, I would like to get a lawyer on board. The lawyer is only available in a month's time. A month come later, you come to court, the lawyer says, hey, I require the following documentation in order for me to know what's happening in this case. Gets postponed for another 2 months, and it can go on and on. Then the matter gets postponed for hearing, for trial. It gets postponed for plea and trial. On that specific date, the lawyer said, I'm not ready, something came about. So it can go on and on. However, at some point, the matter must proceed. The magistrate will get annoyed, exhausted, and at some point, you have to plea, and the matter must run. If the party is found guilty, as the questioner poses, and he does not accept the decision of the magistrate, he can appeal it, obviously, and is allowed to take it to the High Court. If you are unhappy with the decision of a magistrate's court, you have full right to appeal it. You must explain to the higher court, in this case the High Court, that the magistrate's court made an error. The evidence before it did not justify a decision of guilt on your part. So you're welcome to do that. The committee goes further, and I have an increased application in, but it cannot be heard until the criminal matter is finalized. And in the meantime, my expenses increases, but not the contribution from the other party. It's like there isn't much relief in the interim. The person goes further. Before I comment further, this is the last comment. We now go into trial on the 26th of March. I presume that's for the criminal case. The difficulty with maintenance matters and custody matters and any legal matter as such, if the other party does not want to come to the table, he or she can make life very difficult for you. The same way, if someone owes me money, I borrowed somebody 100 Rand, and he does not want to pay it. He does not want to pay it. And I take him to court. He makes life very difficult in order for me to enforce my rights. The same applies for maintenance. If the specific person understands the system and understands that how can we deal with an application for an increase in maintenance if I'm already in arrears with my previous maintenance order because I now specifically stipulated that I cannot afford it, and that's my defense, that I could not have afforded it in the first place. How can there be a parallel hearing of the matter whereby the maintenance court will have to deal with the application for an increase, but at the same time there is an application pending in the criminal courts where the father says he cannot afford it? It makes logical sense for the courts to deal with one matter at a time. Sometimes a party can take advantage of that. Sometimes the court will make a different decision. The court will say, the criminal matter can pend because we're dealing with an old issue, but now circumstances have changed. The father is now saying he can afford the maintenance, but now the issue is concerning affordability based upon what the mother wants. But the criminal inquiry for non-compliance deals with something that happened a year ago. We did not pay for a few months, whatever the case may be. But my understanding is that the maintenance courts do not prosecute. Obviously, I'm speaking under correction here. Not all maintenance courts might follow this, but they do not prosecute you for non-compliance of maintenance if you pay the arrear maintenance immediately. So let's say somebody never paid for a year. They issue summons, you call to the maintenance court, you pay their arrears, they move on with their lives. So in answering this questioner's question, and the trial being the 26th of March, see what happens in the criminal matter. A lot of information can come from the criminal inquiry because he will have to explain now all the circumstances. You will come on the witness stand, you will explain there was a maintenance order put in place. The maintenance order stipulated the following amounts will have to be paid. You would explain that he did not pay those specific amounts and so on, and is in arrears for so much. He will come on the witness stand in his defense, and he will explain that he could not have afforded, whatever the case may be. Once that matter is finalized, the court might find him guilty, the court might find him innocent, but then the court can properly deal with the application for an increase. The best person to discuss this with would be with the court prosecutor, because they prosecute these type of matters, or the maintenance officer. Each court is different. Each criminal court has a different policy. It could be that a court might have an experience whereby if each time they prosecute these type of maintenance matters and the father starts paying the maintenance or the mothers pay the maintenance immediately after they've issued summons, it works. So that's a policy. So they do not proceed. Alternatively, they could have had a problem in the past where they run these type of matters parallel. It just causes much more problems and much more difficulty. Because now we are dealing with inquiry in a civil setting, in a maintenance court setting for an increase. But in the criminal court, evidence is being laid out based upon the fact that the father could not have afforded in the first place. So we have this parallel situation which might not be in the best interest of justice. But also, finality of matters are very important. I would say the courts must be very fast and quick in dealing with these type of matters, and the sooner they can resolve it, the sooner the child's best interest can be upheld. Okay, I hope that answers that specific question. And the commenter made one final comment. She says as follows: affordability is not the defense, or rather, lack of funds is not the defense. Funds are plenty. Then it seems to me that he will be found guilty of that specific offense of non-compliance. And if they find him guilty because he could have afforded, then there's no reason why the application for an increase cannot be completed. And having said that, if affordability is not an issue and there is money available, then the maintenance court must start putting on the gloves and start fighting for you, and then they have to attach these specific funds or whatever money is, get a garnish order in place. The person said, thank you, you are welcome. If you have any other questions, and all the commenters that post comments early on, all 17 comments, you are welcome to pose additional questions and I'll try my best to answer it. If you are joining this video, please feel free to mention where you're from. We are from Cape Town. We have someone else, let me see now, from Somerset West. If you're anywhere out of Cape Town, somewhere north, Joburg, Eastern Cape, and so on, please feel free to leave a comment or say hi. I'll be keeping a close eye on the screen. Sometimes I have to first analyze the wording because people type on their phones, and I do not want to speak gibberish here. I don't blame you for typing from your phones. How else can you do it? And that's why sometimes I take a bit longer to read it out. And also I strain my eyes to look into the screen. Oh, we have somebody from Roodepoort. Thank you. That's very nice to hear. It's nice to know where people are coming from. Thank you for that. Going back to today's topic and the theme of toughening up. Why do I say so? Why do I say so? Why do I say that you need to toughen up? And I'm not referring to you, please. I'm not referring to you. I'm trying to give a message out to people, and I cannot see it being a negative message. It can only help you in fighting for your rights and for that of your child. People are of the view, when I come with answers, when I come with suggestions, they always come with counter suggestions and counter answers that exhaust me a bit. They'll ask me the question, advocate, the father is not paying child maintenance, what can I do? I say the law expects you to approach the maintenance court. Advocate, if I go to the maintenance court, I know he says he can't afford it. There is it. He's not toughening up. Advocate, when I go to the maintenance court, I know the court will find in his favor because the father is charming. They're not working with you. You need to work with the lawyers. You need to work with the system. Advocate, when I tell them, you need to approach a maintenance court. Advocate, I do not have the time. Advocate, this is a lot of work for me to do. We will have time to complete all this income and expenditure. We will have the time to make photocopies. We will get the money to make the photocopies. Whereby clients obtain this very good advice on how to deal with the matter. So we're stuck there. I cannot deal with the issue concerning how the tactics I can advise her or him on how to win the maintenance court case. What ideas I have, what strategies I have. I cannot deal with that because I'm still dealing with this preliminary issue about going to the maintenance court, because every time I mention we're going to the maintenance court and fight the matter out there and battle it out for the client, with putting on our boxing gloves and our brains and so on, I get an answer that is, becomes a bit challenging, a negative answer. We must have the time for this. I do not know how to use Excel. I do not know how to use a computer. I never went to university to learn how to use a computer. Oh, the maintenance court. I live in Cape Town, but the maintenance court that I must go to is like there. When will I have time? I must take time off work. And then the end of the day is, why did you come to my office? They came to my office for the sole reason thinking I can make one phone call and get the father to pay the child maintenance. You need to be smart. And many times the attitude, or maybe the theme which I have to apply to that specific scenario would be take ownership of your case. That's it, maybe. Okay, a lot of comments are coming in, and I do not want to lose any of them. We have now 26 comments that came in. Let's see what's happening here. Okay, Roodepoort, welcome. The other commenter regarding the money being hidden away. I am in Somerset West. Awesome. What if the father is hiding his money in another account? The maintenance court, if you should do a bit of research, because we cannot look at every possible account, and that's a great possibility that he's doing that. It also might not be true. Maybe he's not also doing so. So you need to find specific links to assist you as to how you can potentially verify that he is hiding the money in a different account. And once you've identified that specific account, then you can approach the court for a subpoena to the bank to disclose that specific account. Okay. Or his family's account. So you need to identify that specific account. Once you know it is, you can take it further. I have another comment. It says, where is he hiding it? Transferred to his mother. I think that's an internal conversation, which is fine. You need to be your own investigator and help the court as much as possible. I agree with that comment over there. You need to take ownership of your case. Thank you for that. Thanks, will try my best. You are welcome and do so. Magic only happens if you put the effort into it. Magic doesn't happen on its own. People learn to do wonderful things out there. Lose weight, surf, mountain climbing, abseiling, fly an aeroplane, because they make an effort. It's magic, but they made an effort. Same way with winning your child custody or child maintenance case. You put in the effort, you will win. The question here asks, can they summons her bank account? Yes, they can. You need to know what the bank account is and what the relevance of the matter is, and they can summons it. They can subpoena, put it that way, they can subpoena the bank for the bank statements. Another comment over here, you need to be on the court's case all the time. Yes, you need to hassle them. The more you hassle them, the more the time they get from you, of you, and they will try to expedite your specific case. Okay, comment yes. Thanks for the advice. You are welcome. We have another comment over here from someone else. Good day. Firstly, thank you for all your advice. You are welcome anytime. The short, my ex is taking me to court for the second time for a decrease, still outstanding from the first time. We're due for court on Monday. My question is, can I sue his parents as well? He does not have the respect for the system. After the first time, he's still going on and doing his own thing. Yes, you can subpoena the parents. However, the court must first be, in my view, satisfied that there is no case against the father. If there is no case against the father, the children cost X amount of money, fine. But at the end of the day, the father and the mother together cannot come up with that specific money. Now we need to look at the higher tier, the grandparents. Then you can do so. My advice to you is speak to the maintenance court. Each court might have their own way of dealing with these type of matters on how to claim maintenance from grandparents. Do they do an inquiry the first time, or do they call the grandparents in all of a sudden? You need to determine from them how it works in your specific court. And once you know that, you A4 away. But they'll be able to advise you on that. I hope that answers your specific question, and you're welcome to add additional comments. I have an additional comment. Going to the maintenance court, he made me become a dragon and a bulldog. Wonderful. Many people want to employ a dragon and a bulldog as a lawyer. If you can be your own one, obviously, with a lot of knowledge, I advise you, the sharper the sword, and how do you sharpen a sword? With a lot of knowledge. But you need to put a bit of energy also, so the sword can be super sharp. It won't melt through the meat or the whatever you're doing with a sword. If you're into cooking, you need to put a bit of muscle. So that's where the toughening up comes in. So know the law, that's the sharpness of the sword, but put a bit of energy in and toughen up a bit. The commenter earlier on says, thank you, you are welcome. Thank you for partaking in this webinar. And we got about 4 or 5 minutes left. I need to be offline by 11. Today is quite a busy one. We're having one again tomorrow morning. If you're watching this webinar, I'll be posting the time later today still. But tomorrow around this time, I will be online again to answer whatever additional questions you may have. Someone is replying to a previous commenter. That's fine. I'll say what they're saying. The court investigator picked up my ex-secret bank account via his medical aid record. There's always ways and means. I agree with you 100%. You need to act like a investigator. You watch CSI, you watch all those cool movies. There is a bit of logic behind that. Look through things. Use a highlighter. Highlighters are very good. So you highlight things, Pencil marks. Later on, you might, this specific name or this reference number came up before. Let me go back there, and start working things out. Another comment. I have been in court for more than 2 years, 4 years, and current maintenance. A year ago, an agreement was made in the mediation in criminal court. Since then, no payment was made on the arrears, the current maintenance. That's a concern. I went back to court to let them know, and they will summons him back in March. What is expected at the hearing, seeing that I'm asked to be there? I would imagine it's a criminal matter that's being heard now, so they're subpoenaing him, and he needs to explain his specific circumstances. And if it's not the satisfactory circumstances, then of course they will maybe proceed with a criminal case again. So it seems to me the criminal matter was mediated and the charges were withdrawn and the parties came to an agreement. He did not comply with that agreement. The criminal matter will have to proceed again. That's my view. I hope that makes sense. But at the end of the day is, after they've consulted with him, they will have to advise you and inform you of what has happened, and also verify with you whether or not you are happy with that specific decision. The commenter says, thank you for your advice. You are welcome. Another comment, thank you for your continued guidance. We have Farida Williams, an attorney. You are welcome for that. And a final comment, and I'll cut it short here. Think I need to employ you to help me with going after the grandparents. I am happy to advise, and I'm certain you are competent enough, but when it comes to child maintenance, it's something very passionate. I'm very passionate about it because it deals with the food for the child, the clothing, and the amenities for the child's life. It's not like fighting for a client for other issues. Here we're dealing with money that must be paid, and I'm very angry if a parent does not pay an adequate amount. If the adequate amount which you can afford is 50 Rand per month, then that's fair because you worked hard and you pay the 50 Rand, and that's fine. But if somebody does not want to pay child maintenance, that is very disappointing. Please, if you're watching this video, please share this video. Other people might find it very useful. We're online for 34 minutes now. We had 36 comments. Thank you very much for that. I have another webinar now at 11 o'clock. I hope you enjoyed this video. I'll see you tomorrow online again. Please type out your questions before the time so you can just copy and paste it and put it on the screen. Have a lovely day, and I'll see you tomorrow online. Thank you for all your participation. Good morning. Welcome again to our live webinar. Topic today, child custody, child maintenance, and divorce. If you are joining us, feel free to pose a question on the Advocate Mohammed Abduroaf Facebook page. It should be above me. Nonetheless, I'll be discussing this topic, and hopefully we can learn from it. And maybe if you pose a question, I can learn from your problems, whatever issues you may have, and hopefully try to assist you in resolving it. If you are watching this video later on, other than 11:30 today, please note that I would not be able to answer those questions. We do not follow back on previous videos. We only do live answering. Nonetheless, if you have a question, please write it down somewhere, and the next time we go online, you may just paste it onto the question section, and I will deal with that. Nonetheless, let us begin. Today's topic, child custody, child maintenance, and divorce. They all are in some way intertwined, depending upon your circumstances. If you are getting divorced, of course, if there are minor children involved, child custody issues will have to be dealt with, child maintenance issues will have to be dealt with. If there are no minor children involved, the only topic to be discussed would be the divorce issue regarding the breakdown of the marriage. If you are not married to someone, the possibility of there being custody issues is there, child maintenance issues as well, so that would obviously be applicable to you. Then we're only dealing with point 1 and point 2, child custody and maintenance. And that's it basically. So let us begin with child custody. First and foremost, let's deal with the issue concerning parental rights and responsibilities. That is the starting point. I consult a lot with parents, mothers and fathers. They come to us for legal advice. Many times they cannot afford legal representation. However, they require some advice to get the ball rolling, to kickstart the process. And the process would obviously take place in the maintenance courts, in the family courts, being the children's court. It may even be in the divorce court. However, they require some type of advice, and I would call it basically some type of motivation to take the matter to court, whether or not you are the mother or the father. If you are the mother and you're the primary caregiver, you might require some, guidance or some type of talk advising you on taking the matter to the maintenance court. The father might say, "Mom, should you take me to the maintenance court, you will get nothing. You won't see a cent." I do not take note of those type of comments. I still advise you to go to the maintenance court. Let the court sort him out, and hopefully you'll get the maintenance which you require. If you are a father and you come to me and you say, "Advocate, the mother does not want me to see the child. Do I have any rights to see the child? For the last 2 years, I've just seen the child once a month for 5 minutes because that's all the mother gave to me." I believe that because I'm a father and I am not married to the mother, I do not have any rights, which is all, for lack of a better way of saying it, nonsense. Parents have parental rights. The child has a right to have care and contact with both parents, mother and father, whether or not you are married or not to the other party. We focus on what is best for the minor child, and of course, if it is not in the minor child's best interest to have contact with the father or the mother, then that is it. That should be implemented and be enforced. However, I believe that a child needs and has a right to say, I am 10 years old, and you know what, for the last 10 years, despite my parents not being married or not being together, I had a father in my life. That's very important. The same way where someone will say, I had an education, I went to school, and 12 years later, 13 years later, the person can say, I went to school. 18 years later, 21 years later, I can say I went to university. Whatever the facts are, the same way I can say I had a father in my life. Despite the relationship between the parties, the child and the father might not be the best, but you can say that it fulfills that part of the child's life. And the same with the mother. The child can say, I had a mother in my life, despite my parents having issues. So regarding child custody, parental rights, parents have rights. The moment you are a parent, in my view, automatically you should have a right to exercise some type of responsibilities and rights over your minor child. If you as a father, for argument's sake, decide you do not want to, that's unfortunate for you. I would say it's very sad, but nonetheless, it happens in practice. And what does the law say? If you made a mother pregnant and you went missing after that, you do not have any rights of guardianship, care and contact rights. You can acquire, of course, if you start getting involved in a minor child's life. But nonetheless, we're not dealing with that specific topic. On child maintenance, please remember, before I start this webinar and before people start posing questions, child maintenance applies to the child. The maintenance goes to the child. So we're not dealing with maintenance in general. We're dealing with child maintenance. Although the parent, for argument's sake, the father pays the maintenance to the mother, the money must be used for the child and not for the mother per se, unless there's a specific order stipulating that the mother is entitled to that specific child maintenance, etc. Regarding divorce, of course, a requirement for parties to get divorced is that the marriage has broken down. There is no way the marriage can be saved. Therefore, if the parties have been separated, they no longer communicate with each other, they don't love each other, one party maybe moved on with his or her life, they live in separate homes, the marriage is obviously, in my view, you can obviously argue that the marriage has broken down. There's no room for reconciliation. Both parties has moved on, or they had enough. For years, they've been reconciling and coming back together. There's been arguments, maybe abuse, I do not know. But whatever the facts are, they cannot save their marriage, and they try their best. Under those circumstances, unfortunately, the marriage would have to be dissolved. But if there are minor children involved, we'll have to deal with the issue concerning child custody, child maintenance. And of course, in a divorce matter, we'll deal with the propriety consequences, and I'll deal with that a bit later. As to the issue concerning whether or not the parties were married in community property or out of community property, and so on. There are some questions coming in, and I shall deal with those questions in a bit, but please feel free to pose those questions and I will deal with that. I will pose a question so long so I can remember to deal with that. Live question 1. And that's it. If you have a question, feel free to pose it and I will deal with it a bit later on. So that's the first question. I will definitely deal with that. Okay, the starting block from child custody. As mentioned early on, if people have a child, issue of child custody obviously comes to the table. The point in which a lawyer gets involved in a child custody matter is not when the parties are together, married, living in the same home together. That's not where the point when lawyers get on board, the courts get on board, etc. The point when they get on board is when there are issues involved, and 99% of the time, or 99.9% of the time, when the parties are separated, they live in separate homes, or they always live in separate homes. Mother fell pregnant, had a child, parties are still separated, and there are obviously issues involved. So that's a starting point. There has to be some type of problems involved. So what does the law say? Of course, there are many situations and many scenarios that is applicable, but the law does not want you to come to court immediately. If there is a dispute, if the mother is not allowing the father contact or to see the child, or the father can see the child but only on the mother's terms, or the father can see the minor child for a limited period of time, etc. Or the father feels, you know what, I would like to have the minor child live with me primarily, and the mother can have contact with the minor child every second weekend, or half-half, 50-50. Under those circumstances, the law expects the parties first, please try to mediate this matter. Mediate basically means go to a third party. It can be anyone, doesn't have to be a lawyer or social worker or psychologist or psychiatrist or officer of family advocate. Try to go to a third party first. It could be a parent, one of the party's parents, an uncle, a priest, an imam, a minister, a rabbi, whatever the case may be. Go to somebody and try to resolve this issue concerning care and contact. The father wants to have the child every second weekend as opposed to 1 week in a month. The problem is when the mother and the father sit on the same table, they just argue. The mother just hears words coming from the father's mouth, and the father just hears words coming from the mother's mouth. He is sticking to his guns, and she is sticking to her guns, and nobody's listening to each other. They hear noise. And if you ask one of them the question, what is the other party's problem? They can't answer you because they are just here to argue and defend themselves all the time. But at the same time, people need to obviously, discuss and listen to each other. That's where the mediator comes in. The mediator gives the parties a platform whereby the mother can speak, she can mention her issues, what problems she has with the father, and the father has to keep quiet. He can't interject her like he does with her when they are together on a different setting. He has to listen to her. And the mediator must allow that to happen, and he must listen. And once she is done speaking, the mediator would allow the father to speak, and he can respond to that. And many times, that is the first time these parties, in a period of 5 years or 10 years, whatever the case may be, actually listened to each other. That's very important, because they never do that. They hear each other. While they're hearing the other party speaking, they are preparing their defense, they're preparing their attack in order to continue with their specific stance, but they don't listen. And many times these mediation sessions are very productive because finally one party understands the other party and they can move somewhere. The mediation session might not end that specific day very well in the sense of that the parties now come to an agreement, but the father goes home, the mother goes home, and then she takes out the notes as to why the father said something or why the mother said that, and they will come to some type of understanding regarding the point of view of the other party, and hopefully through that process things can be resolved. However, unfortunately, if a matter cannot be resolved in that specific fashion, they would obviously have to go to court, and the court would have to determine that. So, moving forward on the issue concerning child custody, the general topic which I'm bringing to the table here is that in child custody matters, try to mediate the matter. You're dealing with your children, with your kids. Do not think for 1 second that the court and the law will find in your favor at the end of the day. It must find in favor of one of the parties, or it will find in favor of the minor child, what's best for the minor child, which might not go well where you are concerned. That's very important to note. So in resolving this matter via mediation process, you have power. You can sway the decision of the other party directly, not via a court, whereby the court makes a final decision. You might ask for A in court, the father might ask for B, but the court, he thinks or she thinks, with respect to the court, might decide that C might be in the minor child's best interest. The court might be right, the court might be wrong, whatever the case may be. However, in a mediation session, you and the other parent can mold and work out your own documentation. You go to the family advocate's office, they have their own opinion as well. And at the end of the day, you might be left with a decision from a third party who only knows you and the other party based upon the 10 hours or 5 hours of looking into this matter, the judge hearing the document, reading the documentation and hearing what you have to say or your advocate having to say for the last 2-3 hours, spend 10 hours maximum on your specific file and has to make a decision regarding your future based upon that. But however, in the mediation session, you would have an opportunity to mold and to determine and create a workable parenting plan going forward. It doesn't have to be this fancy documentation which lawyers draft. It can be something very simplistic as well, something that's workable for your specific family. So that's child custody. So as I mentioned early on, the law does not prefer a mother over a father. Both parents have parental rights, and what the law expects is that whatever decision that is made, it is in a minor child's best interest. Each family is different. I keep saying this. Each family's dynamics are different. That's a reality. What applies to your family might not apply to her family or to his family. I may open up a court file today. The facts applicable to this specific case will not be applicable to that case. And it's funny because I draft urgent high court applications all the time. That's just what I do. And it's very hard, and it really happens quite seldom, whereby part of someone else's file is applicable to the specific file I'm dealing here with. And it'll be very nice because I can just copy and paste, and an hour later I'll have a nice document, but that's very hard. Dynamics are different. The ages of the kids are different. The issues involved are different. For that specific family, although the child is 2 years old, they are separated, both of them are accountants, the child does this specific extramural activities, etc., exactly the same as another family, but the dynamics are always different. What one parent wants as care for care and contact does not apply to the other parent. And that's very important to note, that each family is different, and you should know that. And that is why there needs to be this type of engagement. You and the other parent have to come to the specific understanding and arrangement regarding the future, your child's future. However, it's unfortunate if the mediation fails. Unfortunately, you'll have to leave the outcome to a third party, and which is not always the best, as I demonstrated early on. Should the matter go to court, the court would obviously have to make a decision with the assistance of the Office of the Family Advocate, maybe other experts involved as well, social workers, psychologists, etc. Mediation failed. So therefore, the court will have to make use of these experts. You will obviously have to outline your case. The other part will have to outline his or her case. And at the end of the day, the court will have to make a decision regarding what's in the minor children's best interest. So on the issue concerning childcare, what type of orders could the court make? It will all depend upon a lot of things. Historically, what type of contact has the parents been exercising? What's workable under the circumstances? For example, a situation where the minor child lives in, I'll use the example, in Cape Town, and one parent lives in a different province. Contact is workable because that parent can drive down every second weekend to spend some time in Cape Town, but shared care will not work. For the child to be one week with one parent and 1 week with the other parent, it would not make sense. Other dynamics could be applicable in the sense of the schooling, whereby the parents live most probably in the same vicinity, but there are two minor children involved. One, it might be in high school, one might be in primary school. So shared care would not be practical under the circumstances. And that's very important to note. When I say shared care, I mean 1 week with one parent, 1 week with the other parent. If one parent works very hard, late nights, let's say the mother works very hard, late nights, she's never generally available to attend to schoolwork, homework, and so on, it would not be in a minor child's best interest for her to have primary care. If the father does not work as hard as a mother, or does not have the same job, he might work very hard at work, but he has more time to attend to the extramural activities as child education. So that would make more logical sense. So ultimately, I will not delve too deep into this because we have some questions and I have to deal with that. Nonetheless, the law focuses on what is in the minor child's best interest. So that is child custody. And I have a second question. Let me put that over here. Or comment. Question 2. Let's make it live over here. Just paste it over there, okay? And then I have another comment. Let's put that down here. Thank you for the comment, and it's always good for people to see comments. Makes these things more relevant. Costs money, yes, court costs money, very expensive. And a further comment number 2, mediation, the best. And one, I think this follows comment number 3. That is it. If you have any questions, please feel free to pose it. I will answer all of them. I want to deal with the questions in a single fashion, as opposed to going up and down. So that was child custody, my general prelude regarding child custody. Child maintenance. In my experience, child maintenance can be the easiest thing to resolve based upon a certain amount of facts, and it can be the most complicated aspect to resolve based upon a set amount of facts. For example, if the father is a salary earner and he's the one paying the child maintenance, the mother is a salary earner as well. She's the one caring for the minor child. The minor child attends a certain school. School fees is quite simple to work out. It's a monthly payment or a yearly payment. Extramural, the child has to eat. While the child is at the mother's place, the child sees the father every second week in half school holidays. Mathematically, it should be easy to work out. Father's income, the child's expenditure, the mother's income, her expenditure, and so on. We can work out something and say this makes more logical sense. The father earns X amount of money. Of course, the maintenance amount cannot be more than what he earns. He needs to live, he needs to eat, he needs to look after himself. He might have certain expenses as well. The mother, exactly the same. We look at the standard of living, we come to a conclusion. We deal with a different scenario, more complicated. The father is self-employed. He earns X amount of money this month. The following month, he earns much less or much more. The mother is unemployed. She's trying to find work, etc., whatever the case may be. The child is homeschooled. The father has contact once every 3 months. So it complicates matters a bit more. But how do you work out what is a fair and a reasonable amount of money for the father to pay? And also concerning the mother is not working complicates matters. The child must be looked after. At the end of the day, the court will have to make a decision that is in the minor child's best interest and that's workable under the circumstances. But these circumstances make matters more complicated. Because now the father must pay everything. And he might only be able to afford X amount of money, but the child requires more. Then you have to look at the possibility of going to grandparents, etc. And the question is, why is the mother not working? Is it justifiable under the circumstances, etc.? I'm just dealing with a complicated scenario, a complicated example. Then we're dealing with other issues, example, regarding pension funds, policies. The father might not be working, but he owns property. So how do you determine what amount of maintenance you should pay based upon the fact not having an income, but he has wealth, etc.? So that's where maintenance comes in. But regarding child maintenance, I would say my advice to you, either the person paying or the person claiming, I have no problem with either one of those specific parents. You're entitled to claim, and it is a dispute, and you feel that you are paying too little or you're paying too much, you have a right to oppose it. I fully agree with that. So if the mother takes you to the maintenance court and she wants X amount of money, you are paying child maintenance, but you feel that what she's asking for is too much, then my advice to you is to not pay what she wants, that higher amount, and let the matter be resolved in the maintenance court, as long as you are following what you should do. And of course, at the end of the inquiry, it comes about that the father should have been paying a bit more money, then the court should make an order that should back pay it. But why should you pay much more? And at the end of the inquiry comes about that you should have been paying much less. It does complicate issues, but pay what you should be paying, pay a fair amount of money. Remember, I'm being hypothetical here. Please remember that. Each case is different. All circumstances are different. If the child costs 10,000 rand per month for argument's sake, and the father earns 100,000 rand per month, and he only is willing to pay 500 rand per month, and you think that's reasonable, although the mother earns 50,000 per month, I would say, please, father, that cannot work. It should be reasonable until the maintenance court resolves the dispute. It should be fair. And next topic we shall deal with is child maintenance. I have an additional question over here. Let me first deal with that quickly, so we can deal with all these questions in one go. It will be the part 2 of this webinar. question 3. Okay, and then we have a question 4. And I presume you're looking at the questions while I'm typing it out. Question 5. And if there aren't any questions, we might end at question 5. So question 6 came in over here. Is it going to do that? Sorry, this is additional comment on question 5. Okay, that's great. Now the issue concerning divorce. Divorce should be simple. First, let us deal with the issue concerning the breakdown. Remember, the marriage is over, counseling doesn't work, you moved on with your life, he moved on with his life. You guys do not want to be married to each other anymore. The marriage has been broken down, first requirement met. Of course, there are other technical stuff, example, jurisdiction, and can you get divorced in Cape Town if you both live in Johannesburg. Those are things I will not deal with in this specific webinar. Then we're dealing with the issue concerning, in a divorce, the child maintenance, same principles. Child custody, same principles. Divorce does not necessarily have to be too complicated. Regarding the property aspects, if the parties are married, income in the property, simple, division of the joint estate. Other come into property with accrual, simple, calculate the accrual, without the accrual, nothing to divide, nothing to share. Simple as that. However, where divorces can become complicated is one party wants to fight the matter and be unreasonable. And then unfortunately, under those circumstances, the matter would have to go to trial. But I would say mostly on a divorce matter, if you have a proper mediator, someone to deal with these issues, deal with child custody, deal with child maintenance, you should get a divorce finalized as soon as possible. Over the years, my experience are, out of 100 divorces I do, most probably 10 goes to trial. That's how it is, or maybe less. The sad reality for the clients is that a lot of money gets spent to get to that point, to trial. Then on the doorsteps, the matter gets settled. After both parties spend so much money on legal fees, it could have been avoided. Spend part of that money on a good mediator. Yes, get a lawyer on board, but let the matter get resolved and have the matter finalized. So I hope I've been a bit inciting regarding these specific topics and how we can deal with issues, the questions posed live. Thank you for those questions. Okay, question number 1. Hi, what happens to a final divorce order and its terms if an ex has applied for a maintenance order as he now has interim primary residence of the minor? There is also a pending report with a family advocate regarding primary residence. I do contribute every month, even though the divorce order was for him to pay me, and the interim order doesn't mention anything financial. Yes, so in principle, the maintenance order still stands, but obviously it does not make sense for him to continue paying you maintenance because now he is obviously looking after the minor children. So regarding the maintenance matter, if you have this understanding, it's an agreement, wonderful, let it stick. If I was him again on the other side and you're persisting, no, you're looking after the kids, but I want you still to continue paying maintenance despite me not paying for despite me not maintaining the kids, you would obviously have to approach the maintenance court as soon as possible to have the maintenance order set aside. So you are mentioning the family advocate. It's possible, theoretically speaking, that the court might make an order that things basically revert to the way it was in terms of the initial divorce order, or the initial divorce order is as you mentioned over there. If that is the facts, and then things will have to continue as is. He should pay you the maintenance and life goes on. But seeing, and I like your approach here, that you are paying maintenance towards him because he is looking after the minor children, that is a proper thing to do. And once this whole matter is finalized, and if the court makes an order, I'm on nobody's side here, but if the court makes an order that he should be the primary caregiver of the minor child, then the court should at the same time also make an order that the initial maintenance order be changed, varied, that you pay maintenance to him. Okay, question, I hope that answered that question. If not, feel free to comment on Facebook Live and just mention that you are responding to question number 1. Okay, question number 2. Can a couple still mediate after summons has been issued to appear in court? Yes, you can mediate. In terms of the rules of court, there's been some developments. When you're issuing any legal document, you should stipulate whether or not, Form 27, whether or not you would agree to mediation or not. You may still mediate the matter after the summons. You may mediate the matter until the morning of the divorce. So summons has been issued, plea, counterclaim, discovery took places, pre-trial conferences, etc. Preparation for trial, and now we're ready for trial. You can still mediate the matter before the trial date. Still possible under the system. Yeah, both parties must be willing to do that. Question number 3. Ex served me with the maintenance papers, but now wants to mediate. He's demanding a certain amount with complete disregard of my financial situation. I still think these matters are very simple. I mean, if somebody's not willing to be reasonable, then you just walk away and let the maintenance court resolve it. That's the nature of these type of disputes. He believes he's fair, you believe you are being fair. You both might be correct, both might be wrong, he might be right, you might be right. I do not know. He served you the maintenance application, documentation, now he wants to mediate. Wonderful. If the mediation fails, mediation fails. I had the same meeting this morning. I had a dealing with this child custody matter, and we tried to mediate the matter. We're in court next week. The other party and us could not see eye to eye. We said, unfortunately, this meeting did not go off too well, but let's remain friends and let's also sort that out in front of the judge next week. That's how it is. So he's welcome to make the application. Does not mean he will be successful. He's welcome to propose mediation. He can say his thing, you can say your thing. Hopefully things will be resolved. If it does not get resolved, just continue to court as he has served maintenance papers on you. I hope that answers question number 3. Question number 4. Do I need legal representation only first appearance in the maintenance court? No. South African law specifically stipulates you do not have to have an attorney or advocate assist you represent you in court. It's always advisable. I will not say you do not need per se. You do not have to have a lawyer. It is advisable if you can afford it, but it's not necessary. The maintenance court is there specifically made to assist people who cannot afford legal representation. So I hope that answers that specific question. But if you ask me, is it advisable? I'll say yes, it is advisable to have a lawyer present. Same way, doctor, accountant, professional teachers, have a professional person assist you if you can afford it. Question number 5, and that was a noon gun. Family advocate report was not fair, so decided to use expert child psychologist. Father does not want to confirm date with expert. What happens in this case? Matter has been adjourned in court pending the expert reports. Also, what is the legal age for unsupervised contact? So there were 2 issues over here. The father would have to comply. I mean, I would say this matter must go back in front of the court, and the court will have to make a directive directing the father to go to a specific meeting at a specific time. If he does not do that, unfortunately, the court will not look good at him. I do not know what the outcome of the court's decision would be. The court will have to make a decision. Either court will say, in that specific regard, he does not want to go to an expert. Expert, do your report without the father's input, because he now basically waived that invitation. Alternatively, the court will maybe force him to go to that specific meeting. Matter has been adjourned in court pending the expert report. Also, what is the legal age for unsupervised visits? There's no legal age for unsupervised visits. Unsupervised visits can take place at day 1 of a child. It all depends upon the first circumstances of the case, the facts applicable. Many times it happens, people, they have a child's a few days old, few weeks old, they continue not to have a relationship. But then the mother says, Dad, look after the child tonight. So the child goes with the mom, with the dad, and that specific evening. And the other evenings with the mother because she has to go to work, whatever the case may be. So there's no specific age regarding supervised or unsupervised. You can have supervised visits. The age child can be 17 years old and 11 months. That supervision can take place for the next 1 month of the child's life until the child turns 18 years old. And then he or she becomes an adult. So it all depends upon the circumstances of the case, the facts applicable, etc. So there is no age for unsupervised visits. Okay, I have a comment over here regarding question number 2. And I have another comment saying, please make a recording of this available. Yes, the video, it remains on Facebook, so there's no need for me to record it. You can go on Facebook, so on Facebook, on YouTube. We're on Facebook now. Question number 6, or comment number 6. Okay, let's deal with that quickly. So please remember, this video will remain on Facebook. Regarding question 2, if we do mediate between ours and agree, do we both still need to appear the morning of the court appearance, or can the person filling inform the maintenance court, or inform the maintenance court? No, you both have to appear. How does the court know that there was an agreement regarding maintenance or not? So you still have to appear. Both parties have to appear, because you're going to appear, so both parties will have to appear at the maintenance court to finalize the maintenance agreement. Maybe there might be other ways, contacting the court, telling the court, I'm agreeing, is it fine if I do not appear? But my understanding is, for maintenance matters, both parties will have to appear at the maintenance court to confirm the agreement. And that is it. Thank you very much for your time. I see no further questions. And I always appreciate people partaking and joining in these type of webinars. And hope to see you online again tomorrow with any further questions you may have. Have a lovely day. And thank you for joining this live Facebook webinar on the topic of child custody and child maintenance. Once again, I thank those participants that partook in the live Zoom webinar yesterday, as well as the participants who have posed questions live on Facebook Live. Thank you very much for that. A bit of housekeeping. Please remember, I cannot see any comments or posts made on any other page other than the Advocate Mohammed Abduroaf Facebook page. You can see it on top over there, www.facebook.com/Advocate Mohammed Abduroaf/live, or you can make use of the link www.abduroaf.co.za/live. It redirects you to the other link. Please make use of that. If you have any questions, if you do not have any questions, that is fine. You can join in and watch from wherever you are, but we do advise you to like the Advocate Mohammed Abduroaf Facebook page for the sole reason we are streaming from that specific page. So you'll have first notification of whatever videos are streaming. These webinars are very interactive. You pose your question, I'll be able to see it. There's no questions now. You can see there's no comments above. The moment you pose a question, no one can see who you are really, unless they are on the page. And I will copy that question onto the screen on my left-hand side, the document stipulating live Q&A and with today's date. And we can all see it, and you are welcome to pose any additional questions or provide any additional comments after I dealt with the question. So try to be as interactive as possible. And I see we have one question that came in. It's on my phone in front of me, but is it on? Okay, I see it is on the live Q&A. Let's get to the question. Let me copy that question onto the screen. And if you have any additional questions, please feel free to pose it. I'll be happy to answer it. So this will be question one. If question one, commenter on question one has any additional questions, I will just copy it underneath that. I presume we all can see on the screen what the question is. It is as follows. Hi, Advocate. What can parents do if a social worker is handling a matter in a biased manner? One parent and the social worker are and have been friends outside the case. Thank you. That's the first question. I see another question also came in. I'll deal with that question after I dealt with this. But I see question one, he added additional comment. I think I might have to deal with that first. Let's put in that additional comment. Okay, that's the additional comment. The social worker is making suggestions that fit the wants of the one parent's needs.
And is there anything else? No, there's nothing else yet on that. And let me just copy question 2. Otherwise, we might lose that one, lose focus. Okay. Moving from one screen to another screen can be a bit challenging. There's question 2. So let me just deal with this first, and I'll later on deal with any additional comments. So the questioner says the social worker is biased. What can he do? They're friends, the parties, the social worker and the other party, one of the parties, they are friends. And he goes further, the social worker is making suggestions that fit the wants of the one parent as needed. Now that's obviously problematic because a social worker, when dealing with a matter, and I presume this is obviously a child custody matter or some dispute regarding parental rights and responsibilities, has an obligation, professional obligation, to be unbiased. He or she should apply his or her professional opinion on the matter and not be swayed by personal prejudice, personal judgments, and at the same time, the knowledge, knowing someone, one of the parties. So under these circumstances, I would, if I was a social worker, and this was probably the best thing to do, is to recuse yourself from this matter and say, I cannot, deal with this matter in an objective fashion because I know one of the parties, I'm friends with one of the parties, and let's say I have to find against my friend. There will obviously be, negative consequences regarding friendship. I think you follow where I'm going to. So you will be limited to your decision. You might say, oh, I want to find against my friend, but if I find against my friend, he or she might tell my other friends, and then I'll be unpopular and so on. So on that basis alone, the person has to recuse his or herself. My suggestion is, to the commenter, is to ask the social worker, please recuse yourself from this matter. You do know one of the parties, you are friends, and it's clear that your decisions are in line with the ones of your friend. Even if it's not in line with the ones of your friend, you feel that there is some type of unfairness, unjustness, and there's a reasonable apprehension of bias in this specific case, that you think, you will believe, you are confident that the specific social worker will find in the favor of the other party or be sympathetic to the other side. And that becomes problematic because how can you successfully, or in a meaningful manner, engage with a social worker or a professional if you feel that the specific professional is biased and will not make a fair and a reasonable decision on the specific matter. Therefore, under these circumstances, ask the person to recuse his or herself, maybe stipulate it in writing, send an email to the party and also copy the other party in as well, send an email to the social worker and copy the other party in as well. And if the matter is before court, also file that specific letter or document with the court and tell the court, this is your concerns, this is how I feel. I do not feel that I can, in a meaningful manner, deal with the specific social worker. I hope that answers the question to a certain extent. Question number one, you're welcome to pose any additional comments now that I have given my view on the matter. Let's just deal with question number 2. What happens when one takes a retrenchment package after serving court papers? No court order yet, can apply for future maintenance. I would obviously want to ask the question, are we referring to parties who are married to each other, in communal property or out of communal property, with accrual, without accrual? That could possibly play a role. Or the parties not married to each other and the one party is getting a pension payout and there's no maintenance order in place. So I presume we're doing maintenance here, but the commenter could possibly add some additional information, some background information. Where are we going to? Because you are entitled to take a retrenchment package after serving court papers. What type of court papers are we talking about? Divorce court papers, maintenance court papers? I do not know. Maybe add a bit of comments and I can give you more of a meaningful answer to that. So I'll hold that. If I do not get additional comments, I will come back to it and I will try to answer it on basically on various scenarios. I have a third question. Let me just copy it in. Okay, got it. It seems to me the best way to do this is a manual way. Use a mouse and copy, not Control and C and Control and V. There we are. Third question. Morning, please advise what can be said to MO, I would presume the maintenance officer, who is telling parties that because one party is unemployed, the expense of the child should be split in a 50-50 ratio. Now, let us maybe go to the basics first. Maintenance is not payable 50-50. The law doesn't say that. It's almost like saying if a child costs, for example, 1,000 Rand, I'm using round figures, and another parent earns one of the parents earns 500 Rand, and another parent earns 10,000 Rand. Then we're basically saying if it's 50-50, the one parent, all his or her income must be used for child maintenance, and the other parent must only use 50 Rand of his 10,000 Rand towards child maintenance, if I remember the numbers correctly. That will obviously be unfair and unreasonable if you go on the 50-50 ratio. Same would, for example, apply the child costs 1,000 Rand, but one parent earns 2,000 Rand, so he must pay 1,000 Rand according to this logic. And the other parent who earns 100,000 Rand per month, he should also pay 1,000 Rand. So one parent pays 50% of his or her income, and the other parent pays, how much is that? 10% of his income. Sorry, 1% of his income. Now, be that as it may, whatever the circumstances of the case, we need to make a fair decision when it comes to maintenance. Now, maintenance is applicable or payable according to your means and proportionate to your means. And at the same time, someone can be earning nothing, be unemployed, but he or she owns a great amount of assets, is extremely wealthy in the sense of assets-wise, owns few houses, lots of cars, but has no salary per se as such. But the one parent, the other parent earns a salary of, let's say, in this case, 2,000 Rand per month, the child costs 1,000 Rand per month. You can't say I am earning nothing and therefore I can't afford to pay. So, because you have assets, that basically applies generally how maintenance is calculated. So my advice to you, the Pacific commenter, is unless you have a lot of assets and the court considered your assets, then the court could be right, it must be 50-50 because the one party earns X amount of money, but you have a lot of assets and you are unemployed. But if you're unemployed and without any significant amount of assets, the usual assets which people will generally have, the same like the other parties, what the other party has, then maintenance should not be split 50-50, it should be according to your means. Because let's say, for example, you are not unemployed. You earned half the other person's salary. Then the law, certain specific maintenance officer would apply the principle that you should pay 1/3 and the other parent should pay 2/3. But here you do not earn half his salary, you earn none of his salary. So obviously 2/3 or 1/3 will be impossible. But you earn nothing, so automatically the amount should be less. It can't become more. It's like saying somebody earns X amount of money, you should pay little maintenance. But if you earn less than that amount of money, you should pay more maintenance. And the logic doesn't make sense because there is no money. You are unemployed. How can you pay that 50%? So there is no logic. The child requires 1,000 Rand per month. That's my example for now. The maintenance officer's logic is because you're unemployed, you should pay 50%, 500 Rand. And the other parent should pay 500 Rand. Where must your 500 rand come from if the other parent can afford to pay that? Unless possibly the other parent cannot and can only afford to pay that 50%. And then, unfortunate for the minor child, then we have to maybe go to the grandparents and look for money from them. So I think the bottom line is, regarding the law, you most probably just have to go look up some case law, Google child maintenance amounts, some cases, how the courts dealt with that, and address that to the maintenance officer, or maybe to the maintenance magistrate, or speak to somebody in the court, maybe a maintenance prosecutor, for them to try to explain to the maintenance officer that that is the specific law and that is how it should be applied. If the party can only afford the 50%, the other party, then that is a factual thing. And then, unfortunately for the child, that the other parent doesn't work. The unemployed parent must make a plan. However, nonetheless, moving forward with a specific thing, look up the law, find out how the law works, have a discussion with the maintenance officer and see what he has to say. But at the end of the day, if he makes a silly order, remember, he can't make the order, sorry, my apologies. The maintenance officer cannot make the order. He only deals with the administrative aspect of the case. It is the maintenance magistrate that makes the final order. Address it to the maintenance officer. If it doesn't work, you have to address it to the maintenance magistrate. But however, the entire process still needs to take place. There still needs to be an inquiry. How much does the child cost? What is your income and expenditure? Of course, it's zero your income. Then the court has to determine, you need to explain to the court how do you survive, and same with the other party. The other party has to do exactly the same. So I hope that gives you a bit of a nutshell, a general understanding on how these type of things work. I see question number 2 added some additional comments. I'll be happy to copy that quickly in. I think my query was what court applied. That's the first comment I see. Any other additional comment? So let us make this as interactive as possible so we can all learn and benefit. I also learn and benefit because I give my brain a chance to develop and to keep it moving. I have another comment, question number 4. Let me just quickly add that one in, so while I'm busy with copy and pasting. There it is. So let's go back to question number 2. What happens when one takes a retention package after serving court papers, no court order yet, and I can apply for future maintenance, divorced parents, is a child maintenance order. Okay, so the parties are divorced. There's nothing regarding the patrimonial property aspects. Here, one party is going to take out a retrenchment package, or maybe cash his retrenchment package. He took a retrenchment after I served him papers for maintenance in March. He is welcome to do that. The only way you can attach that specific money is if the person is not paying child maintenance. It is a sound reason for that specific person not paying child maintenance. Sorry, it is the only reason, sorry, my apologies for this. The only time whereby you can attach that specific retrenchment package is if the other party is not paying child maintenance on time, he does not want to pay, or he refuses to pay. The maintenance obligations will obviously apply on a month-to-month basis. So as long as a specific person pays maintenance on a monthly basis, then there's no basis on which you can now attach his specific lump sum. It is his money. Regarding the specific retrenchment package, if there is any cash amount being paid to him, I presume there will be a cash amount paid to him, and this basically increases his wealth, his net worth, then the court can basically relook this whole situation. Because before he cashed his retrenchment package, his earnings or his net worth was a bit less. Of course, he had a package lying somewhere there, but his disposable income was less. Now he's cashing in on this retrenchment package, and he has more money available, more money to dispose of, which money can obviously or should be used for the minor child as well if the minor child requires that. So that is where the court can look at that. But he has full right to make use of his retrenchment package. He worked with it. The parties are divorced already. Life went on. If he does not pay the child maintenance, then we can ask the court, please attach this pension fund or interdict the retrenchment interdict the retrenchment fund from paying monies to him, and they should pay the specific monies over to me as maintenance in lieu of the current maintenance order. So there needs to be a legal basis upon why you say the court must now attach or take this money or use this money. So going to the question, what happens if one takes a retrenchment package after serving court papers? Nothing. You can do whatever you want to. You are applying to the maintenance court for a certain amount of money. I presume you're applying to the maintenance court for an increase. He can do whatever he wants to do with the money. The same way you can do whatever you want to do with your money. Only if there's a problem and the court is afraid, or you are afraid that he will dissipate the money, then you can approach the court and say, please hold on to that money. We found some money. Please hold on to it and let the money be used as maintenance. Sometimes the mind goes a bit here and there because the screen is just moving up and down. So I hope I have answered that specific question. Let's go to question number 4. How do you prove that the other parent have extra income but the business is not registered? That is a very difficult question. My guess is just as good as yours. I can give you a lot of possible scenarios. One would be to speak to the person's clients, have an investigator follow this person, find out what the person's operations are. If the person has a bank account, had the bank accounts subpoenaed. Those are the normal stuff. I mean, this is isolate. Every case is different. Every parent is different. Every business is different. And how the specific person operates is different. Some people, they run a business where they do one job per month. So it's one invoice going out and one payment coming in per month. Let's say they do big jobs. And some people, they do a lot of small jobs for the month, or maybe 200 of it per month, and they get paid most probably 100 Rand per job. So those are the variables that applies here. Some people work with cash, some people work with bank accounts, some people work with EFTs, credit cards, and so on. So what you need to do is you need to be creative. If you, ultimately what I'm telling you is, what I'm mentioning to you is, if you cannot prove that this person is earning extra income, and this specific person denies it, and there's no evidence before the court that he is earning extra income, then more than likely he's not earning any extra income. It's your allegation against his or hers, depending upon the gender of the parties. Therefore, if you have a strong assumption based upon facts, or there is information which you have seen while you were with the person, while you were living with the person, or what people have told you, this person is operating this business, he's doing graphic designing, he's setting up websites, he's a taxi driver, he's an Uber driver, whatever the case may be. So there you have your evidence. Now you need to dig a bit further, and you need to now maybe get the assistance of the maintenance court. So if he's an Uber driver, working in the evenings, doing Uber work, and he's earning some money from that, if he's a delivery guy who must delivery, extra income, whatever the case may be, you can ask the maintenance court to subpoena the Uber, Mr. Delivery, whatever it is, the bank statements, and based upon that, the court will know whether or not he is earning extra income or not. But generally, when you go to the maintenance court and you make these type of allegations, do your research first. And if you come to court with a strong allegation, for example, no, he works for Uber, he has photographs of him driving customers. I actually know of a few people that have, you'll say this, that have a use of his services, etc. And I found Uber, and Uber confirmed he works with him. So when it comes to the maintenance court or the maintenance inquiry, he won't deny it, he will admit it. But if you go to the maintenance court and you say, I believe he earns more money, I do not know, he'll most probably keep his mouth quiet. Or she will keep her mouth quiet, depending upon the facts of the matter. The same way, if a child does something naughty and you do not know what he's doing, you will obviously have to do research, investigate. You know, he or she might deny it. You will have to find out ways of figuring out the truth. The same way with the maintenance matter. This is an income, additional income. There should be bank statements. There should be some type of proof that the person is earning additional income. And you need to find it. I hope that answers that. If not, if you are commenting now additionally, please just say question 4, question 3, question 2, so I know where you belong. Sometimes it's a bit difficult to connect the name to the question as the string goes further and further. But now we got question 5. Let me copy it over quickly. Copy. And there we are. Let us deal with this question. Is there any recourse a parent can take if the court loses the case file? An urgent application was made, but due to COVID, the matter was postponed for 1 day, only to hear the medical test need to be performed and returned to court. Upon return, the court claimed they lost the file. The urgent matter has now become just another matter and not handled in an urgent matter anymore. The urgency was based on drug use by the primary caregiver. Should the parent engage the court administrative clerk in a more aggressive, constant basis to find the file or start a new process? I feel that we are parents and children are not responsible for the court's administrative and operational process. This is a very sad issue and a very concerning issue because, if court files are getting missing, there are original affidavits, original court documents in the court files. The court is a public building. People go in and out all the time. The files can easily get missing, and that's unfortunate. And if the files have gotten missing, it places the parties in a very difficult position because you spend thousands of rands or hours, if it's on your own matter, on preparing, filing, serving documentation. It costs money also to do all of that in serving documents by the sheriff, emails, whatever the case may be. Now the lawyers are ready. We're in court, ready to proceed with the matter. The fees must be paid. I mean, the time is money. Court file is missing. Court says, I can't find the file. Everything else is stamped. On your side, you have proof that the documentation was presented to the court. The clerk stamped the court documentation the day before. Obviously, it was handed in to him or her, and so on. Court file is missing. There's nothing can be done. Yes, you can give the court a photocopy of the file. I presume there is a photocopy, but then the judge never read through the documentation because the file was not handed to the judge. And everything is stalled for a day or two. One option you obviously have is to file a duplicate court file. Obviously, the principle would be always have photocopies available of all documentation that you file at court. But on the bigger question, you can obviously, if you feel that the court was negligent, the court did not do their job, negligent in losing the court file and so on, you can maybe suffer damages. You can sue the Department of Justice for not doing a proper job because of the damages you suffered. They had a legal obligation to ensure that the court file was taken care of while it was in their custody, and because of their negligence, whatever the case may be, it's all theoretically I'm talking now, not specifically say it applies to your case, but theoretically, you can prove to the court that due to the Department of Justice's negligence, you have lost out or incurred certain damages, and they must compensate you for that. It will be a very interesting case. I never heard of any such a case before because I went to court so many times over the years, and so many times duplicate files had to be opened because I can't find a court file. Files get issued, it goes in the pigeonhole behind, at least I'm referring now to my local courts. It goes into the pigeonhole. Anybody can come later and say, oh, that's my file, let me have a look at it. While they have a look at it, the clerk is busy with another 100 people. You would have forgotten about. The person can walk out of the court with a file, put it in a bag and walk out. Nobody will know. Maybe there should be cameras, maybe there should be a more stringent way of dealing with these type of matters. So I hope that specifically assists with that specific query. Depending upon the nature of the matter, you might have to decide to file another application, depends on the facts of the matter. The question is, should the parent engage the court administrative clerk in a more aggressive, constant basis? If the file is missing, the file is missing. There are thousands and thousands of files in the High Court, tens of thousands of files in the High Court that are being issued. Thousands of files are being issued on a yearly basis, but there are tens and thousands of files in the High Court, maybe a million, I don't know, I do not know. If that file is laying with anybody else's file, let's say the clerk came and came to collect a certain file, but took your file by mistake and in some judge's office on the 3rd floor. and it will remain there maybe for the next 3-4 months. So the file is most probably missing. Duplicate files are very useful, and if the court is willing to issue a duplicate file, that will most probably be your second best guess. And obviously, suing the Department of Justice if you feel that you have been strongly aggrieved and you have suffered damages. I never saw such an action before, but you can consider it. I see no additional questions. If there are any additional questions, please feel free to pose them. We are now past, let's see the time. From a recording time now, I record these videos from the moment I started so I can put it onto YouTube later on. It's 28 minutes. That's a lot of time. If there are any additional questions, please feel free to pose them now. Otherwise, we'll conclude this video. We will have another one again tomorrow morning. I cannot say exactly what time because with this COVID-19 and everything, you do not know how your schedule goes. We are busy with another court case, a custody battle for the last few years. The matter was heard last before COVID-19. We think it was still fine. I think it was in February. And then the matter got postponed for the other party to get legal representation. COVID-19 came in. Now we're back in court a year later on the same facts, on the same reports, just because of this COVID-19 challenge we had. I see another question coming in. And it's concerning because you do not know how to deal with these type of matters unless you keep an eye on them all the time. We had to confirm with the judge, are we being heard virtually? Is the matter being dealt with in court? All important things to do, but it's a different world in the litigation world. So you do not know what happens, what to expect the next day. Generally, I will start high court litigation or high court proceedings at 10 o'clock. So I leave my chambers at about 9:30, get to court, introduce myself to the judge if I never met the judge before the time, and so on. Now, those have been suspended. You do not meet the judge before the time in the chambers, even if you never met him before, to limit the spread of COVID-19, which is all fair and reasonable and correct. The challenge comes, of course, in knowing how to deal with your day. Sometimes you prepare to appear before a judge in court, but then you get a notification that the judge is dealing with the matter via Microsoft Teams. So that also puts a bit of a challenge, but it seems to me that it's working very well. Okay, the last question, I guess, but however, feel free to pose any questions. I'll copy this quickly. Question number 5. Question number 6, sorry. We'll stop there. There we go. This is a 2-part question regarding maintenance. Can a parent provide physical items, formula, clothes, food, etc., instead of transferring currency? I think that's the first question. If so, will this method not lessen the rampaging parental alienation issue in the country by using this method to keep the parents in contact with the minor children? I would say that's a good idea if the parents are fine with that. The difficulty with such a scenario, if it's not workable, is that we have this constant communication between the primary caregiver and the secondary caregiver, whereby they will have to be, the parties are acrimonious, the parties are not friendly with each other. And now the mother says, for example, I'm using the stereotype example that the mother is the primary caregiver. She says, I require X, Y, and Z, right, for the minor children. Clothing, food, etc. But how does she work the food out? Because she can't only 3 potatoes for the minor children, but then she needs to add, because there's 4 other people in the house, let's say new kids and the step parent. How do you work that out? And what if the bill comes to, let's say the maintenance order is 500 rand per month, and now she says, no, I require the following, and now the bill comes to 800 rand per month. Does the father only buy 500 rand worth of groceries, or the last week he says, no, I'm not buying any additional groceries? What if the mother does not want to make peas food and the father's buying the peas food all the time? And she'll say, I mean, we can't eat peas food all the time. So if there is an understanding, wonderful. If there's no understanding, it does make logical sense in my view. If you just pay the one parent the maintenance, and that parent is supposed to use that maintenance. Then you deal with the issue of control, because parties are separated, they divorce, they move on with their lives. But one parent got to always be involved in the other parent's life. So every week, email his ex-spouse, here's this, and if there's a dispute, they start fighting. And I don't think that is in the child's best interest. In my view, my professional view, not my personal, my professional view is, you pay the maintenance, the other party will have to use it. 1 month, let's say you pay 1,000 per month, but the kids are now, for example, not so much at home, and she only uses, for example, 800 Rand for the child. But the next month, the kid eats more. Then she will use the 200 Rand of the previous month for the next month. They need parties who are acrimonious. They should not have to communicate on issues concerning the child. Tomorrow the mother says, I needed some more potatoes. I couldn't get hold of you. I bought another kilo of potatoes. Then the other parents said, bought the potatoes. Say, no. You should have contacted me. Or I bought a lot of potatoes last week. All these type of challenges comes about. We have one parent who is actually caring for the child, who knows exactly what the child requires on a day-to-day basis, and another parent from the sideline who is not so actively involved in the child. That is where it doesn't either acrimonious. And having such a clause in place stipulating that one parent should purchase certain items can just cause more problems. But if the parties are fine, their marriage has broken down, if the relationship has broken down, and they WhatsApp each other, they have an understanding, wonderful. That is perfectly fine. Things like school fees, those are simple things, because those are monthly expenses or yearly expenditure, and all that the parent has to do is just pay it. School fees, extramural activities, and so on, those are easy to resolve. But when it comes to these groceries and food, is a bit hard. Clothing as well can be difficult, because a primary caregiver will know exactly what the child requires. Like sizes, who's to take the child to the store. The other parent, if that's fine, if they're happy with it, that's fine. But however, if there's issues between the parents, because now the dad buys the daughter a nice miniskirt, and the mother said, how can my 16-year-old daughter wear this miniskirt? You know where I'm going to. And the commenter says, thank you, advocate, appreciate your advice anytime. You are all welcome, and thank you very much for your questions. We have 6 questions, and I think that is it. If there's anything else, please pose it now. Otherwise, I'll have to end this webinar in the next minute or two. That is it, guys. I appreciate it very much. I hope to see you tomorrow online again. If you have any additional questions, please feel free to pose it on the Advocate Muhammad Abduroaf Facebook page. I hope you can see, you can't see it on the screen. You see something on my right-hand side, but you can't see the finer details. Just type in the Advocate Muhammad Abduroaf, not my personal page, but the Facebook page. Have a lovely day further, and I'll see you tomorrow sometime online.
Let us begin. Welcome again, and thank you for joining us in a live webinar on child custody and child maintenance, where I'll be discussing on these specific issues and topic. However, if you have specific questions, feel free to pose it, and I'll try my best to answer it. With the lockdown, COVID-19, and the restrictions on movement, many challenges have come about when it comes to the issue of child custody and child maintenance. As I mentioned in yesterday's webinar, the word custody is no longer being used legally, but I still continue using it. The legal term now is care and contact, no longer custody and access. But for the purpose of this webinar, and many people do not know those specific legal terms, and they're used to the term custody and access, I will play around with those terms. I'll more than likely use the word contact as opposed to access. I had a few webinars yesterday, specifically yesterday with a practicing attorney from Durban, and she agreed with me that when it came to COVID-19 and the lockdown, our jobs of legal practitioners became more relevant because there was major challenges in the protection of minor children's rights, the protection of parents' rights, and the issue concerning general parental rights and responsibilities. The courts were challenged to us. It was very hard, or it is still hard to obtain, justice or legal recourse, for the sole reason that there are certain regulations in place certain practices in place where the courts are trying to limit the spread of COVID-19, and being heard or obtaining some form of justice from the legal system becomes a bit harder. For example, you might have a criminal matter pending against you and they postpone this matter to another date. You may have a pending maintenance matter and they postpone those matters sometimes indefinitely, sine die, and you will have to be informed later on of that date. Urgent applications to the High Court or to the Children's Court and so on is becoming very difficult. However, nonetheless, they are still being made and the courts have a legal obligation to attend to your matter. But having said that, at the same time, it is expected upon parents to act reasonably and understandably, knowing that we are in a pandemic and it is in no one's best interest to play the system. I do not advise you to do that because judges know what's happening, magistrates knows what's happening, and if you are trying or attempting to, renege on your maintenance obligations or your child custody rights and so on, or obligations, the law will pick it up, and once these matters are presented back to the court will obviously know your attitude and act accordingly. So please, we're in a pandemic, be reasonable with the other parent. And when I say reasonable, and maybe I can provide an example, we know that during this lockdown period, kids are longer with one parent. Kids are on holiday. They're costing more money. They're eating more. More money is required, for argument's sake, for entertainment, maybe internet, whatever the case may be. They flush the toilet more, they use more water, and so on. Is it necessary for one parent to approach the court in order to convince the other parent that there are more expenses in relation to the minor children? It's clear. If you have a maintenance order which you have to adhere to for the sum of 500 Rand per month or 10,000 Rand per month, whatever the amount is, and the minor child is now more in the care of the other party, where the school holidays has been extended. It has already been extended initially. This is the longest school holidays, December school holidays, children had in many years, maybe decades. Nonetheless, expenses are high and expenses are still being incurred for the minor child. You as a parent needs to be responsible and need to know that and cannot hide behind the fact that the court order says you must only pay 500 Rand per month. That 500 Rand per month might be adequate under normal circumstances, where the school holidays are a certain period, a few weeks, but it's not adequate during this lockdown period. Even if we go beyond the school holidays, kids are most of the time at home. They go to school every second day. They're online all the time. It costs more money. Why should the primary caregiver approach the maintenance court in order to increase that maintenance order, despite its common knowledge that the minor children are costing more during this lockdown? So that's my comment on that. So things are different, things have changed. Regarding the change in circumstances of child custody rights, another issue. During this pandemic, minor children spend more time with certain parents or less time with certain parents, depending upon the certain circumstances. Yesterday, in my discussion with the attorney, I posed a question on catch-up contact. Catch-up contact in the sense of whereby a parent was was limited in his or her contact based solely due to the pandemic. For example, at the start of the lockdown, the law was clear. Minor children should have remained in the care of the caregiver they were at the start of the lockdown. Therefore, if a father, in my example, always had contact with a minor child only on a weekend, once a month, and the other parent cared for the minor child, of course, for the rest of the time. But let's say lockdown started on the father's weekend. Maybe they live a bit far apart. They received notification that the lockdown came in and they did not understand the regulations. But all of a sudden, midnight came in and the minor children were with the father. The law specifically stipulated, despite a court order saying something else, the minor children should have remained in the care of this father until those regulations were changed. And that was a few weeks later. And despite that, parents still quabbled and parents still refused the other parent time and contact to the minor child. Where I'm going to this is, there is no such thing basically as catch-up contact. Parents need to act responsible and reasonable. They cannot hide behind a court order. So let's take that scenario, for example, that example, and take it further. Let's say the mother, who is a primary caregiver, had the minor children for that first 3 weeks during lockdown, and the father, who was supposed to have contact to the minor children, could not exercise contact. Let's take it further. Let's say there is interprovincial contact, whereby the father stays in Cape Town and the mother stays in Johannesburg, and the kids usually come down to the father for half the school holidays and so on. But it could not happen because of the regulations limiting interprovincial travel of people. During the year of 2020, clearly, one parent would have had much more contact to the minor children than the other parent. The one parent will complain and say, I had little contact to the minor children. Please give me some type of additional contact. Despite it being a court order which stipulates how much contact I'm entitled to, or when I'm entitled to have contact. And the mother, for example, in my example, they will say, no, the court order says the second half of the June holidays, the kids are with me, and that's it. Or the court order says that the second half of December holidays, the kids are with me. If you could not, because of the law, exercise contact during the first half of the December holidays, that is your fault. That's unfortunate. Sorry, not your fault. That is unfortunate. But I'm not here to forfeit any of the contact which I am entitled to have in terms of the court order. So with my discussion with the attorney yesterday, she advised me, and I agree with her, the courts know the reality. The courts know that we are in a pandemic, we're in a lockdown, and clearly, there needs to be a change in circumstances, or a change in the manner in which parents care for the minor children. You cannot hide behind a court order if it's blatantly clear that the child needs to have more contact with other parent, but you are using the court order as a means and a mechanism of limiting contact. Therefore, on that note, please be reasonable, please be understandable. We do not know how long this pandemic will continue. Could be many more months, I don't know. My guess is as good as your guess. However, we're living in a reality where I honestly and truly believe that the minor children are being damaged. They are losing out on education. They are losing out on contact to the parents and so on. And therefore, we need to make it as comfortable and as good as possible for the minor children in order for them to enjoy life and live a life as normal as possible. But limiting contact to a parent because of this lockdown, despite a court order, because the parent did not have contact during a specific period of time because of the regulations, would not be in the minor child's best interest. And at the same time, why let one parent suffer and struggle despite you knowing that that parent is incurring more expenditure during this lockdown? Having said that, if you have any questions, please feel free to pose it. I'll be happy to answer it. Please comment where you watching it from. And as mentioned earlier on, you need to pose a question on the Advocate Muhammad Abduroaf Facebook page. You can see it over there, www.facebook.com/ ADV Mohammed Abduroaf /live. That's where you can watch a video. But if you type in that link, you should be able to come to the relevant page. We try our best to post or advertise these webinars before the time. Unfortunately, we can't have a fixed time. I need to be in court, things happen, other consultation and so on. So at least the day before or the morning early, I'll know my schedule and I'll know when I can go online for about 35 to 40 minutes. And you should get a notification of that. If you are working during the day and you are extremely busy, like all of us are, and everybody should be, keeping busy is the way to survive. Please visit that page again and you can watch previous videos. They are all stacked there and you can catch up. You do not have to watch it live. You can watch it later. While we're waiting for people to pose questions, I see a question came about now. Let me deal with that question. The question goes as follows. Can maintenance be reduced because he had another child? That's a very interesting question. And I'll answer the question, and a question which arises regularly. The quick answer is yes, it can be reduced for the sole reason, and it doesn't necessarily have to be reduced. It can be reduced. It's possible that it can be reduced. It does not always mean it should be reduced, or there are valid reasons for the reduction. Let's say, for argument's sake, let me first deal with a scenario where it will not be reduced, and then we can go further from there. Let us say the father in this scenario has to pay child maintenance, and child maintenance is an amount of 500 Rand per month. He clearly can afford it because he earns 50, 60, 70, whatever amount of 1,000 Rand per month. So it's affordable, and he can do that. And the mother can afford it as well. Let us say tomorrow he gets another child. Or 9 months later gets another child. The obligation or the people who is obliged to care for the new child is of course him. So the expenditure would obviously incur, and obviously the mother, the new mother of that specific child. However, if the amount is insignificant, he's paying for his new child 300 Rand per month, 200 Rand per month, and he's still earning 50, 60,000 per month. Are we going to deal with rands and cents over here? So under those circumstances, I would say, there's no valid basis to approach a court to reduce it by 100 Rand if you really can afford it. But having another child, nobody limits you to have that, to do that. If you have one child, you are not limited not to. Nobody can tell you can't have another child. That's just being silly. People go on with their lives and move on with their lives. You cannot say because I'm paying maintenance for my one child, which I had in a previous relationship, I am limited in having new kids, other kids, because I must continue paying for that. That's not how the world works. But you obviously have scenarios where fathers are fathering kids left, right, and center, and they do not pay maintenance for any of them. The principle would be applicable here would be the father earns so much money, he has one child, which you always maintained in terms of an agreement, a court order. Now he has a new child. He is incurring more expenditure. He is. And we have to look at the facts of the matter. If at the end of the day he's working very hard and he can only afford to pay for his first child 500 Rand per month, now is another child. He has a legal obligation to maintain that child. Should the new mother go to the maintenance court, the court will make a maintenance order for him to pay maintenance for that child. So what do we do then? In order for him to earn his salary, he has to buy clothing for his work, he needs food, he needs a place to stay, and so on. So the long and the short of the matter is, yes, it is possible that the court can reduce the maintenance for the first child based upon the fact that he has a second child. But it all depends on the mathematics, the economics, and so on. If he is incurring additional expenditure for the second child, we can't, the law doesn't say, okay, second child, you have a lesser right to maintenance from your parent, like the father, because the parent has a first child, or the first child has a better right. We have to look at all the mathematics, look at all the equations, the income, expenditure, the father's, what he does, does he smoke regularly, does he consume alcohol a lot, Does he entertain himself a lot? So those are the factors we have to look at, and that's how a maintenance inquiry works. We look at the man's lifestyle. But if the man earns 1,000 rand per month, he bare minimum, whatever he earns, he goes to his accommodation, which is totally reasonable, transportation, work, etc., food. So that's bare minimum, and because he earns 1,000 rand per month to the bare minimum, he has 300 rand available to maintain for maintenance, to pay for maintenance. How a second child came out about. He only has a 300 rand to play around with. Can we say that the second child should not receive any maintenance? We cannot say that. That will be improper. He's not curtailed from having maintenance. But he is only 300 rand. He doesn't waste money on cigarettes, on entertainment. Salary goes to small room accommodation, or shared room accommodation, to a limited amount of food, and that's it. And it's 300 rand left, which he initially paid for the first child, but now is the second child. That's a scenario if I should apply it, whereby there will be grounds for a reduction of paying maintenance for the first child. Yes, we can say he must find a better job and a new job. Yes, and he's doing that, but that's a scenario. That's my general answer. Obviously, the facts might be totally different where the commenter is concerned. There might be a totally different financial scenario whereby the person who is paying maintenance can afford it, and he is just hiding behind the fact that he is now a father of a new child. We need to also look at the circumstances of the new spouse. How are they married? If he married a wealthy woman, income into a property, he became wealthy overnight. The new woman, the new wife of the father, has a legal obligation to maintain the father and the minor child as well. So those are all the factors that we have to look into. Oh, I have another comment over here. Says, thank you. Wow, a lot of comments came in now. I should keep my eye on this one. I have another additional question. Can maintenance be reduced because ex and new wife ran up more debt? My Sunday expenses are high because he has special needs. The maintenance should not be reduced on principle that someone now ran up debt. Let's say the maintenance is 100 rand a month, but this party goes to the retail stores and buys an item of clothing on credit every month for 100 rand. And because he or she does that, they are incurring more debt each month. That will obviously be improper. If you look, so the maintenance should not in principle be reduced. There are ways of servicing that specific debt. And of course, if we on principle say that it can be reduced based upon debt, what are we telling the world? What are we telling people? That if you don't want to pay maintenance, incur debt, buy nice clothing, buy nice items and so on, and then go to the maintenance court and say, okay, when the order was made, I had to pay 100 rand because I was only in debt of 20 rand, minimum debt. There's 1 or 2 accounts. But now I've lived lavishly. I went on holidays on my credit card. I purchased nice clothing. And now I am 5,000 rand in debt. The maintenance amount is 100 rand. My salary is 1,000 rand. I'm in debt. What are we saying here? We are telling people that it's fine, to incur a great amount of debts, and at the same time put the responsibility now on the other parent to maintain the child. Because in that scenario, the mother would be left with the brunt to care for the child based upon the father living a good life, that got himself into debt. Where I'm going to with this is we need to look at all the circumstances, and if the father's debts are not reasonable, not justified, if his debts were based upon, paying medical expenses for the child, was for his personal medical expenses, something very important that is justifiable, that's a different ballgame. But if it's silly debt and debt of living a lavish lifestyle, the court should take a robust approach and say, sir, the maintenance order still stands. You have to pay the maintenance order. If not, you make a plan. Go into further debt and pay the maintenance order, but make a plan. So my quick answer over there is depends on the circumstances, but generally, debt should not be a reason why the maintenance order should be reduced, especially if the child has special needs. Thank you for that question. I have another question. If the parent kids' time is split 40-60. 60 to the mom and 40 to the dad. And he says he should pay maintenance. Also, if he says he can't pay, can the parents be held liable? Can his parents be liable? Held liable? I presume the general question would be, can paternal grandparents of minor children be held liable for maintenance? The general rule or the law, grandparents can be held liable for maintenance if their specific kids can't afford to pay the maintenance. Therefore, if a father can't afford to pay maintenance, and then they can approach his parents to pay maintenance. But I also believe then you have to look at both sides, the paternal and the paternal side of the scenario. Yes, you can. If the father truly cannot afford to pay the maintenance, then you may approach the maintenance court. You first need to deal with the inquiry regarding the father. Okay, I see the person says he shouldn't pay maintenance. No, he should pay maintenance. Okay, but let me first deal with the issue concerning claiming maintenance from grandparents. You can't go directly against the grandparents. That doesn't make sense. Grandparents live their life. They've brought up their kids. They've paid their support. They've paid their dues. If, however, there's a scenario after a full-blown inquiry and it comes about that the father cannot pay child maintenance, or he can pay limited child maintenance, but the child requires additional maintenance. And also we looked at the circumstances of the mother. Then, under those circumstances, the inquiry can go into whether or not the father's parents can come into the picture and assist in paying the child maintenance. But in my view, then we have to look at both sides of the scenario. We also have to look at the maternal side. It will be unfair for the paternal side to only be responsible for that shortfall in maintenance without looking at the maternal side, despite the maternal side being extremely wealthy. So therefore, for argument's sake, let us say the child cost 100 Rand. And the mother, based on her salary, she can only afford to pay 20 Rand. Now they do an inquiry and they find out that the father can only also afford 20 Rand, but the child requires 100 Rand. So there is 60 Rand missing. Would it be fair to only proceed against the father's side for that shortfall? No. You need to now do an inquiry on both paternal and maternal grandparent side. But this specific father says now he does not want to pay. That's nonsense. You can't say that. Even if the mother cares for the minor child 60 and the father 40% of the time, how would that generally work is maybe the mother cares for the child Monday, Tuesday, Wednesday, Thursday. That's 4 days, and the father has the other 3 days, and so on. And then the mother again cares for the child Monday, Tuesday, Wednesday, Thursday, alternatively. But if that scenario does apply, we have to look at the circumstances. We still have to look at the income and expenditure of the parents. Despite the father caring for the kids 40% of the time, if, however, he earns much more than the mother, and we work out it proportionately based upon the expenditure which the father has and based upon the expenditure which the mother has, there would be a legal obligation for the father to pay the mother maintenance. However, if the mother earns much more than the father and she has much more wealth, remember, maintenance is not only determined based upon your income, it's based upon your assets as well, your means. If the mother earns, for example, 10,000 Rand per month and the father earns 5,000 Rand per month, but he cares for the kids 40% of the time, and all else is equal, then I would say there's no legal obligation for him to pay maintenance to the mother. There might be an obligation upon the mother to pay the father maintenance to maintain the child, because he's caring for the kids, he's incurring expenditures for the kids, but the mother earns much more than him. So that's scenario is possible. I look at maintenance matters as mathematical equations. I take a spreadsheet, I analyze it from that basis because it needs to make logical sense at the end of the day. if the father is looking after the kids 40% of the time, he still has to provide a room, electricity, water, Wi-Fi. Those are now the new things now that's coming about in maintenance application forms, and so on. So he needs to still provide those provisions to the minor child. And the mother needs to do exactly the same. So the child has two households. The mother's electricity bill might be a bit more, her food bill might be a bit more. But if she's earning triple the father's salary, then she will have to pay the father some maintenance because he's caring for these kids for 40% of the time. So therefore, take a spreadsheet, work it out, what's reasonable and logical. Based upon that, you can determine. But there's no principle applicable that if one parent, even so, if the minor children are shared equally between the parents, 1 week, 1 week, 1 week, 1 week, it's still possible, and it happens regularly, where one parent has to still pay maintenance towards the minor child to the other parent. So I hope that answers that question. Okay. I have an additional question. Okay, going to the previous question regarding can maintenance be reduced based upon debt. The additional comment is, if debt is personal loans and vehicle debt. No, man, they had a choice, personal loan. What did he do with that money? I didn't know what he done with that money. And vehicle debt is for vehicle. You can't hide behind those specific items not to pay maintenance. As I said now, there are scenarios, there are situations where it makes sense. But why must one party be prejudiced because you decided to live a lavish lifestyle or be irresponsible where debt is concerned? Like a vehicle debt, for example, if you need to have a reasonable vehicle, because you work in a dangerous area and you need to have this vehicle, otherwise you cannot work, then obviously you're allowed to have that specific debt because you have to pay it. But vehicle debt will be a monthly payments, monthly installments. Alternatively, if you took out a big amount, you took out a personal loan and you purchased a vehicle, and now you have to pay that loan and something happened to the vehicle. Where I'm going to with this whole answer is you need to look at the matter logically and reasonably. And if it's a reasonable debt, of course, he has to incur it. You can see it as an expense, a monthly expenditure. But if, for argument's sake, the guy earns 10,000 rand per month, he was flush at the start of the year, now he's in debt of 100,000 rand per month, 6 months later, clearly he was lavish and he wasted money. The court will have to consider that, and the court will consider that, and under those circumstances, he must make a plan to pay the debt, but he needs to continue paying the child maintenance. I have another comment regarding the issue of grandparents. No, this is a total different comment. If grandparents are not SA citizens and do not live in SA, can you claim maintenance from them? So the basic scenario would be, let's say mom and dad, father is most probably an American. He comes to Cape Town, they're in a relationship with a mom. She has a child. He goes back overseas, he passes away. That could possibly happen. Or he goes overseas and can't find him, or he doesn't have any reasonable wealth or income. Now you want to claim maintenance from the paternal grandparents. Now, those are tricky questions to answer because we have to go through a checklist first. The first question, the first thing I have to mention to you is South African law or South African courts or the South African government cannot advise another government what to do. South African court orders are not applicable in other countries. Countries are autonomous. Our court orders are only limited to South Africa, and the same way European, American, Russian, Arab countries, their specific orders are applicable to them. It makes logical sense. Imagine you get someone goes to America, lay a complaint against you, an American court gives a warrant of arrest, and South African law must just follow the order. Countries are autonomous, and one country can't tell another country what to do. There are, of course, agreements between countries. For example, like extradition. If someone commits a crime in one country, in South Africa, for example, and he flees to a different country, there may be an agreement between South Africa and that country whereby they will send that person back to South Africa. But that's based upon, obviously, upon an agreement, an international treaty, and so on. The same applies to child maintenance. You can't make a maintenance order in South Africa and expect the maintenance courts that side to enforce it and execute it. Who are we to tell them what to do? I mean, they got their own laws, their own court orders, and so on. And the same way, if they send a court order to South Africa telling us to do something, we won't do it. We don't have to. Now, international maintenance, or the law that applies to that, is the Reciprocal Enforcement of Maintenance Orders Act, the REMO Act. You can Google it, it's REMO, or Reciprocal Enforcement of Maintenance Orders Act. Type it into Google and you should find one. I know the Department of Justice has a website dealing with that. There are certain countries around the world who entered into an agreement, South Africa is one of them, signatory countries, where the agreement basically says the following: we will assist each other in enforcing maintenance orders. The long and the short of it is, if there's a maintenance order in South Africa, you can have that order registered in another country. But there needs to be an agreement between the two countries. So I think South Africa has agreements with a few states in the United States of America. The basic principle on how it works is you apply to your local maintenance court. So the father is in the States, the grandmother is in the States. You live in Cape Town. You go to your local magistrate's court, Cape Town, Wynberg, Mitchells Plain, wherever it is. You advise him that the other party lives in the United States. The maintenance officer will go onto the website of the Department of Justice and find out, is this a signatory country? He decides, yes, it is. Wonderful. An inquiry will take place. Remember, we do not have any of the father's details over here. He's in the States, so we can't deal with him. An inquiry takes place. We deal with the issue concerning paternity, details of the father, what the child cost, what the mother's income is, her expenditure. So we do a full-blown inquiry here, but a one-sided inquiry. We don't listen to the other party because we do not know who the other party is, or we do not have jurisdiction over the other party, and he's in different province in a different state, in a different country. That's done. So the maintenance court in Cape Town or in South Africa will now decide, we believe that a reasonable amount of maintenance for a specific child would be amount of 1,000 Rand. I'm using simple figures here. That specific order and all the documentation, supporting documentation through diplomatic channels will, for example, diplomatic channels will be the Office of the Family Advocate or Director General in government, whatever person that is designated in the relevant legislation. So the REMO Act will actually explain that to you. It goes to that office, that department. It gets registered with them, and it gets sent via diplomatic channels to the other countries' receiving party, designated party. That could be the Office of the Family Advocate if they have one in the new country, the minister, whoever it is. So each country has a different person. They'll have their own act in place. That documentation goes there, and ultimately, I would presume it goes to the relevant court, the maintenance court or the family court, depending upon the country. They will call the father in, and they will do their own inquiry. They will look at the documentation that the mother has provided. They will look at the documentation that the father provides, what he says, his income, his expenditure. They'll do an inquiry that side, and then whatever order they make that side will be registered there, and of course a copy gets sent down to South Africa via diplomatic channels again. That is how the Reciprocal Enforcement of Maintenance Orders Act works, and how international maintenance orders are made if you live in South Africa, and vice versa as well. I was lucky or maybe experienced in dealing with both scenarios, whereby someone in another country applied for maintenance, and I was involved in Cape Town, assisting the process, where the father lived in Cape Town, and at the same time where the mother lives in Cape Town and she's applying for maintenance against the father in a different country. So that's a practical aspect of it. We can't necessarily answer how the other country works. You'll need to look at their specific law. Like we have the Reciprocal Enforcement of Maintenance Orders Act in South Africa. The states, whatever other country, they will have their own specific laws. So answering this question from the specific commenter, if grandparents are not SA citizens and do not live in SA, can you claim maintenance from them? So the first way to answer the question, number one, is it doesn't matter if you're an SA citizen or not. If you're not an SA citizen in South Africa and you live in South Africa, you can claim maintenance from that person. So you're not immune from the maintenance court, unless you maybe like a diplomat or whatever the case may be. Going forward, you need to look at the Remo Act, to the specific commenter, find out if South Africa is a signatory to the Act. If the father lives in South Africa, the inquiry must first be finalized against the father. Then after that inquiry, and you still require more, the court here locally needs to process that inquiry in the States, like by diplomatic channels. If the father is not in South Africa and the father is not being able to be found, and you only have the details of the grandparents who are living in the States, I'm using the States as an example, you need to make an application to the local court, and the local court will, through diplomatic channels, process the application. So that's a long and short of it. Please Google it. REMO, or Reciprocal Enforcement of Maintenance Orders Act. The Department of Justice got a nice, I think you can download the Act. And at the same time, there is a list of countries with whom South Africa has a reciprocal agreement with. So the commenter says, thank you, you are welcome. I do not see any additional questions. If there are any, please pose it as soon as possible. I'll have to leave this webinar quite soon. I do appreciate all the comments. It's always valuable to have people comment so that I can answer practical questions, as opposed to just talking and advising you of what I think is reasonable or rational to speak about. But at the same time, the viewer might not find it rational or reasonable or relevant to his or her situation. Therefore, if you do provide me with live questions, I can at least assist one person, and maybe many other people with the same problem can benefit therefrom. Otherwise, tomorrow morning, I'll be back online. It will either be 9:30 or 10 o'clock. If you have any questions, please feel free to pose it. And as I mentioned earlier on, you might later on watch this video on a different platform, Our Lawyer, for example, but please like the Advocate Mohammed Abduroaf Facebook page. That is a page from where we are streaming from, and there will be notification on that page. Type out the questions today, and tomorrow when I go online, it will either be 9:30 or 10 o'clock, more than likely 9:30. The moment I go online, pose the questions so we can get immediately on that. Have a wonderful day, and I hope to see you tomorrow. Thank you. Good morning. Welcome, everyone. Thank you for joining our live webinar. We are streaming live on Facebook Live as well. And also those of you on Zoom, thank you for joining us. It's always good to have some live audience. So if you look at the screen, the guys on Zoom, you'll only be able to see me and, of course, the questions which I'll be posing soon. And the guys on Facebook Live will be able to see a screen that's different from what you have. Nonetheless, this is the way we're going to deal with this interaction today. Perfect. Someone commented, we can hear me loud and clear. Wonderful. So there's two ways of interacting with me. Yes, we have questions on the whiteboard. I shall deal with all those questions. There are quite a few of them, about 15 of them, which I want to get past in the next hour. If you're on Facebook Live, you can leave a comment and I will look at that and I shall deal with that as well. And for those of you on Zoom, please remember you are allowed to deal and interact with me live. So if you want to say something, if you want to speak to me, please feel free to request and unmute, and then I'll unmute you and we can converse. Remember, your face won't necessarily be on the video, so I advise you, in case a technical glitch might appear, to, how can I explain to you now, not activate your camera. Many of you are doing that, and that will obviously assist us in, trying to be anonymous and so on. So wonderful. If you have a question and you want to interact with me live, feel free to do so on Zoom. And put up your hand and you're welcome to do so. Yeah, the screen is a bit messy, but that is fine. So on Zoom,
let me do one thing quickly. Let me share the screen, and the screen will obviously be the questions that were posed. Okay, wonderful. Let me sort something out here. It seems to be coming out a bit funny when I do that. Nonetheless, let me admit these people. Okay, sorry about that. Let us stop it for now. Okay, let's deal with the first question, and feel free to interject at any time. Pose a question, put up a hand if you're on Zoom, and we'll deal with that. Okay, today's topic, child custody, child maintenance, and divorce, live Q&A from myself. I'll hopefully be able to assist you and guide you on the specific topic. About myself, I'm an advocate practicing as such for the last almost 20 years. So I'm a family law expert. I deal with a variety of family law legal matters, ranging from child custody, guardianship, relocation, maintenance, domestic violence, and everything. Divorces, I deal a lot of divorces as well. And that's where my expertise comes in. Many people, they cannot afford legal representation or legal advice, and that's the purpose of this webinar. And at the same time, many people can afford legal advice, but they don't get a chance to actually, get some insightful advice regarding the specific matter, and that's the purpose of this webinar. So the first question goes as follows. It's from Gauteng, and it is, my wife's attorney, who is handling the divorce and is a ACER, I presume, meaning plaintiff. And the person said, sorry, do not know the English. I found is lying to the High Court and impersonating the magistrate to cancel my contact to the son. So the person obviously wants to know what type of advice do I have for the specific person regarding that. Obviously, long and short of the matter is, you're not allowed to impersonate a magistrate. It's obviously a criminal offense. So the first issue, the first thing we need to do is try to get rid of this magistrate, or try to expose the magistrate, or this person who's trying to impersonate himself as being the magistrate. So I cannot maybe take it further, because that would most probably be the quick advice to you to deal with the matter on that specific basis. Lay criminal complaint, speak to somebody, and hopefully they can make some noise and they can deal with a specific issue. Let me go on the Zoom one more time and try to share the screen. My apologies for this. I've never done this since March. That's the last time we've done these webinars. Okay, let's do that. I'm seeming to still have an issue, a problem with this. Nonetheless, my apologies for that, and obviously the email questions will be emailed to each one of you afterwards, and you'll be able to see this later on as well. Ah, there we are. No, sorry, there we are. Let me get past that. Okay, then the second question, let us deal with that quickly. The second question that was posed, an interesting question, it goes as follows. Separated but married with 3 kids staying with me. Looking for financial help and a parenting plan from the father of the kids. I've initiated maintenance against the father, but his sister is paying the school fees. So that's what the person from Gauteng commented and stated. I do not have any additional information, so I'll try to deal with that. And hopefully I will be able to be of some assistance regarding that specific question. Okay. Regarding child maintenance, if a party is separated from the other parent and you're not living together anymore, maintenance will obviously have to be determined based upon your means. Okay, so if somebody is earning quite well, automatically what that means is that specific person will have to pay more child support or support the child more than the other party. That makes logical sense. So here the parties are separated, they were married for 3 years, and the kids are, they're married, and the kids are obviously living with the one party of their 3 kids. Now he's looking for financial help, and obviously they're tied to enter into a parenting plan. He initiated the maintenance matter against the father, but the sister is paying the school fees. That's the information I have, so I'll try to be, creative and try to assist the specific party over here. The sister has no legal obligation to pay the school fees. Obviously, the sister is paying the school fees on behalf of the specific parent. Under those circumstances, that is fine, and it can be seen that the specific sister is paying the maintenance, or the specific parent is paying the maintenance, but the sister is doing it on behalf of that specific parent. My advice to you is unpack exactly what the needs of the child are, or the kids are, the 3 children are. Work out exactly what your specific income, potential income is, and also the other party's income. And that is most probably the starting blocks on where this matter will have to be dealt with or, action from. Once you've determined that specific date and that specific information, then you'll be in a much better position in order to advise the maintenance court on coming to a fair conclusion regarding child maintenance. So that's basically the advice I have regarding the question that has been posed from the specific commenter. Let me change the screen quickly. Okay, there is it. Let us move on. Please, those of you on Zoom, you're welcome to interact with me live. I have no problem with that. And we can hopefully be able to advise and assist you properly. Okay, the third question we received is from KwaZulu-Natal. The question goes as follows. Can the father change the maintenance amount according to his own calculations to exclude things he thinks is not needed, like exclude the nanny's fees, even though I need her because I work? Now, this is a challenge people will have. If the parties cannot come to an agreement regarding child maintenance, it's not for one party to decide, I make the decision as to what is fair and reasonable. No, that doesn't work that way. Maintenance, as I mentioned earlier on, is determined according to the party's needs, their means, the child's needs and the child's means, and so on. So therefore, when it comes to the scenario, you might say, I require the following, and the father should be paying this, and maybe he should not be paying that, or maybe he should be paying more, I do not know. So I always advise people, if you want to have a fair assessment on child maintenance, you need to have this matter properly resolved in a maintenance court, in a proper forum. So here we're having a situation where the person believes he's entitled to, for example, the nanny fees, but the father believes he's not entitled, he should not be paying that. I do not know, my guess is as good as you. Maybe you're earning more than the father, maybe you're earning less, or maybe the father should be paying that. The bottom line is, if the parties cannot come to an agreement, it's silly for you guys to go on like this, where the father believes he must pay for this and the mother believes he must not pay for this, or whatever the case may be. Try to resolve it as quickly as possible. If you cannot resolve it, one of you have to take the matter to the maintenance court. And here, obviously, it will have to be the mother. It's possible for the other party also to take a matter to the maintenance court if, for example, there is a maintenance order in place and you want to vary that specific maintenance order. From KwaZulu-Natal, I hope I answered your question. That was the third question. If I did not answer it properly, feel free to put up your hand if you're on Zoom now at present, and add additional comments, and hopefully I'll be able to assist you and advise you accordingly. I'm seeing we are having some technical issues here regarding the screens. Hopefully in part 2, next week and Saturday, we can sort out all these glitches. But thank you anyway for partaking. Question number 4. It goes as follows, and this question also arrived from KwaZulu-Natal. The reason why I'm mentioning the province is because it will just connect you to the question. Many people, they pose these questions, but they do not know, later on, they do not know if they pose a question or someone else pose a question. Of course, I copy these questions verbatim as it was received from you, with the spelling mistakes, with the grammar mistakes. None of us are perfect. So you can just double check later on if it was your question. Question number 4. How do I find my ex-husband who has immigrated to New Zealand? I think it's immigrated. He has defaulted in child maintenance, unlike many other parents, feel exhausted, and the justice system does not help either. Now, this is a bit of a challenge because here we're dealing with international maintenance. If a party immigrated to a different country, now obviously South Africa courts does not have power in a different jurisdiction, the same way that the Cape Town court doesn't have power in the Johannesburg court. The High Court in the Western Cape does not necessarily have power to the Johannesburg court, but here we're dealing with countries whereby how can a South African order be implemented in a different country? But there is something called REMO, Reciprocal Enforcement of Maintenance Orders Act. That is, my apologies. It is an international agreement between South Africa and various other countries. You will need to determine whether or not South Africa has an agreement with New Zealand. If there is an agreement with New Zealand, you can enforce a maintenance order made in South Africa to another country, to another signatory country. So you need to look into that. However, if South Africa does not have an agreement with New Zealand, unfortunately, there's not much you can do unless he has assets and property in South Africa. I hope that answered your specific question. If I have not, please let me know. Okay, somebody put up their hands. I see somebody wants to ask a question. I will unmute that person and hopefully we can deal with that question live. Please go ahead. I'm unmuting you. Or you may unmute yourself. There is it. You're welcome.
Good morning, Advocate. How are you? Good, thanks. I have a question regarding primary residence. So I've got divorced like 6 years ago, and my ex and I, we reconciled a few months after we got divorced. But at the start of this year, I decided to move back home to KZN. It wasn't working. So we have an 8-year-old together. And, the advice that I was giving moving from Joburg to Durban was that I could. And I've informed him I'm in KZN. However, he's now challenging primary residence. He would like my son to be with him in Johannesburg. We've had our inquiries with the family advocates. I just wanted to know, a bit of insight as to, grounds in challenging primary residence. When I left, I left without a job, but, I'm in a position now to provide for my child. So my son is in Joburg with him based on the interim order. He had to go back to his old school and he's with his dad. So now I'm just waiting for outcome from the family advocate. I'm not sure if I should, be in contact with them to just find out how's it going, because they did advise me that, they're in a backlog with COVID and they under enormous pressure. So I don't want to come across as being too pushy at the same time, but, I need something for now because, schools are closed because of COVID, but at the same time, primary residence is being in dispute. So any advice for me on that one?
Yeah, let's stay on the line quickly. Let me just get this right. So after you guys divorced, you were the primary resident, primary caregiver of the child while you were living in the same province with the father. Since you've moved, the interim order stipulated that the child should now, at least in the interim, remain with the dad.
Correct.
You can stay online. We can stay online, or we can, of course, interact with me via Zoom a bit further. So the challenge you have here is when the court deals with a matter regarding primary care of a minor child, the court obviously focuses on what's best in a minor child and his circumstances, etc., not necessarily what the parents want. The advantage a father here obviously has is that this child's school is in his province, and it makes logical sense for the minor child to remain there. You need to obviously now be strategic if you want to have primary residence of your minor child. You need to now start being proactive in the sense of, okay, I want my child to come to live in my province. What would be in his best interest? Obviously, making sure there's an adequate school for him to stay in there. What are the advantages a child has by living with me? Of course, I've always been his primary caregiver. I know when he gets ill, I know his moods, I know everything about him. So those are advantages of having you as a primary caregiver. The stickler here obviously is the minor child's school. Then also the other aspect regarding the father, can he adequately care for the minor child as well as you can care for the minor child? Obviously not. You can do a better job where that is concerned. So you need to present that specific scenario which I mentioned now to the family advocate, and let the family advocate be convinced, you know what, okay, yes, the child's school is here by the father, but it will be holistically more advantageous for the child to live with the mother. He will be better cared for, better looked after. If the father has more money, that is fine, but he can pay more maintenance to the mom. But at the end of the day, you must just make a very good argument to stipulate, yes, the child will be deprived at least by leaving his old school, but he just has a good school. Children adopt, and there's no reason why the child should not be in my province, live with me, be cared for me, and he'll thrive there from. I hope that answers your question.
Yes, thank you very much.
I see there's another hand. I think your hand is coming down. Any other hands up there before I go with the next question? You're welcome to put up your hand and I will unmute your microphone, or you can unmute it yourself, and you're welcome to pose any additional questions to me. Let us carry on, and hopefully soon I'll see somebody's hand up to pose another question. Question number 5 from the Northern Cape. If my ex and I split, we were never married, that's fine, and he now has decided to get married to someone else. Does he and the wife have a better chance of getting custody over me, a single mom? Okay, one of those difficult questions to answer because I do not have too much data coming here, but I presume that the mother is the one who's primarily caring for the minor child and the father is the one that's remarried and he has contact quite often to the child, but he's not the primary caregiver. That's why there is now a custody dispute regarding this. In principle, there is no reason to stipulate that because a party remarried or married to somebody else, they are in a better position to care for a minor child. That's nonsense. That there's no principle where that is concerned. I run many cases whereby the reason why we were successful in receiving primary care for the one party was because the other party met someone else and remarried. There's a lot of things that can play a role. For example, the other party might have the new party, the step parent might have, for example, kids from previous relationship. The house might be crowded, the room might be small, they might be arguing a lot, and the mother situation is obviously better and more reasonable under the circumstances. So under those circumstances, I do not, on principle, stipulate that that is necessarily an advantage. It could be, depending upon the circumstances. It could also be a disadvantage. You need to focus, the person from the Northern Cape, you need to focus that you can care for the minor child better than that specific scenario. That is what the court will ultimately have to decide. Which parent can care for the child much better, considering all these factors. And if you can show that, and you can show to the court going forward, I will look after the child much better, then obviously the court would make that order in your favor. That's question number 5. I have a question on the Zoom. It says the following. Is a father allowed to withhold maintenance when the kids visit for a few weeks? One of those difficult questions because I believe maintenance are mathematical equations. The long and the short of the matter is no, but it also depends upon various circumstances. For argument's sake, if the maintenance is being paid for certain type of expenditure, for example, aftercare, extramural activities, certain expenditure which are not being incurred at all during this time that the minor children are with the father, then clearly it doesn't make logical sense for the father to continue paying those specific expenditure. At the same time, the argument can be made if the child is with this father now for a few weeks, and the father now has to spend a lot of money on food and certain things which he has to obviously incur because the kids are with him, he can bring up an argument, the kids were with me for the last few weeks, I spent so much more money on them because, and the mother, the other party, who is a primary caregiver, saved a lot of money where this is concerned. If it's for a few weeks, like 2 or 3 weeks, I would say no, there's no case to be made because at the same time, many times the primary caregiver incurs more money than what the maintenance order says, more expenditure, my apologies, what the maintenance order says. So it doesn't necessarily cut there. But if it's for a long period of time, like 2 or 3 months, then I can strongly argue that the person who is supposed to pay maintenance, who now cared for the minor child for the last 2 or 3 months, would have a very good case to stipulate that during that 3 months, I paid for all the water, the food, the clothing, the accommodation, everything, and the other parties saved there. There needs to be a relook regarding that specific amount. I do not think it will be correct to stipulate that you can withhold. There needs to be a discussion and an agreement. And if the agreement cannot be amicable or agreed upon, the parties can't agree to it, then obviously one party will have to go to court. So if the maintenance order stipulates that the father must pay, and he feels now, okay, it's now 2 months down the line, he must still continue paying the maintenance because they can't come to an agreement, then he needs to approach the maintenance court for variation of the order. And he can have it backdated as well. I hope that answers that specific question, and if I did not answer it, you are welcome to pose an additional question to that. Question number 6 from the Western Cape, where I'm from. Son had a case at the High Court, Cape Town. He stopped at the mother, put the child on question through many things. I asked the paternal grammar, I presume, went forward. The advocate that advised handing the current case said I. In all honesty, I copied and pasted that. I didn't know what it entailed, but that's a question from the person from the Western Cape. Question number 6. If you have any additional comment to that, question number 6, just leave me a note and I will deal with that a bit further. I do not know how to answer that question. Let us deal with question number 7 from KwaZulu-Natal.
When your kids and you are still on the family trust, what are the benefits and what are the benefits, okay? What happens when they divorce? Please may you discuss family trust benefits. Okay, I'll be short, and I told myself, and I told you as well, I'll deal with all questions posed. A family trust will only be to your advantage and to your benefit if there are money and assets involved in it. That makes logical sense. But the one true advantage would be that the assets of a family trust is not the assets necessarily per se of the beneficiaries or the trustees. It's separate from that. And if there are assets in the trust, and monies that can be withdrawn on a monthly basis, you can look after the beneficiaries of the trust. So generally, the father and the mother will open up a trust for them and the minor kids. They must probably put some money over there, whatever the case may be. Should any problems happen regarding the mother and the father's assets, they become insolvent, the money will still be in the trust, and the trust can continue looking after them. At the same time, should something happen to the parents, whatever the case may be, the trust can still continue looking after the minor kids. So those are the advantages of having a trust. It's separate from the estate and the assets of the individuals. And it is a working structure in the sense of, even if the parents are no longer there, it still has life. It still has to look after the beneficiaries. For example, it can stipulate it should continue paying the interest or the profits or the rental received from the property that belongs to the trust to the minor children until they turn 21 years old or self-supporting. And when the younger child turns 18 years old or is self-supporting, then automatically the trust can be dissolved and all the proceeds can be, or the assets can be distributed or sold and distributed to the beneficiaries. Okay, if you have anybody from the Zoom, you're welcome to pose any questions. I'm happy to take your, put up your hand, and I'll be able to deal with that. Let me have a look at Facebook Live. There is no movement there, so that is okay for now. We are ending this webinar on the dot at 12. I had an agreement with some construction people. They are knocking here, so they'll be keeping quiet until 12 o'clock, so we'll have to wrap it up until then. But I'm sure we will do well. But that's why, if you have any questions, live questions, please pose it now and put up your hand. Let us deal with question number 8 from KwaZulu-Natal. Okay, that's great. KwaZulu-Natal is quite active today in this webinar. How do we go about using a state lawyer if one is unemployed? Okay, state lawyers, legal aid, that's what I'm hearing here. State employed. It depends. I mean, the Legal Aid Board does not deal with all matters. Of course, if you are an accused in a criminal matter, they will definitely assist you. But maybe, for example, I'm just speaking for example, let's say somebody knocked into your car and now you want to sue a third party, they might not assist you regarding that. But for legal aid, you need to go on the website, find out where they are, your nearest legal aid department office. Go to them, they'll do a means test and they'll determine whether or not you qualify. If you are very wealthy, of course not, you will not qualify. Why should they give free legal service for people that are extremely wealthy? If you cannot afford legal representation and require legal representation, for example, a criminal matter, they will appoint somebody to assist you regarding that. So I hope that answered your specific question. Okay, I have a question here. Let me deal with that quickly from Gauteng before we go on to question number 9. Another question. I'm a single mother, 2 oldest from previous marriage. Okay, the youngest one's father claims to be unemployed, although I see him going to work. He also owns a house, pays a bond, and he can easily live with his retired mother. Okay, he changes the maintenance amount according to what he thinks he can afford. Every time this happens, I come short because I have to still pay the expenditure. Okay, that is a question over there. Yeah, that's a question, and I'll deal with that question now. So bottom line is, the father says he's unemployed, he can't afford the maintenance, but he works, he pays a bond, and he can live by his mom. Now he decides what he wants to pay, and the bottom line is the mother cannot, continue with a month because every month comes, she's short, etc. She needs to approach the person on Zoom that left a comment. You need to go to the maintenance court. You need to resolve this matter as soon as possible. If there is a maintenance order in place and it's paying short, of course, it's a criminal offense. They should do something about it. And we all know being in contempt of a court order, we've seen it in the media, is quite serious. If there is no maintenance order in place, bottom line is approach a maintenance court as soon as possible, and they'll have to do an investigation and inquiry. It needs to be done. It might take some time. It needs to be done, and the maintenance court will make a decision as to what would be a fair amount, and it will be an order of court. So the father will be forced to pay that amount, and he owns assets. I see he owns a house and so on. So that can also ultimately be sold to pay for the child's maintenance. So that's important to note. I hope I answered that question. The bottom line is you need to do something about it. Okay, I have another live question from the Zoom. Can a Rule 43 be brought to the respondent after 3 talaqs been given? If I'm working, can your long-term savings be taken into account as well, like retirement? So I think that's a talaq. Obviously, we're referring to Muslim marriages here. Muslim marriages are not recognized as valid civil marriages, therefore your assets of the parties aren't necessarily taken into consideration. And there needs to be some type of a legal basis as to why you want to bring your assets and your retirement investments into the picture. Okay, so the question over here is on the child custody. It goes a bit further. Let me go further. If a person has a mental condition and has a history of substance abuse, can the non-primary parent have sleepover contact? Okay, let me first deal with the first question. I think the same questioner has 2 questions. A Rule 43 is a application in the High Court for dealing with interim maintenance, contribution towards legal cost, and dealing with care and contact regarding minor children. Those are the 3 things that Rule 43 application deals with. The other parties have divorced, have resolved their marriage. I do not see the basis upon why a Rule 43 order application will necessarily be made. The marriage is over. If there's a dispute potentially regarding the marriage or the issue regarding that, then of course a Rule 43 application could possibly be made because it's a dispute regarding the marriage. However, if the marriage has been resolved, that's it, and in my view, the parties will have to continue with their lives. Regarding the second question, if a person has a mental condition and has a history of substance abuse, can the non-primary parent have sleepover contact? So I would imagine the parent, there's 2 scenarios here I'm seeing here. Either the parent who is a primary caregiver has those specific challenges. That's unfortunate. And then the question is, can the non-primary parent have sleepover contact? Sleepover contact either way, whether or not you have a mental condition, whether or not you're abusing substance, etc., it must be in the minor child's best interest. Full stop. And I'll be blunt here, and I'll talk as a lawyer. It does not mean, in principle, that if somebody is abusing substances, he or she is not allowed to have contact or sleepover contact, okay? Because there are different levels of substance abuse. If the substance abuse takes place away from a minor child and at days and times when the minor child is not with a specific parent, then of course the legal answer would be that care and contact would not have to be limited based upon something that happens at different times. However, if the person is abusing substances and so on, at times when he or she is not having contact with a minor child, but it affects the contact ultimately, then of course it's an important factor. So what the court looks at and what the law looks at is not necessarily whether or not you're abusing substance, because that's not how the law works. We don't say because of this, we checklist. We still have to look at the matter holistically and properly. If the substance abuse has a detrimental effect on the potential or the dealing with the aspect regarding overnight contact, then of course overnight contact should not take place. If it does not play a role, if it does not affect the quality or the safety of the minor child when overnight contact takes place, then of course overnight contact may take place, put it that way. I hope that answered that specific question, and I see there's another question on the Zoom, but before I get to that, let me first deal with question 9 from the Western Cape. Question 9 from the Western Cape says the following. Maintenance arrears, non-compliant, children's court, not doing anything about the arrears. So I'm presuming there's a statement and someone wants me to comment regarding that. Okay. If a person is in maintenance arrears, the maintenance court should be able to, should assist you. Not necessarily the children's court, it will be the maintenance court. And the maintenance court has 2 options. They can either deal with a civil route where they can assist you in attaching the person's assets, for example, his car, selling the car, his bank account, taking money from the bank account, or having his employer pay you the maintenance directly, a garnish order. So those are the things that could potentially happen and take place. However, not the children's court. So my advice to you is to approach the maintenance court, not the children's court. If they aren't assisting you and made a mistake here and you mentioned, children's court by mistake, my advice to you is to start complaining and to speak to relevant people, go up the ladder. I know with COVID-19, some courts, I'm not mentioning any names here, but they are maybe a bit more not as enthusiastic to assist people as they would have been had it not been COVID-19. That is no excuse. You are being paid, you have a job to do, you should do your job to the best of your capability. So therefore, my advice to the Western Cape, question number 9, please go to the maintenance court, lay the complaints, criminal complaint or the civil. If they do not assist you, go up the ladder, speak to the manager, go up till the Western Cape Provincial Minister of Justice, speak to him, and make some noise. That would be my advice to you. How does one go about getting a copy of a court file from the children's court? I'm the grandmother and would like a second opinion on what the social worker is reporting. So that's question number 10 from Gauteng. Okay, this is the challenge you have regarding children's courts. If you want a copy of the court file, the magistrate will have to authorize you receiving a copy thereof. You cannot just request, I would like to have a copy. Even me as a legal representative to a party, I have to do it many times. When I get instructed and briefed by an attorney to appear in the children's court, I see we have a bit of a challenge here. We're back online again. Something happened over there. Okay, even me, when I get instructed and briefed to appear for a client in the children's court, I need to specifically request from the magistrate or via the clerk for a copy of the court file, and I have to give reasons therefore. So it seems to me the files in the children's court are quite locked. They were, say, sealed. So if you want a copy of that, you're welcome to do so. Go to the clerk of the children's court and ask the clerk to ask the magistrate whether or not you can get a copy of it. And if you have good reasons, they'll give you a copy of the file. But you are a third party, you're not the parent, so it might be a bit challenging, but I would say try your luck and see what you can do. Now we get into question number 11. If anybody wants any additional questions, you're welcome to pose it from the Zoom and the Zoom chat, which I've seen there are a few questions, or you can put up your hand and deal with it live. Question number 11 from Gauteng. When a child is removed from the primary residence and placed in a place of safekeeping by the Department of Social Development, social worker, after false accusations were made, what are your rights and recourse against a biased social worker? So what happened is, this is obviously a children's court matter. A complaint was laid and said the child is in danger or not being looked after, neglected, and they placed the child in type of foster care for safekeeping. Under those circumstances, a social worker obviously done some investigation, and then you are not happy with that. Obviously, if you're not happy with that, you're welcome to say that. But if you are saying that this person was biased, you'll be able to prove that this person is biased. And obviously, the first way to do that is to complain to this person's boss, go up the ladder. If, however, you feel the person is biased, and at the same time, the matter is pending in the children's court, and you disagree with that, you can present an argument why you think the person is being biased, but at the same time, you can also come with another opinion as to why a different decision would have been taken had the person not been biased. I see a hand going up. You're welcome to unmute yourself and chat on the... I'll ask you to unmute. You're welcome to go ahead.
Hello, can you hear me now?
Yes, I can hear you. Please go ahead. Thank you.
Hi, this was my daughter's question. And with regard to the case, it is still ongoing in court, and we just wanted to know, how would we present that to the magistrate? Do we have to fill in any kind of documentation to tell her that we would like a second opinion? Or How does it work?
So am I dealing with a question from Gauteng, question number 11
Yes,
now?
the one, yes, that one you've just been dealing with.
Okay. So the challenge I have, the challenge you may have is that because the report is most probably not in your favor, the court and everybody else might think because the report is not in my favor, automatically I have a challenge with that, and now I'm saying the person is unbiased, is now being unbiased, or being biased, sorry. The way I will challenge something like that, and I'll be honest with you, is not necessarily attacking, say the person is being biased. I will unpack the report and stipulate exactly how did it come about that the report is flawed, that the logic applied by this person does not make logical sense, because that will speak better to another person. So, for example, if the person, for example, comes with an allegation that was unsubstantiated, that was thumb-sucked, and that will be the way how you will attack that. So you need to sit down with pen and paper and say, this doesn't make sense. Or, for example, what happens many times with these reports, that people, these social workers, they put data in there that was never told by the parties. Or they come to conclusions that doesn't make logical sense at all, no matter how you look at it. And that is what you need to bring to the attention of the magistrate. Because if magistrates and court officials, I mean, they deal with hundreds of files on a regular basis. You just one file, and they look at, when they read through these reports, they jump, and I do it many times myself. The moment I receive a report, I go one time, I immediately go to the last page and look at the recommendations, because I don't have much time unless I have to study it for court. Now the magistrate might do that. So my advice to you is unpack that report, deal with it properly, say why you have a problem with that, and at the same time, maybe take that report to another professional person and find out if that professional person agrees to that. And that might be able to assist you regarding.
How do we present that? So when we go and we put it down on a piece of paper, do we just create an affidavit which we then present to the magistrate?
Yeah, so in children's court matters, you generally orally speak in the before the magistrate in the children's court matter as opposed to a high court matter. So regarding your circumstances here, not necessarily an affidavit, I do not think that's necessary. Maybe there's a response, a written response to the problems you have with a specific report, and you file that at the clerk of the court. Affidavit will only kick in, for example, if there are factual problems you may have. For example, if the social worker says, no, the child is 6 years old, but the child is actually 5 years old or 4 years old. And then you can say under oath, because now you're confirming with evidence. But if it's arguments which you want to challenge regarding the social worker's report, for that specific stuff, you do not, affidavit won't necessarily be necessary. This is an argument. So the magistrate can see now, this is the response I have regarding this specific report. And send that response also to the social worker as well, and he or she can obviously have a look at it as well. So everybody can, opinions can be presented.
Okay. You just hand that into the clerk prior to the case being heard.
Yeah. So the way I will do it is yes. So you receive the report of the social worker. I would most probably just email it to the clerk of the court and ask him or her to give it to the magistrate. Then it is on record and it needs to be dealt with. You see that the difficulty we have in these type of matters, especially if you are a lay person and you're underrepresented, you talk and you argue and it goes through the one ear, into the one ear and out of the other ear. But if it's on paper, it's always there. And if you challenge these decisions on appeal or review, automatically it was on record and the courts will have to apply their minds to it.
Very well. Thank you very much for answering that. You have helped me tremendously.
Welcome. I hope you get justice. And I love it, honestly. People need to start owning their cases. You are in the system. The magistrate's job is not here to be the umpire and decide how you guys play the game. You play your own games as to the best as you can, and the courts have an obligation to decide on what's best for the minor child. Yes, but they can't tell you how to present your case. You have that duty and you have that right and privilege to be able to present your case and to deal with the case how you think is fit. So thank you for that. So let me deal quickly with, you're welcome. Let me deal with question number 13 from Mpumalanga. That's nice to hear people from Mpumalanga. Hi, Section 21 of the Act, I think presume the Children's Act, unmarried fathers, rights of unmarried fathers, stayed with the girlfriend till the kids were 2. Okay? She damaged my property after an argument and had to move out. I asked for the kids to remain but failed. What are my rights as police help out her? So I'm still typing it out verbatim with all the WhatsApp type of short handwriting. But anyway, nonetheless, You as a father, you acquire full parental rights and responsibilities with the mother if you are involved in the child's life since the child's birth. So that is fine. If you have acquired that rights, if you wanted to form part of the child's life, you paid child support, you maintain the child, whatever is reasonably possible, and now the mother decides now, okay, I am now the mother, and therefore I can decide what's in the child's best interest. That's obviously nonsense. So my advice to you is, go to the children's court, let the court hear this matter, let the court make a decision as what's best for the minor child. If it does mean you must have limited contact and the court believes that is the case, there's nothing I can do regarding that. However, the court will obviously have to decide what's best for the minor child, and generally, what's best for the minor child is not necessarily what one or what the other party wants. The court will make that decision. So that's from Mpumalanga, and I hope I've answered that question, and hopefully we can go to question number 14, 15, 16, and 17. Okay, those are the last questions on the whiteboard. But before I deal with that, let me first deal with the question which I have on Zoom. Okay, I have a question on the Facebook as well, but it's basically a question regarding the Zoom link. Unfortunately, it will be too late to send the link out now because you are watching this. But please note, we are having a webinar next week and Saturday as well. We'll be better set up for that one. And any questions or any participation you'd like to make, you are welcome to do so with me. That's next week. Okay, so here we are, back on the Zoom. I'll make sure I should just make sure I do not lose out any questions. Okay, here we go. My son is spending time with his dad's side of the family today. My son messaged me to fetch him and he's scared. His dad is not around. Can I go through and fetch my son and try? Is it not a good idea? I'm available right now to fetch my son. He's clearly unhappy. And I'm available right now, okay, to fetch my son. It's basically repeating that. Okay, this is a difficult question for me to answer. I mean, in isolation, I mean, if the other parent has rights of care and contact, that person must exercise that contact. It's not for one parent just to go and play around with the care and contact rights. The first thing I would do is contact the father, discuss this matter with the father, ask father, why are you not with the child? Remember, it's not for a child to decide what is best for the child. For the same reason, and I will say this. Let's say tomorrow your child decides, no, mommy, I do not want to stay by you this week. You know, I want to stay by dad, and it's your week on. Do we listen to the child wholeheartedly, or do we apply our independent mind to this? My advice to you is, find out from the father why is the child unhappy, what is happening there, why is the child not with you, because we all know many times parents have care and contact over a minor child, but you know, they have to do certain things, and for 1 or 2 or 3 hours, a child can have to be cared for by third parties or be alone if a child is safe and so on. Then later on, you exercise contact. It wouldn't make sense, for example, if a child gets picked up by the dad, take to the mother picked up the dad at 8 o'clock in the morning, take it back to the mother at 12 o'clock or 2 o'clock, collect from the mother at 2 o'clock, and now the dad must go quickly back to work at 5 o'clock and drop the child. It doesn't make sense, you know, up and down, up and down. It doesn't mean the child must always be physically in the care of one child, depending upon the age and maturity and so on. To be careful here, and I wouldn't want to advise you just to collect the minor child. Speak to the father, try to come to some type of understanding. Can I collect my child? What's happening there, etc. At the end of this contact period, then of course this matter must be properly re-looked at. Then I would advise you, please speak to a parenting coordinator, speak to a social worker, speak to some professional person, try to resolve this, because we do not want this to happen again in the future. So I'm very weary or very loath in stipulating collect your child. I mean, what am I basing that upon? You know, some text messages here. I cannot do that. My advice to you is speak to the father, contact the father, communicate with him, and find out exactly what you can do. And if he says, okay, it's fine, you can collect your son or child, wonderful, please do so. But please try to resolve this matter soon after this contact period has come to an end. I hope that answers your question. Another live question on the Zoom. Does the case go to the children's court when the agreement signed at the family advocate is breached? I am nervous that he will get more rights than what he deserves if I go to the court. So I've been tolerating the short payments out of fear. Okay, the family advocate can have the parties enter into an agreement, but that agreement will basically be useless unless it is registered with the Family Advocate's Office, Parental Plan registered in terms of Section 33 of the Children's Act, alternatively made an order of court. If it's only an agreement, it doesn't really mean much. It's just a piece of document signed by the parties. It has a bit of value in it as to what the parties intended, but it doesn't have any legal effect in that specific regard, if you understand where I'm going to. So court order, as opposed to an agreement signed, it's two different documentation. If a party is not adhering to this agreement, yes, you need to take the matter to court. I cannot tell you not to. Sometimes the courts will agree to the specific agreement, or sometimes the court will come to a different conclusion based upon the facts and circumstances of the matter. My advice to you is, if the person is not paying child maintenance, is not doing what he or she is supposed to do, you're supposed to enforce your rights. I always have a policy of moving forward as opposed to taking punches and holding back. You believe that the child will be best in your care, or you believe that the care and contact arrangements are in the child's best interest, you need to fight for that and you do uphold that. Do not, be bullied by the other party, I will pay less maintenance, but if you go to the children's court, you might get less contact. That's not the way we want to deal with these type of matters. It's not in the child's best interest. Okay, before we deal with Western Cape, question number 15, the last three questions, let us deal with the questions coming from Zoom. What happens if I pass away primary residence and the father not in a position to take care of the child? What route should my parents or siblings take if they want the child to be in their care? We're married but separated, no physical contact with the child, only video call twice a week. Automatically, because you are married to the other party, both parties have full parental rights and responsibilities of guardianship, care, and so on. Should something happen to you, automatically the father will be the sole guardian over the minor child, and he can take the child away, and the grandparents and the sisters and the brothers have no rights over the child. That's the way it is. If you are concerned that should something happen to you, and the father will automatically be the sole holder of parental rights and responsibilities and take the child away, and is not in the child's best interest, and you want to reign from the grave, I'm just giving some advice over here, you need to speak to your family now and advise your family. Family, if something happens to me, immediately go to the High Court or see an attorney or speak to somebody and immediately make an application in terms of Section 2425 of the Children's Act for interested third party like you to acquire certain parental rights and responsibilities. That is possible to be done. So you need to have the conversation now with your family, or maybe now you speak to an attorney regarding that. And should something happen to you, they should immediately approach a court and try to enforce the rights. So that what we'll basically do is, let's say something happens to you, heaven forbid, but let's say something does happen to you now, but obviously the child was with you and the father only had video contact. Now the next day, after they buried you, immediately, or maybe before they buried you, immediately your parents should approach High Court and say, Judge, the mother passed away, the father only had every contact, whenever by video contact. We would like to keep the status quo for the child to remain with us until there's a full-blown investigation by the Office of the Family Advocate to determine what is best for the minor child. So you're maintaining the status quo. So that's how I will deal with that matter strategically going forward. Okay. I saw another question come in over here. So that's the last question on the Zoom. We're ending at 12 as I said. So let me first properly deal with this next three questions, and I can go back to the Zoom. And if you want to put up your hand, you're welcome to put up your hand, and I'll unmute you. Question number 14. A parenting agreement was signed in the Children's Court, and the father no longer is paying for maintenance and refuses to pay any more than 500 Rand for the support of the child. I don't know what the question is, but if a party is not paying an adequate amount of money which you believe is reasonable and which you believe he can afford to pay, my advice to you strongly is go to the maintenance court. The maintenance court will obviously make a decision and determine what is a fair and adequate amount to pay. So generally the Children's Court doesn't deal with maintenance matters, they deal with care and contact arrangements. I hope that answers the question from Gauteng. If I have not, we have a few moments to deal with that. Okay, today I have to just push the video for the sole reason that at 12 o'clock, these construction people are starting to work in this building. However, next week, we will have this webinar again, and any questions I did not deal with adequately, you are welcome to engage with me next week. Same time, same place. Question number 15. Do I have to inform my ex about my children's lives if he is not paying maintenance? Do I have to inform my ex that I'm getting married? We share 3 kids. Can I cut communication because of verbal abuse? This is the challenge you have. Now you do not inform the other party. What happens then? There'll always be controversy. There'll always be issues. My advice to any parents who are separated, you need to communicate. You need to go for co-parenting counseling. You need to become the best co-parenting for co-parents for your child. That's very important. If there's a court order in place stipulating that you need to communicate and you have to deal with these specific issues via email, you need to do that. So I would strongly advise you, I mean, you're remarrying, it will come out. Send an email to the other party. If the other party is being abusive, go to the domestic violence court, get a protection order. So you have a protection order limiting the other party from abusing you emotionally, psychologically, etc. But you still communicate with this person and tell the person, you could have a protection order. So be respectful here. But I'm informing you that I'm getting married, X, Y, and Z. So I strongly advise, for the sake of the child, for parents to continuously communicate with each other. So I cannot say do not communicate. I cannot say to cut out communication. You must try your best that you can do in order for you to avoid that scenario from happening. Question number 16 from KwaZulu-Natal. Thank you, KwaZulu-Natal. Hopefully next week we'll have more from KwaZulu-Natal and from other provinces as well. I'd like insight on having an X-file for primary residence. I'm in KwaZulu-Natal and he's in Johannesburg and he wants residence of our 8-year-old child. Had an inquiry with a family advocate, but I'm still waiting. Okay, so I'd like the insight on having an X-file for primary residence. The bottom line is the courts and the family advocates determine what is best for the minor child. They look at your circumstances, they look at the child's circumstances and the other party's circumstances. They look at everything. Generally, the professionals comes on board. The family advocate, they will investigate this matter. And if they decide that it is best for the minor child to be in your primary care, they'll make that decision because the child's best interest is of paramount importance. If they make the decision that the child should be in the other party's primary care, they'll make that decision. So my guess is as good as yours based upon this data. But if you feel that you want to have primary care, you need to put your best foot forward and try to motivate to the court why you believe the child will be best cared for by you. And now the last question before you're going back to the Zoom. If you want to put up your hand, do so now. Question number 17 from Limpopo. Thank you for joining us, Limpopo. Future maintenance not in the Pension Act and the lack of it in the pension fund. Oh, I think the person is basically asking the question here regarding future maintenance. Can you attach pension funds and how does it apply? That is very, very sad because I honestly believe that a person should be entitled to attach a pension fund. But it's one of those things that the Maintenance Act does not necessarily allow that you can attach somebody's pension fund while the person is employed for the specific fund. I might be wrong. I will have to relook that as well. But what can happen is if the person is acquiring money every month or is entitled to have a lump sum, and that specific money can be attached. Thank you for that. For those who have posed questions, next week again, we're back same time, same place, and we can elaborate further. Let us deal with the Zoom questions, and that will be basically the end of this. Hi. If there is a parenting agreement signed and contact as per the agreement, father access to contact is supervised by the father's mother, and introduction of contact was done over 6 months period to get more. Now the father once again has taken me back to the children's court in unfounded allegations and concerned that this is the second time in the children's court when I have primary residence over the child. A social worker is on the case and have not found any of the 13 allegations to be true. Father is abusive, and that's why he's separated in the first place, and we are unmarried, and he neglect to pay maintenance. That was agreed by the children's court. I see this is what we're having over here is we're having a serial litigator, someone that always approaches a maintenance court, always causing problems, always, despite there being any merits, he will still go to the maintenance court. My advice to you is, the court is in a difficult position. The court can't say, okay, you're not allowed to ever come to the children's court and lay a complaint, because what if at one point the father has good grounds for this specific thing? So I always advise parties under these circumstances, have a third party being appointed, a social worker or facilitator, a parenting coordinator, that's the term I want to use. So before anybody approaches a court, you first need to go through this third party, this parenting coordinator, to basically audit or to filter out unnecessary grievances. And if there are valid grievances, of course, then the person can go to court, but obviously with the permission of the plaintiff facilitator, because he would have looked through the system first and analyzed everything. If there aren't any merits for it, then obviously the plaintiff facilitator would not have given a certificate. And has this person gone to court based upon the plaintiff facilitator not agreeing to it, the court can maybe potentially make a cost order against the specific person. I hope that assists you with some advice. That is off-the-cuff advice I have for you. And the last question I have, I would just like to find out what can I do on an incident that I came across while visiting my son at the temporary foster care. On the one visit, I arrived to find that my son was full of bruises, bite marks, and scratch marks, especially bruises on his ear and around his neck. I took photos. I would like to find out what I can do. Can I open up a case with the police for abuse? I have contacted the owner of the home and they deny that there are any marks. Yeah, I think the challenge you'll have is to, with the police, I mean, the police will obviously have to investigate the matter. I'm not saying do not do that, but there needs to be some investigation within the foster care system. So you maybe have to go to someone further, Department of Social Development, to deal with this matter. And I would say that might be the better thing to do. Is it abuse? Is it a child maybe fighting with another child? I do not know. Is it a child maybe getting some flea bites? I do not know. I'm just saying, speaking general, speculating here. So the question I have over here is, you may want to consider going above the ladder. Oh, that's a noon gun in the Western Cape. Maybe you heard that. And I think I'll have to deal with this quickly before I hear some noise upstairs. Prime residency is that the child stay with me, the biological mother. Protection order was issued and we signed agreement in protection order court, domestic violence court, I presume, that he will stop the abuse. Okay. But he has not stopped the abuse behavior towards me in front of the child. Thank you. If the person doesn't stop the abuse and there's a protection order in place, he's in violation of the order, I would strongly advise you to go lay a complaint at the domestic violence court and lay a complaint regarding this. I mean, it's a criminal offense to violate the domestic violence order. So do that. So ladies and gentlemen, it's 12 o'clock on the dot. Thank you very much. And the person that commented here, thank you very much as well. Next week we'll have it betterly set up. As I said, the last time we had this live one was in March, unfortunately. But hopefully we will warm up again and try to figure this thing out as we go along. Have a lovely day. Thank you for joining us. Please, by tomorrow, notification will be sent out again for the next Zoom webinar. Please register for that as well for next week. You're welcome to interact. You're welcome to ask questions. You're welcome to post questions. I try my best to deal with all the questions. And by that way, we can all learn and benefit from each other. Have a lovely day. Thank you.
Wonderful. Our official start. Welcome again to our live webinar dealing with the topic of child custody, child maintenance and divorce. Live Q&A part 2. Last week was part 1 where we dealt with quite a lot of questions regarding this specific topic. We have people viewing this video, or this live video, via Zoom. Those are people who have registered before in the last week to form part of this webinar. Quite a lot of questions were posed. About 13 we have today, dealing with various issues concerning child custody, child maintenance and divorce. If you have a question, those on Zoom, please feel free to put up your hand using the Zoom functionality, and I will unmute your microphone, or I believe you can do it, you can unmute your microphone, and then we can interact. And I call upon you to do that quite early in the webinar. This webinar is not intended to be any longer than an hour and 15 minutes, an hour and a half maximum. So if you have a question, please decide what the question is. Let us engage, let us interact, so that the community out there will be able to learn from our interaction. Nonetheless, those of you who have specific questions on Zoom, you're welcome to type those questions into the message section on the Zoom platform. I will periodically view those specific questions and then we can deal with that as well. So that's the other platform via Zoom. For those of you who are watching this video via Facebook Live, we are streaming on various pages. Please note that you are welcome to post questions on the Advocate Mohammed Abduroaf Facebook page. That is a specific page which I will be making use of, not our lawyer, the family consultancy page. I'm looking at the Advocate Mohammed Abduroaf Facebook page. I do apologize now. There is again still construction in this building, some drilling happening at, I do not know which floor it is. So intermittently you might hear funny sound. I do not have any power over that. And I hope you can be with me, and I'm being with them as well. Nonetheless, let us now begin with today's topic, and I'll be keeping an eye out on the various platforms. And please, on the Zoom, don't forget to put up your hand and unmute, and we can interact with each other. The person asked a question. I was unable to join last weekend Saturday. No, there's no problem with having been unable to join last weekend Saturday. There is a video that was uploaded onto our platforms, and a video should have been sent to you as well, so that is perfectly fine. Let us begin. Unfortunately, those on Zoom cannot see the questions on the screen. It seems to be a problem with streaming on the same PC and at the same time sharing that specific screen. But nonetheless, we're on the same page and we'll be able to get past this very easily. Child custody, child maintenance, and divorce. Why did we or me choose that specific topic? It's obviously holistic. It deals with various aspects regarding family law, child issues, etc. Child custody deals with care and contact. You know, when can a parent have contact to a child? What's the circumstance? What's the law? What does the law say regarding that? Rights of fathers, rights of unmarried fathers, children born out of wedlock, and those things. Would contact be 50-50, 1 week with the mother, 1 week with the father? Can contact be suspended? You know, is that possible? With that, I'm also dealing with issues concerning guardianship rights, child custody issues, parental consent, for example, a child applying to a school, an application for a passport, relocation to another country, going for medical procedure, etc. So those are guardianship issues. Child maintenance, we all know what that is. You know, each parent has a legal obligation to support their child according to their means. Therefore, today's topic dealing with that as well. If you have any questions regarding that, feel free to pose it. And I see some questions are coming in via the Zoom platform. I will deal with that shortly. Great. And as I said earlier on, feel free to put up your hand and we can chat as well. So that child maintenance, we all know what that is about. For example, the mother is not paying child maintenance to the father because the father has primary care, or the child is living with the father for 1 week and with the mother for another week. What does the law say regarding that specific arrangement? Could there be a maintenance order in place if there's 50-50 care and contact? Is it possible? Or does the law say that one parent should care for the child for their week and the other parent should care for the child for their week, and we just split the schooling expenditure or the fixed expenditure like medical aid and so on? Nonetheless, those are hypothetical questions and there are answers to that. And those are the questions which I will not answer necessarily because it's not being posed. But if you have the question today, you're welcome to pose it. And then finally, divorce. Divorce, obviously, it applies to the adults, moms and dads. I'm not applying specifically to moms and dads. Obviously will advise people who have no children and they would like to get divorced. What's the legal requirements to get divorced? What are the propriety consequences of divorce? For example, the money, the property aspects. What happens to the house? Who pays the bond afterwards? What if the parties can agree to what should happen to the house? What happens to pension funds? You know, does one party have a claim against the other party's pension fund? What are the various matrimonial property regimes? In-community property, which is a default, out of community property, which has two scenarios, with the application of the accrual regime and the other one without the application of the accrual regime. So obviously, those are interesting questions that people might want to ask and would like to find out answers to it because it applies to the specific scenarios, the specific situations. It might not apply to any other viewers today, but if you have an issue regarding that, please ask me and I would like to answer that for you. So before my Zoom chat becomes too full, let me first answer some of the questions that were posed to us whilst the parties were, when they registered for this webinar. Please note, you can register for our next webinar, taking place next week and Saturday again. You can do that via the link www.abduroaf/live1. My apologies for that. So it's www.abduroaf/live1. You can register for the next webinar. Unfortunately, I see it's not mentioned on our screen. So question number 1 from the Western Cape, my province. I think this was the first person that registered for this webinar. He or she asked the following: why is the judicial system failing me for 2 years for maintenance? Is this normal? That is a typical question I receive a lot. Many people, they approach the maintenance court and they do not get the type of relief or the type of response from the maintenance court, which they would obviously want. And so I generally have we apologize for this, what's happening here on the screen. Yeah, so I have generally a two-pronged answer to that. Number 1, if the maintenance court may be assisting you to the best of their capabilities, however, you are not getting the type of relief from the other side. So, for example, you want X amount of rands maintenance per month, but the maintenance court is not assisting you in getting that specific amount because the other party from whom you are claiming from does not want to cooperate, does not want to abide, does not want to comply with your request. That's the one scenario. So the maintenance court is assisting you, but you're not getting the result which you are looking for. The other scenario is the other party can clearly afford to pay the child maintenance, but the maintenance court is dragging their feet. They're losing the files. They're not subpoenaing the relevant parties. They're not invested in your specific matter. So that's the two scenarios which you apply. Sometimes, I think most of the time, I get the scenario where the maintenance court, unfortunately, with respect to everyone, and not mentioning any courts, is not engaged or not invested in the specific file or specific case. The person mentioned something very interesting from the Western Cape. Mentioned the system failed me for 2 years. Now, we all know that COVID-19, I'm not making excuses here, but COVID-19 and the lockdown and the courts operating the way everyone operating the way they have been, has been a bit challenging for everyone. So I do not want to make excuses, but that could have been part of the problem. We all know that courts, at the start of the hard lockdown, everything was shut down, everything was basically closed, and they opened up and they started operating in a very skeleton manner. Things were not so accessible, and I'm certain now they are operating much better. However, that could have affected the logistics of the matter. But that is still no excuse. The matter should obviously have proceeded. So this is the advice I have to you. If you are having problems with the judicial system in obtaining child maintenance, if your scenario is number 1, the other party is not complying with your request. The maintenance court calls the parties in, they bring you in, both parties are there, but he or she does not want to pay the child maintenance. Under those circumstances, I strongly advise you maybe to get some type of better legal representation to assist you in your matter. Because the system works, but the enforcement, the maintenance courts only have so much clause, they can only do so many things. So that is the one aspect. Maybe get legal representation to assist you regarding that. But if the situation or the scenario is whereby the maintenance court is very lax, they're losing files, they're not doing their job properly, that I do not accept at all. Under those circumstances, I will start complaining. Speak to somebody above. Speak to the court manager. If that person does not try to resolve this matter, go further up, speak to the provincial minister of justice and make those complaints. So deal with those matters in that specific fashion, because the maintenance court is a creature of statute. They have a legal obligation to assist all parents in obtaining fair maintenance, and they're acting in the child's best interest. So that was question 1, and I hope I've done justice to question 1. Question 2 from the Limpopo province. It is as follows. If a guardian is appointed in a will but stays overseas, must they adopt the minor or make an application for guardianship in order to come and fetch the child? Very interesting question. Now, a child would obviously by default have 2 guardians under normal circumstances, the mother and the father. If the mother or the father passes away, one of them passes away and the other one is alive, then the other party is automatically the sole guardian, full stop. Even if the parent who passed away stipulated in the will, I would like to make my aunt or my sister or my brother the guardian of the minor child, that won't necessarily work because he is a guardian who's alive, and this third party, why must this third party have any powers over the minor child? If the scenario applies to a fact whereby the parent who passed away was a sole guardian of the minor child, and that specific parent stipulated, I would like to have this party, and I'm using the example, my sister, for example, to be the guardian of the child, guardian of my child at my demise. Then under those circumstances, the law will obviously have to give effect to it, because in terms of the Children's Act, that is possible. But the challenge you have over here is you have a piece of paper stipulating that. How do you know that is authentic? And you can't go right around the world when applying for a passport for the minor child, showing a piece of document calling a will. How do you connect all of these things? How do you know the person passed away in the first place? So you must move around, apologies, for the death certificate and with a will and try to prove all of those things. So my advice to you is to make an application to the High Court and have the High Court confirm that you are the guardian of the minor child. So that will be in terms of section 24 of the Children's Act, assignment of guardianship rights to interested third parties. So you will basically confirm that, for lack of a better way of stipulating it. You'll leave with a court order, and that court order you can show to anyone right around the world. So if you are overseas and the child passed away, the parent passed away in South Africa, my advice to you is to get an attorney in South Africa to launch an application. You can stay where you are because the child is living here. Make the application, launch the application, obtain the court order. Nobody will oppose it. There's no interested parties other than you. And then that order can obviously be sent to you, or the attorney can use that order with some power of attorney to have the minor child sent to you overseas. So my advice to you is get an attorney on board. The matter is quite straightforward if the party that passed away is a sole guardian. Question number 3 is an international question from Maputo. Thank you, Maputo, for joining us on this platform. The question is as follows. If the father asks the minor children to reside with him for a certain date and agreed on the divorce settlement, what happens when the date comes and he doesn't take the children? Can I then keep the children? Now, that's a sad thing. And something which I've grappled, and I mentioned quite a lot in public, on various forums, on TV as well, that a parent would be held accountable if he or she refuses the other party to have contact. And that's right, I agree with it. I'm fully supportive of that. But the law does not cut two ways, in the sense of if one parent who is entitled to have contact, who should exercise contact to a minor child, decides not to have contact despite of a court order, basically nothing can happen to that specific party. That specific parent will not be held accountable for that from a legal point of view. A crime is not being committed, although a crime would be committed if the mother, in my example here, refuses the father contact in terms of a court order. So, yes, the answer is, of course, you must keep the child, because who must keep the children in the first place? The other party does not want to have contact or access to the minor child. If this does happen continuously, it happens a lot, then I would say approach the court to have the court order varied to avoid this scenario from happening in the future. The reason why I'm saying so is before put it differently, the father is supposed to have contact to the minor child on the Easter weekend. You make plans for yourself, because you know on the Easter weekend, in terms of the court order, he will have the kids, and you might make plans to go away with a friend or on a holiday, or you're remarried with your spouse, etc. You booked a place for 2 people, and that's it. Easter weekend comes, the father decides, you know what, I now decide, no, and I do not feel for these kids. I want to go somewhere else. I want to go on my own holiday. Mom, WhatsApp her, say, I'm not collecting the kids on this Easter weekend. That causes serious problems, because what happens now? Must the mother now cancel her plans with her friends or with her new spouse, etc., to go away on the Easter weekend as well? Must they now spend more money to bring these kids with them? How devastating is it for these kids as well? So under those circumstances, if it happens because of a very good reason, there's a death in the family, there are certain serious issues that happen, of course, we're all human, it's reasonable, I understand that. However, if the party, he or her, was vindictive or unreasonable, vexatious, and so on, under those circumstances, I would definitely approach a court and have the court order varied to be workable, more workable under the circumstances. I think that would be most probably make more sense. So I hope that answered the question for Maputo, question number 3. Let's move on to the Northwest, question number 4. Let me quickly have a look at our other panels, other questions. Great, our chat is filling up a lot. Please, okay, yeah, I see we have a question. Somebody put up their hand. Let me deal with that quickly. The person who put up their hand, you're welcome to unmute your microphone and start speaking. And let's take it from there.
Good day. Thank you for this opportunity. Can you hear me?
You're welcome. Yes, I can hear you. Please go ahead.
It touches on something that you have begun answering already, so you can tell me if I need to park that and you wish to continue. You were talking about the maintenance. I was the person who submitted that question about the maintenance dragging on. It's actually a combination. You said 2 prongs, and my experience is actually a combination of both. So I've got an ex-spouse who earns more than double my salary. He's being a high school principal, my being a part-time lecturer. But I'm finding that he's been not very uncooperative. So for instance, I opened the matter 2019 in the Weinberg court. The first date, the January 2020, he didn't appear. Then they served a subpoena and then only appeared in February. Unfortunately, by that stage, I'd been moved out of the home and couldn't continue staying where I was staying in the interim. So I then started renting a flat in Pinelands. Because of this shift, the magistrate was just frank about it, that no interim maintenance, she's not hearing anything. This doesn't fall under that jurisdiction. Transfer the file to Cape Town. So the file gets transferred to Cape Town, February 2020. I hear absolutely nothing. Of course, then lockdown hits. And I go back and forth and back and forth. I've appointed probably my 3rd attorney by that time and had a consultation with the attorney and her advocate. I am out of funds. I am broke beyond what you can possibly even imagine. I am dependent on the good grace and mercy of friends and family to help me support my children and live at the moment. I have made this clear to the court. I've proven it with my bank statements and photos and everything. But what then happened was the Cape Town court lost the file, lost in inverted commas. And that dragged back and forth until when the lockdown levels reached a lower level, I then began complaining about it and nagging until I received, through a friend of mine, an email for Ashika Singh, I think it is. I think she's the head of whatever justice and in the Western Cape. So I emailed her. Then suddenly I got a response and I had movement and people were running around to find the file. But because I had now complained, when I went back to the Cape Town court, of course, I was viewed in a very different manner. People were very offended by me having reported and complained and stuff. You know, I was seen as that person who had gone so high up and complained. So then they recopied the file. And then, of course, after they recopied the file, suddenly the file appeared. It was then found. Nevertheless, they made me open a brand new application, which application I then began in August 2020. Both appeared to the clerk in September 2020, given a date we go, and then the man's, so of course we're told what documents to bring forth, fill in, bring our files. I produced my file 1 week before the pre-trial. But my ex-husband, who note is a high school principal, tells the clerk over the phone, oh, because he doesn't pitch, he doesn't produce his file. Oh, I'm sorry, I didn't know. I thought I should just bring the file with me when I come to court next week. So the man explains, and the clerk says to me, oh, ma'am, he sounds very confused. I said, no, sir, he can't be confused. He's a high school principal. How is he managing a whole school and yet be confused? You gave us both the same sheets of what documents to provide. So then he doesn't come. Then in frustration, my mother draws her last bits of money and says, look, my child, get a lawyer. No matter what, we have to sort this out. You need money for my grandchildren. You can't continue living like this. So I get a lawyer. Then when I go in November 2020, the magistrate says, oh, sir, well, since she has a lawyer now, would you like a lawyer? So, of course, he ums and ahs, and there's death, and there's COVID, and there's all sorts of things. And he has a cousin who's an advocate, and we have to listen to this whole story. And he's very busy because he's a school principal. And this is where the narcissistic element comes through, because every person he meets, he has to tell that he is a school principal, and he's just so busy, and it's matric exams. So then in December, they meet. I didn't have to be present. This was merely to put his attorney on record. Then he's supposed to submit certain documents to my attorney by mid-December because, of course, he was too busy with the matric exams. I don't know if he was writing them or what. He only submits these documents by the end of December 2020. Come the new date, which is only the February 2021, we then appear, his lawyer is not there. Oh, what has happened? No, his lawyer is withdrawn because he hasn't paid the lawyer anything. So we now proceed. Then there was another date. The magistrate wasn't there. There was a different magistrate. I must say he's probably the only one I've met in the 5 years that I've been busy with this, who tried to be helpful and say, look, I'm not interested in your issues with each other. It's about the children. Try and come to an arrangement. The lawyer I had at the time tried high and low. The man is unwilling. He is still holding on to the marital home, which is an 8-bedroom house, refusing to sell it. And by the way, charging me monthly for a room. He was even earning income off that house because he had tenants there. And he just point blank tells the magistrates, oh, I'm sorry, I can't afford it. I can't afford it. And they just fall for this. My lawyer said, are you telling me you choose to maintain an 8-bedroom house, but you can't afford to pay maintenance for your 2 children? Yes, no, I can't. Oh, shit. He puts his hand on his heart and gives a whole dramatic performance. Then, of course, it's back and forth dates and things get postponed. And then he wants more information on this and more information on that. He's wanted printouts of the children's accounts which don't even exist. I've gone to the banks to get letters from the bank declaring that this is the only account in the child's name. And then our most recent, and then of course there was one date in April where he just didn't appear. Now surely that was contempt. He doesn't appear, they don't do anything about it. And then he submits a medical certificate which shows that the time he went to the doctor was only that evening of the day that he was supposed to be in court, which to me was a bit suspicious. But the magistrate doesn't say anything about it. The clerk doesn't say anything about it. We enter the next date when the trial only began. This is from 2019, only began in April 2021. And the magistrate doesn't say a word about his contempt of court, not pitching. And now my last date was just postponed. We just got an email from the clerk saying, sorry, it's postponed. And I'm still waiting for a date. And in the meantime, I'm living off buying waste in the shops and people's kind donations like a charity case. Now, how can this be okay? But our wonderful president makes great speeches about gender-based violence. I've had my fill of dealing with I've tried to get I've been to the domestic violence court about psychological and emotional abuse. I've had no joy there. My entire experience of court, and this is why I asked our magistrates clued up on dealing with narcissists. The attitude of the magistrates at the Bishop Davis Court was, oh, okay, so if he's not hitting you, okay. So he's not hitting you. So the only kind of abuse taken seriously seems to be physical. I've spoken to the court manager in Cape Town. She referred me to some different women's organizations. I call them. They say to me, no, they can only help me if it's a matter of domestic violence. I phoned the Legal Society. They can't help me. What do I do? Really, what do I do? I'm sorry for becoming so emotional, but this has really been an arduous process. Thank you.
No, you're welcome, and thank you for sharing that with us. Now, your story obviously is something which I do hear quite often, and many people do not believe it because they think it only applies in theory, but not necessarily applies in their life. And that is exactly why these questions are being posed and why all these people are posing these specific questions, because the maintenance courts are failing people. And also with my past webinars with Felicity and guests, with quite an activist in child maintenance matters, that is a narration coming from what's happening in the maintenance courts. The government on paper draws beautiful legislation, beautiful amendments to the Maintenance Act, stipulating that now you can, blacklist a person, you can use Vodacom, MT, and Cell C to get the person's details into the maintenance orders can be made based upon previous agreements and so on. However, the reality of the matter is the maintenance courts needs a revamp. So to the caller, unfortunately, I can sympathize with you, and I wish I had a quick answer, do this, do that, do that. I have a range of possibilities you can do, and my best scenario would be complaining to the ministers, complaining to the provincial government, because if there's apathy on the ground level from the maintenance court's point of view, clearly it's ongoing. So you might be the one file, and tomorrow someone else comes and they'll perpetuate the apathy, the nonchalant type of ways of dealing with these type of matters, and they need to be exposed. I'm not referring to any person specifically, you can quote me on this, but they need to be exposed. These officers, these maintenance clerks, either aren't doing their jobs. And I know you have complained to the court manager. Maybe they're also part of, the same type of attitude. Is this one of those things? We are overworked, we have many files, whatever the excuses are, but it is totally unacceptable. The Children's Act, the Constitution, there is an imperative on the maintenance courts to do their jobs, to ensure that maintenance is provided. So my advice to you is, I do not know how far you went up to the minister's office, writing to the radio stations, writing to the newspapers, to the TV, complain to them, explain to them your situation as you outlined it here. You've approached a maintenance court, this is the timeline, they're not doing their jobs. Let them get on board here, let them now start consulting. I'm talking about the media, with these maintenance officers, mention names. Let us get some answers, because I think that will be the only way we can actually, get results without spending money on legal fees, because legal fees is so expensive. And the problem is, should you spend money on the best attorney or advocate, and that advocate now has to deal with a nonchalant court, I don't think you'll get your money's worth. So I sympathize with you. You're welcome to pose any further questions. You have our email address. You're welcome to pose any additional questions via email as well, and I hope I'll be able to assist you. But my advice to you under these circumstances, something that will not cost you anything, is to complain. And I do know, and I've said this because based upon years of experience, that if you complain to the right person, and the proper noise is made, people start doing their jobs properly. So I hope I have been some type of assistance with you, and you're welcome. I saw the comment you made now. Thank you very much. If you have any further questions and you would like to join us again and like to call in again, put up your hand and I will be happy to unmute you, or you can do that yourself. Thank you very much for that. Okay, let us go to question number 4, and at any time you're welcome to pose any additional questions. Question number 4 from the Northwest. How does one claim for past costs the prolonged maintenance dates the courts have led to me paying for everything, and the father says he will only pay for what the court said he should? Interesting question, and a question which many maintenance courts and officers do not know how to apply, and that's very sad and very strange. And I'm speaking about experience.
the question basically being posed over here is, yes, we all know if you apply to the maintenance court and you apply for child maintenance, the order going forward is always granted. For example, okay, the father can afford to pay maintenance of X amount of rands. You should be paying that from the 1st of the next month or the 7th of the next month going forward. But what about the maintenance incurred for the minor child before the order is granted? Let's say the child is 6 years old, the father never supported the minor child. What happens to that? Now, in terms of the Maintenance Act, you are allowed to claim for that amount. It's not a real maintenance because there's no order that has been made, but it's cost incurred for the minor child. You're also allowed to claim for birthing expenditure for the minor child as well, despite the child now being 6 years old. It is possible. So I implore to everyone, if you are applying for child maintenance, ensure that in your application form, stipulate, I would like to have the following moving forward. Of course, the court must still inquire and determine whether or not it's reasonable, but I'm also claiming for child maintenance since the birth of the child, the birthing expenditure up until now. It's very important that you do that. Come with a figure. Nobody will know for exactly how much it will cost because you didn't keep receipts. But obviously the child maybe went to creche, the child needed to eat. So you can come with some type of a figure. So the child costs, for example, X amount of thousands of rands per month, whatever it is, maybe work it down. Obviously there was inflation, things cost a bit cheaper at that time. So please look into that. The Maintenance Act is clear on that. On the application form, it deals with that as well. So I hope that answers the question from the Northwest. Question number 5. How does an unmarried single parent get a passport for a 6-year-old child? The father cannot be found and the child is solely raised by the mother. Now, that is one of the questions which I deal with in webinars a lot, and a question which I get posed to a lot, and something which I on a regular basis appear for clients in court for. In terms of the Children's Act, both guardians of the minor child should consent for the minor child to be given or issued a passport. So that's the law. So the mother might go to the go to the Department of Home Affairs. The mother will go there and say, I would like to apply for a passport for my minor child. Here's a birth certificate. I do not know where the father is. They will say, no, that's maybe you're lying. I'm not saying they say that. Maybe the father is around, but you want to leave with the child overseas without the father's consent. And the law says both guardians' consent is required. And they will persist that we will not provide you with the passport unless the father is present to give consent. I presume some departments might not follow that. I do not know, but that's a general trend which I've been experiencing over the last few years. I've had clients who had a scenario where they could not have found the father 5 years ago, 6 years ago, and the Department of Home Affairs then have issued a passport without the father's consent, but then they come see me 5 years later because the passport expired. And I ask a question, they say, no, that time it wasn't a problem, but now it is a problem. So it seems to me the Department of Home Affairs is causing that, are requesting or demanding that we will not provide a minor child with a passport unless both parents are present to give consent, unless a court orders otherwise. Either divorce order will stipulate that the mother's consent is only required, or the children's court might make an order in that regard, or the High Court will make an order in that regard. Regarding matters concerning passports, I would advise you to approach a High Court for such an order. The High Court will obviously not only deal with the issue concerning a passport, I'm referring to the specific questionnaire now on the screen. The High Court won't only, or your application should not only be for the dispensing of the father's consent for a passport, your application should deal with various guardianship rights as well. For example, you do not require the father's consent for the child to be enrolled into a school, for the child maybe to relocate, whatever the case may be, because you have a specific problem here. The father is missing in the child's life. So under those circumstances, go to the court for an holistic view order dealing specifically with how can a court resolve issues going forward because the father is missing. Tomorrow you have to enroll the child into high school. The schools are saying, no, we require the father's consent. We're easy. Then you'll have to move from high school to high school until you find there's one high school who is sympathetic with you and willing to enroll your child without the father's consent. So if you are, the specific questioner, going to approach a high court to dispense with the father's consent for the application for your passport because the father is now missing, you can't find the father, ask also that the father's guardianship right be disposed of completely regarding the minor child. Because you can't find the father, unfortunately, you'll have to make an application for substituted service, meaning you'll have to serve or notify the father regarding your application via the government gazette or the local newspapers and so on, depending upon the court. So I hope I answered that specific question to you. Just be smart on what you're asking for the court. Ask for a bit more than less. Question number 6 from the Western Cape, and here all the questions are from the Western Cape. I have been trying to get a divorce court date for 3 years. What is the delay? Okay, my quick answer could be possibly COVID-19. I do not know which court it is a high court or the divorce court, the magistrate's court. That could be an issue. I also do not know how far the divorce proceedings are. Have the various internal aspects of the divorce been resolved, for example, discovery of documentation, pretrial conferences, and so on. The case management part of it, has that been resolved? But once all that have been resolved, then the court date should be quite a few months, but it shouldn't be more than a year, depending upon the court. So if you are legally represented, many times, and that's come to my desk, and I'm not saying it happens in practice, it's the norm out there, but when complaints come to me, obviously, it's because there are problems. The attorneys do not communicate with the clients. They do not advise the clients what is happening in the specific case. So speak to your attorney. If you do not have an attorney found out by the court, what is happening, what is the delay, and let that delay specifically resolve the matter. Because, for example, sometimes the courts are efficient, but the parties themselves are not completing their specific role. For example, discovery of documentation. For example, if you would like to use a certain document in court at a hearing, for example, maybe a pension fund document, or a report from a professional, whatever the case may be, you have to disclose that specific documentation to the other side, discover it. And that could be something that can cause a delay in the finalization of the matter. Because no court will give you a court date unless the internal or the procedural aspects before the trial date has been resolved. I hope that answered that question for the Western Cape. Question number 7. Why does a father get away with not paying maintenance? He buys new cars and wears flashy clothes. This is unfair. Of course it's unfair. I mean, how can someone who is obviously living a reasonably good life here buy new cars, wear flashy clothing, not pay child maintenance? I cannot take this a bit further, but then you should apply to the maintenance court as soon as possible and start doing your thing, enforce your rights to child maintenance for the minor child. As the person who called in early on mentioned, there are certain problems she has experienced, and obviously the father in her specific scenario was one of those deadbeat fathers who does this not want to pay, or there's a principal of a school. My advice to you is go to the maintenance court, do what you can. If that doesn't work, climb up the ladder, but don't fight until you obtain child maintenance. I know it's sometimes difficult, but all that I can say is don't give up. Question number 8. Why does the law only take the side of the mother? Very interesting question. Sometimes when I represent mothers, they ask me the question, why does the law only take the side of the fathers? So it depends what side of the fence you're on. Where is the wind blowing? Is the wind blowing in favor of you? Is it filling up your sails, or is the wind blowing in favor of the other party filling up their sails? So it depends what side of the fence you're on. My experiences are, when the courts do find in favor of the mother, it will generally be in a child contact or care and custody matter when the child is quite young and the child is in the primary care of the mother, and the court is convinced obviously the child would be best cared for by the mother. So there's a bit more of a preference for the child to be with the mother based upon the age and who's caring for the child. As the child gets older, the preference starts going away, and we focus more on what's best for the minor child, not necessarily gender, based upon the gender, but more holistically speaking. But the law, the courts should always apply what's best in the child's, what is in the child's best interest. Sorry about that. If it's a child maintenance matter, I do not see any reason to argue that the courts find in favor of the mother. I would say it all depends upon the mathematics of the case. Of course, if the father is super wealthy and the mother is not so wealthy, not doing too well, then obviously the mother's case becomes a bit easier. And the father who has the money might not be happy with that. Question number 9. Can I change my marriage to A and C? Interesting topic. Okay, this applies more, not to divorce, more to marriage, but it does form part of our theme. Now, A and C means antenuptial contract, meaning the two scenarios out of community property with a accrual system, and the other scenario out of community property without the accrual system. We all know what the accrual system means. It's basically benefiting from the other party's growth of the estate. I'll give you a quick example. If the parties are married out of community property, meaning that during the marriage, whatever belongs to you belongs to you, what belongs to him belongs to him. So there are two separate estates. And if you are married without the accrual system, meaning at divorce or at death, that remains the case. What belongs to you belongs to you, what belongs to him belongs to him. If you are married out of community property with the accrual regime applicable, obviously you would have entered into an antenuptial contract stipulating that. And during the marriage, what belongs to you belongs to you, what belongs to the other party belongs to the other party. People can't come and take money from you because your spouse owes them money. However, at death or divorce, that's where it kicks in. If you are married with a accrual regime, you would have a claim against your spouse for basically the growth of his or her estate during the marriage. That's a quick and simple way of explaining it to you. So if at the start of the marriage, your spouse's estate was worth, let's say 100 Rand, and at divorce, his estate is now worth 1,100 Rand. And your estate at marriage was 0, and now your estate is still worth 0 at the divorce. Meaning your spouse had a growth of 1,000 Rand and you had no growth. Meaning that you would obviously be entitled to 50% of the growth of your spouse's estate. Meaning you would leave the estate with 50 Rand. Sorry, 500 Rand. My apologies for that. And your spouse will leave the marriage, my apologies, with 500 Rand. So you work it out that way. If your estate grew to 10,000 Rand and his estate only grew by 1,000 Rand, then obviously you will have to give him half the difference, which would be 4,500 Rand, because you deduct the growth of your estate being 10,000 Rand less the growth of his estate being 1,000 Rand gives us 9,000 Rand. The difference is 4,500 Rand. So yes, it is possible to change your marriage to an antenuptial contract. Basically what the person is saying here, can you change it to out of community property? That would be an application to the High Court. It needs to be the High Court. It cannot be done in the Children's Court or the Divorce Court. You approach the High Court and you make an application to the High Court for the change of your matrimonial property regime to out of community property. So that is possible. The court will grant that if the court is convinced that it will not be prejudicial to your creditors. That's one of the requirements. And of course, you must live within the province and so on. So that's question number 9. Yes, it is possible. Question number 10. Yes, there's only 13 questions. Okay, those of you who are online, please note you are welcome to put up your hand and I will deal with you as well. You will put up your hand on the Zoom and you can call in. And after question number 13, we will go to those specific questions on the Zoom. Question number 10. Can adopt a person who is 23 years old? Very interesting question, and not the first time that question has been posed to me. Can you adopt an adult? The answer is no. He's an adult. You can't adopt an adult. You can only adopt a child under 18 years old, yes. So 17 and below. Question number 12 from the Western Cape. Why do I need to undergo a blood test if I'm not the father of the child? Two scenarios. Number one would be child maintenance. The mother says, you are the father of the child, you should pay child maintenance. You say you're not the father. Of course, how do we resolve this matter? Will be via blood test. That's unfortunately how it works. The mother will say, I was in a relationship with his father, didn't work out, child gets born, the father says, I'm not the father. How do we resolve it? We go and do a blood test. Question number 13. The last question from the pre-registration. The mother does not want to work. The court sees nothing wrong. Okay. Why must I pay for all the school fees? Very interesting question. It's obviously a question regarding the courts. The courts should obviously be fair. The court should not prejudice one parent above the other parent. If the mother does not want to work, the mother must explain why she does not want to work. Is it fair? Is it reasonable under circumstances? If it's not reasonable, her answers are not reasonable, the court will obviously have to now force her to go to get a job. And the court should not see nothing wrong with the mother not wanting to work. But there is a specific scenario that could be applicable that says that makes more sense for the mother not to work, and the father should contribute all of the minor child's expenditure. I do not have the scenario in front of me. All that I know is that the law says that each party should maintain a minor child according to their means. So the mother cannot decide on her own, I do not want to work, I will not be responsible for any of the minor child expenditure, but the father must be the one that works and he must pay for all the minor child expenditure. That is totally wrong. So I would implore upon you, bring that argument to the court and stipulate, I can only afford to pay the following, or I will pay for everything so long, but the mother needs to show to the court that she is trying to get a job and she is trying her best to become employed. Thank you for that. Those are the 13 questions to the participants who have registered and posed questions. Many participants have not posed questions. There was quite a lot, quite a huge amount of people who registered for this webinar. Obviously, you do not have to join via the Zoom. You might be working, you might be shopping, you might be attending to certain things. But the nice thing about registering for this webinar is that you'll get a video later on and I would obviously deal with your specific questions. So let us now move on to the live questions on the Zoom. We'll just move the screen over here. Let me just sift through them. Sorry about that. Okay, the first question is, how do I deal with an ex-spouse who refuses to sell the family home and pay me half share? Okay, the court order says it should have been sold in December. Is this not contempt? Okay, let's deal with that. If the court order says it must be sold, it must be sold. And so you make an application to the court to force the sale of the property. And basically what happens is, if the other party does not want to sign any documentation, the court order will stipulate specifically that if he or she does not sign the specific documentation, the sheriff of the honorable court will be authorized to sign the documentation. So you make an application to court, you outline the facts, you outline to the court that there's a court order in place, and the property must be sold, I must get my half. The party obviously did not comply with that. The court makes an order that the property will have to be sold either by auction or private sale, whatever the case may be. And if the party does not want to sign, the sheriff will gladly sign and the property will be sold. So that resolves that matter. The unfortunate thing is you'll have to go to court and it costs some money for that. Yes, the same person who posed the question early on was, why does it take so long to obtain maintenance via the maintenance court? That question was answered early on as well. Then I have an additional question. What is the ratio of earning? What if the ratio of earning is very different? Surely then 50-50 cannot be applied. Of course, you do not pay maintenance based upon 50-50, you pay maintenance based upon your earnings, your proportion to your means. So if one party earns much more than the other party, of course, he or she must pay more money. However, it's very important to note that when we say means, we're not referring to only income, we're referring to assets as well. So it is possible for somebody who earns very little money, let's say 10% of what the other party earns, but he or she owns property. I'll give you a practical example. Let us say the father earns 50,000 Rand per month and he owns no property. The mother earns 10,000 Rand per month, but she owns property worth millions, let's say 50 million Rand worth. Now, her income is less, is 10,000, and her father's income is 50,000, but she owns property worth 50 million. I'm upping the figures here. Clearly, she should be paying a greater amount of maintenance towards a minor child as opposed to the father, although her salary is less or her income is less. She might have to be paying 90% of the income based upon the asset value worth 50 million. Next question on the live Zoom. How does a single unmarried mom apply for a passport if there is no contact with the father? I think I've answered that question early on. You'll have to make an application to the court. And the court, because if you can't find the father, then obviously you have to get the court's consent to serve him via the newspaper, whatever the case may be. And then you approach the court, and the court will obviously grant you consent. But as I mentioned early on, the best thing to do is to get a holistic order whereby you will never require this person's consent again going forward. Making an application for substituted service, meaning service via the newspaper, it can be very expensive. So try your best to find the whereabouts of the father. Getting a tracing agent, some of them do not charge if they don't find the person. It should not be that hard. Speak to his family and so on. Next question, somebody that partook in last week's webinar, welcome back again. As I mentioned last week, I am busy waiting for the report from the family advocate. My ex-husband seems to be very confident that he will be granted primary residency of our son. He has created a fake Facebook profile and stalking my page. Makes it seem like I'm promiscuous, and based on my social life, says he will be granted residence. Does the family advocate take into consideration the social media status of a parent, or is it solely based on being an unfit parent? Yeah, I think the family advocates are past, looking at social media and let's say, you're living a good life. I mean, when you're dealing with these type of matters, you have to look at the matter based upon the facts of the matter. Who can care for the minor child better? So if you are somebody that enjoys partying and living the good life, and if you are promiscuous, I'm being hypothetically here, the question still is, can you care for the child? That is the bottom line. So if you go out at night, the child is well looked for after at home, and you go out and you enjoy yourself, you're allowed to do that as long as the child is being cared for properly. So I hope that answers the question. So what your ex-husband is doing, he's doing that, but I don't think the court will make a decision based upon that. There's so many other things to look at. It's like a car is worth, they say, 500,000 rand worth, and now the tires are dirty. Doesn't make the car now less worth. The car is still expensive worth, So we don't look at the tires alone and make it say, no, because the tires are dirty, the car is useless. We look at the thing holistically. So I hope I answered that specific question over there. The court will have to apply their mind to the matter and make a decision what's best for the child, just considering all factors. Another question, are magistrates trained to realize when they are dealing with a narcissist? I do not think they are trained specifically regarding that. I think they should be able to see it, if they are dealing with that. But sometimes with the limited interaction with this person in front of the court, they would not necessarily know that, because a narcissist puts up a certain presentation, and you'll only know this person is a narcissist if you dealt with that person on a regular basis for months, or you lived with a person, or you're in a relationship with that person. You do not necessarily find it out at the first meeting with this person. And I would imagine these magistrates meet with these people, they waited 20 people before him or her. That person comes in front of him, puts their best foot forward, and the magistrate would not be the wiser. And a comment regarding that, good question to that person that asked about a narcissist. Another question. Oh yes, another person commented over here. It says, you are welcome to join me in contacting the media. So ladies and gentlemen, those are all the questions that have been posed today. I see no questions on the Facebook Live. Any of my Zoom participants, if you have any questions, you're welcome to pose it now. We are now entering into exactly 1 hour. That's a good time to end this webinar. But if there are any questions, you are welcome to pose it. You're welcome to put up your hand. If I have not dealt with any of your specific questions, please feel free to put up your hand and I will deal with that. Okay, I see the hand up here. You're welcome to unmute your microphone, the person whose hand is up.
Thank you. I hesitated just in case someone else would like an opportunity, because I did have one earlier. I take note of what you've said about pursuing further and going to the media, etc. And I've jotted down a few ideas of places. It's not the first time that I've heard this. And I tell you what's been holding me back is the fear of obviously retaliation from the narcissist. And because, he would be crazy enough, even if he has no money, he would take a loan out just to sue me for defamation or, whatever the case may be. So should I be concerned about going to the media, or should I refrain from naming his name? How would you advise to go about pushing the matter forward publicly and yet being safe enough? Because I clearly can't afford to defend myself.
No, that's fine. I understand where you're going to. I think, if you'll be laying a complaint against the maintenance officers, and you'll be laying the complaint to them formally, number one, and you'll be most probably informing the media as well that I have a problem with the maintenance courts, with the maintenance system. So they might not necessarily be interested in your specific facts. They will obviously not mention the minor child's name. They won't mention certain parties' details. They shouldn't do that. But you are now making it public to the media that the maintenance courts are acting inefficiently. Maybe not only it doesn't apply to your specific case, it applies to various other cases as well. So that would be the angle regarding that. Your angle will not necessarily be I'm exposing my facts, my specific case to the maintenance court or to the media. Okay. I'm exposing the issue that I have with them not assisting me. Are you with me on that?
The general issue, I get that, and I would be able to do that. However, when going back to the maintenance court, because my issue is as yet unresolved, does that not mean that I would now have jeopardized my own application? Wouldn't they hold that against me?
I do not think so. I would say you would fall more of a... It depends on your complaint. You are complaining to the media that the maintenance courts are inefficiently dealing with my matter because I have climbed the ladder. I have gone further up. I have complained to the court manager. They have not assisted me. I've laid a formal complaint. I've laid a formal complaint to the local government, provincial minister of justice, dealing with the issues I have with the maintenance court. And I'm still nowhere where this is concerned. Therefore, I'm informing the media about the problems I have with the maintenance court. Are you with me where that is concerned? So, but I would advise you to first maybe follow those specific avenues.
Okay.
Formally doing it and advising them that you do not assist me, I will have no alternative but to expose the improper functionings of the maintenance court, because this is now my time frame which I have, and as I mentioned earlier on, when you move now to from Wynberg to Pinelands falling under Cape Town, they should have expedited your file, because they should have, if they could not have granted you with a interim maintenance order in Wynberg because you now moved, they should have ensure that the file is as quickly as possible. It goes down to Cape Town Court with notes in place stipulating we do not have jurisdiction. Please assist this lady as soon as possible. So if you look at the Maintenance Act and look at the regulations and look at the Constitution and the Children's Act and all these specific laws, the case laws applicable, you would think that anybody going to the maintenance court, they will act as an ER, as an emergency room, working as quick as possible to assist you. That is the theme that comes out of the law and the legislation. But the reality is, when you go there with a child that's hungry, people not being fed, people not having money, although the other party has money to pay, they don't treat it as an emergency. They treat it as another file which will deal with in due course. And that's a flavor which needs to be presented to the public, telling them that despite the maintenance courts and the law coming across that the maintenance courts are there to assist you. Yes, and they do assist many people. Don't get me wrong. I'll be honest with you. I have to be fair. But my case over here, they have not dealt with it in a very fair fashion. And I would like to conclude. So I've followed all possible remedies I could have followed internally. They still didn't assist me. I have no other alternative but to expose the maintenance system.
Okay. Okay. Thank you.
You're welcome. You're welcome to, for that. So unless there's anybody else who's putting up their hands, I think we are basically done for today. And I would like to thank each one of you for posing those questions, all those 13 questions, for those of you who have registered for this webinar. There is a webinar next week and Saturday again. It will most probably be again at 11:30. please register for that as well. And I like this interaction, and that's the only way we can all this benefit and learn from each other. So, and those of you who have came on the voice, unmuted the microphone, thank you very much for that. And those of you who pose question as well live via Zoom. I hope you have a lovely day, Saturday. It's now 12:33. I hope you have a wonderful weekend going ahead, and I hope to see you online next week and soon again. Thank you very much. Good afternoon. Thank you for joining us on this live webinar. Today's topic, does child custody matters need to be a fight? And if you can see on my right-hand side, there's a lady hitting a guy. I'm not trying to be gender unequal, in the sense of why is a female hitting the man. I did for a picture online, and that's the one we could find. Nonetheless, it's proverbial, fight, not necessarily physical. Does child custody matters need to be a fight, in the sense of, must it be a battle? Must it be an argument? Must you get lawyers on board? Must you, put up guards and prepare yourself to take the other party on, or to teach the other party a lesson? Must there be acrimony? That's where I'm going to. Or can the matter be amicable, friendly, settled easily? Is that possible? Or does it need to be a fight from the word go? For argument's sake, if the mother says, "Father, is it fine if you do not have contact on a Sunday evening so that the minor child can come home early in order for me to prepare him for school the next day?" The father says, "How can you tell me that? I'm the father. I can decide when I want to bring the child back." There's this continuous acrimony, argumentation all the time. So that's the topic. Does child custody matters need to be a fight? Or can it be amicable? Can it be friendly? My advice to you is, if you want to get good results out of your child custody matter, it should not be a fight. That's where I'm going to. Once parties are no longer civil with each other, whereby the parties are now arguing with each other all the time, they're always involved in acrimony, they're no longer amicable and civil as they used to be while as they were together as husband and wife, as partners, lovers, friends, whatever the case may be. Once that is out of the window and the parties are losing respect for each other, the challenge which we as lawyers and third parties who are there to assist parties in resolving the issues have is that the door, or that one specific door that you could always use in order to resolve issues, are no longer there. That is the respect the parties have for each other. I can use a simple example. If there's a meeting taking place, there's a chairperson, and there are parties to the meeting, and the meeting follows a certain procedure. When one person speaks, the other person listens, and so on. You can object if you want to, but in a very nice and proper way. However, if people start shouting at each other, they start disrespecting the chairperson starts disrespecting the participants of the meeting, what happens then? They lost respect for each other. It is virtually, not I want to say impossible, but it will be extremely hard for the parties to move forward in a constructive and a workable manner. It's very hard. Therefore, the question which I am posing again, does child custody matters need to be a fight? My answer to that is simple, no. It does not have to be a fight. It has to be understandable. There needs to be understanding. The parties need to be able to be in a position to listen and ponder upon what the other party is saying, where they're coming from, where are they going to, and with the hope that the other party will understand where you're coming from and where you're going to. However, if the parties are entering into the specific arena, into this ecosystem, with the intention of battling and fighting and showing the other party a thing or two, 9 out of 10 times, the matter will not be resolved in an amicable manner. And what does it mean? It means that you have to get lawyers on board. You might not get what you are entitled to. Justice might be delayed. For argument's sake, let's say you are the father and you'd like to have contact with the child on a certain date, because you took this antagonistic approach in dealing with your specific problem. The other party might be very hard hard-headed, make life very hard for you, causing you to incur more fees, causing you to pay lawyers a lot of money in order for them to fight your battles for you. And at the same time, should this matter come to a court, to a tribunal, the magistrate's court, the children's court, whatever the case may be, and they see these issues before them, that father and mother are very toxic with each other. In other words, whenever the mother and the father are in the same room together, they start arguing, they start fighting. And that might have an adverse effect upon which order or what type of order the court may make in the specific child custody matter. So in short, that's what this video is all about today. That child custody matters need to be a fight? The answer is no, it does not have to be a fight. It is advisable if it is not a fight. In that specific way, you will get the best possible results in your matter. I hope it assists you, and thank you for watching, and I hope you have a lovely day.
Good afternoon. My name is Mohammed Abduroaf. I'm a practicing advocate in the Western Cape, and today's short video will deal with the aspect of child maintenance. When it comes to child maintenance, the child's best interests are of paramount importance. This principle is immortalized in our Constitution and applied in our courts of law. Therefore, in relation to child maintenance matters, and specifically to child maintenance courts, the moment a parent files an application for child maintenance, the principle should apply. Before we move on a side note, it is not only child maintenance that a maintenance court deals with. A spouse may take the other spouse to the maintenance court for personal maintenance. Let's move on to parental maintenance obligations. Both parents have a duty of support towards their minor child's proper living and upbringing. This should be in accordance to their means, standard of living, station in life, and the needs of the child. This is found in our Constitution, common law, and also applies to divorced parents. According to Section 15.2 of the Maintenance Act, the duty extends to such support as a child reasonably requires for his or her proper living and upbringing, and includes the provision of food, clothing, accommodation, medical care, and education. Furthermore, the duty is not discharged when one parent earns substantially more than the other. According to Section 15.3 of the Maintenance Act, in determining the maintenance amount, the maintenance court must take into consideration the following: that the duty of supporting a child is an obligation which the parents have incurred jointly, that the parents' respective shares of such obligation are apportioned between them according to their respective means, and that the duty exists irrespective of whether a child is born in or out of wedlock, or is born of a first or subsequent marriage. Any amount so determined shall be such amount as a maintenance court may consider fair in all the circumstances of the case. Lastly, there is an onus on both the maintenance officer and the maintenance magistrate in placing evidence before the court in determining a fair maintenance amount. This is our starting point. Processing the maintenance application. When a parent approaches a maintenance court for child maintenance, it is the duty of the maintenance clerk to expeditiously process the application. In doing so, the clerk, through the other resources the maintenance court might have, should ascertain the details of the other parent and ensure that he or she is brought to the maintenance court as soon as possible for a maintenance inquiry before a maintenance officer. Therefore, for example, should the maintenance clerk not have the living or working address of the father or the mother, then he or she must enlist the assistance of the maintenance investigator to obtain it. For that, he or she can make use of search companies, tracking resources, the maintenance investigator, and furthermore banks, SARS, etc., in order to obtain the details of the other parent. Now, let's move on to the issue concerning getting the non-paying parent to the maintenance court. After the maintenance application has been processed, it is a duty of the maintenance court to ensure that the non-paying parent makes his or her way to the maintenance court as soon as possible for a maintenance inquiry. This inquiry is held before a maintenance officer. Even if the maintenance court's diary is quite full, it should still be expedited, giving both parents adequate time to make arrangements to appear at the maintenance court. Therefore, if the next available date for the maintenance inquiry is in 3 months' time, the parties can use this time to make arrangements with their work, obtain necessary information for the inquiry, or make alternative school traveling arrangements for the kids. There should therefore not be a delay in notifying the parents of the date of the maintenance inquiry. Furthermore, when notified of the court date, both parents receive a document stating what information they should bring to the maintenance inquiry. These include 3 months bank statements, salary advice, and proof of expenditure for the parents and the minor children. Giving the parties adequate time to obtain this information will be vital and in the child's best interest. The last thing we want is for the matter to be postponed to another date due to either parent not having been given adequate time to obtain such documentation, even though the mother made the application many months ago. Now let's move on to the maintenance inquiry before a maintenance officer. The maintenance inquiry is the next legal step in the process. This is where both parties appear in court. This is where things becomes a bit interesting. Sometimes at the inquiry, it is the first time the parents are in the same room together. Since the child was conceived, quite often both parents do not know how much the financial both parents do not know the current financial affairs of the other parent. The parent asked to pay the child support, furthermore, does not know how much a child costs to be maintained. Then we have the possibility of the issue of denial of paternity. What sometimes happens is that the father denies paternity. This he would either do out of spite or due to genuine doubt on his side. This would often be the case if there was a brief encounter between the parties when the child was conceived. Sometimes the father is married to someone else, and for the sake of his current marriage, he needs to deny paternity. Once the paternity tests are finalized, the parties would need to return to court again for the results. If the results are positive, in that he is the father, then the inquiry proceeds. If he is not the biological father, the application would obviously be removed from the role. Now we can move on to the role of the maintenance officer. Again, the golden standard in which the inquiry should be conducted is that of the child's best interest. This is of paramount importance. The maintenance officer should therefore ensure that all the financial information about the parties are properly disclosed. This is very important. However, at the same time, the maintenance officer should try to settle the matter, taking into consideration the child's best interest. Should the parents not be forthcoming regarding their income and expenditure and the needs of the child, then the maintenance officer must subpoena witnesses if need be and make use of the maintenance investigator, which is dealt with next. Section 7.1d of the Maintenance Act empowers the maintenance officer to require a maintenance investigator of the maintenance court concerned to perform such other functions as may be necessary or expedient to achieve the object of the Act. Section 7.2e of the Maintenance Act empowers the maintenance investigator, after being so instructed by the maintenance officer, to gather information concerning, number one, the identification or whereabouts of any person who is legally liable to maintain the person mentioned in such complaint or is alleged so liable, the financial position of any person affected by such liability, or any other matter which may be relevant concerning the subject of the complaint, or gather such information as may be relevant concerning a request referred to in section 1c above. Now that we looked at the important role of the maintenance officer and maintenance investigator, we move on to the role of the maintenance magistrate. This is where the formal inquiry takes place. Should the parties not be able to come to an agreement regarding the amount of child maintenance to be paid at the inquiry before the maintenance officer, the matter would then have to be taken or forwarded to the maintenance magistrate for formal inquiry. Here the court has to properly consider the means and needs of the mother, the means and needs of the father, and the needs of the minor child, therefore make a maintenance award. There is a legal obligation upon the maintenance officer and the magistrate to conduct a thorough inquiry. The court should not play the role of an umpire. Therefore, a passive attitude should not be taken by a judicial officer in a maintenance inquiry and then give judgment. Should all go well, at the end of the inquiry, a maintenance award should be made. We thank you for watching this video, and we would appreciate it if you could share this video, and we're looking forward to you partaking in the next live video. Thank you.
Good morning. Thank you for joining our live webinar. Today's topic, child custody and child maintenance, Q&A. Good morning. I received a few questions from persons regarding this topic, and it seems to me that there is a need for a live Q&A at least once a week, whereby you can send us questions and we can deal with it live on our platform. We have a few questions. I'll get to it shortly. The way we'll be dealing with this webinar, if you wish to pose any questions, please do so on the Advocate Mohammed Abduroaf Facebook page. I'll be keeping an eye on that specific page. So if there are any comments made, I will deal with it and I shall answer it. This specific webinar will be about, about 15 to 30 minutes maximum. Therefore, if you have a question, please pose it as soon as possible. Sometimes there's a delay from the time you press enter to when it appears on my screen. I have 4 questions which has been posed already. How often can I apply for child maintenance increase? How long must I wait until I can apply for a reduction? Interesting question. What do I do if my child does not want to visit the father? Happens often. Who has a larger say over the child's life, the mother or the father? So those are the questions I'll be dealing with. And if there are any other questions, please leave a comment on the Advocate Mohammed Abduroaf Facebook page and I will deal with that as well. Let's head into it immediately. Okay, the first question. How often can I apply for a child maintenance increase? So let's deal with the scenario. The parties could not come to an agreement regarding child maintenance for whatever reason, and one party approached the maintenance court. The maintenance court obviously had to do an inquiry, and the parties may have agreed to it as well. It happens often whereby parties do not wish to litigate child maintenance issues. They come to an agreement, a sensible agreement, and that specific agreement is made in order of court. That could be the one scenario where the parties approach a maintenance court, or one party approaches a maintenance court and the maintenance court makes a maintenance order. So that's a date when the maintenance order was made. The other scenario could be whereby the parties where the parties got divorced. And the divorce court, either the magistrate's court or the high court, made a divorce order with a maintenance clause in it. So there's another scenario where a maintenance order has been made. And it happens sometimes where the children's courts make parenting plans in order of court, and inside the parenting plan there's also a maintenance provision. So those are the 3 potential scenarios. Now the maintenance order is made. The question which the questioner posed was, how often can I apply for child maintenance increase? Now, looking at that specific question, there's 2 legs to it. Number 1, the maintenance order was made, the party applied for child maintenance increase sometime thereafter. The question is, when can I apply for it again? Or if you are watching this video, another scenario which I'll be dealing with is how soon after the maintenance court made a maintenance order, an increase or a first order, can you apply for an increase? The long and the short of it is there is no specific date. That's very important to note. The moment there is a change in circumstances for either you, the applicant, the mother or the father, or in relation to the child, that justifies an application for an increase immediately. I'll give you a practical example. Let's say the child currently attends a school, and the specific school carries on from grade R right through to grade 12. Fine, the child is in that specific school. In grade 7, for argument's sake, something happens, the parties moves out of nowhere, they have to move to a different area, and now the child needs to change schools. School fee is much higher. Although the mother applied for maintenance a month ago, because of this new circumstances that arose, which causes the child to cost much more money, automatically there's a material change in circumstances, and the mother can apply, or the caregiver can apply to the maintenance court for an increase. Now, the maintenance court made an order stipulating that the father should pay more maintenance because there's a change in circumstances. They looked at his income, his expenditure, the mother as well, and the child, and they worked that amount. Okay, father, you need to pay more child maintenance because the child is attending a different school, despite you've been at my doorstep 3 months ago where I dealt with this matter for an increase, but the issue regarding the change in the school was not on the table. Let us say, for argument's sake, going forward, the child attends a new school. For some or other reason, the father loses his job. He no longer can afford to pay the child maintenance or to pay a certain amount of child maintenance. Immediately then, he can apply to the maintenance court for a deduction. But that deals with the second question, which I will be dealing with shortly. And at the same time, should the mother, for argument's sake, under these circumstances, although she applied 3 months ago for an increase, the court granted it to her because the child cost more money. Last month, she applied for another increase because the child changed school. Now, all of a sudden, a month later, COVID-19 kicked in, she lost her job. Then she can apply for another increase in child maintenance. So there is no specific time period. I think you guys figure that out based upon my discourse. Nonetheless, if there is a change in circumstances, you are welcome to approach a maintenance court, and they should be able to assist you. Let us deal with the second question, which I touched on a small bit early on. How long must I wait until I can apply for a deduction? Same principle applies, a reduction or an increase. So usually the deduction would be the person who is paying the child maintenance. If his or her circumstances have changed, even if the circumstances change regarding the other parent, for argument's sake, let us say the father is paying the child maintenance and he's happy with the amount and he can afford to pay the amount, but for some good reason the mother became extremely wealthy. Now the question is, must he still pay half his salary or quarter of his salary toward child maintenance, despite the mother being extremely wealthy, whereby she only spends not even 1% of her salary towards a minor child because she came across a lot of money? Those are material circumstances that causes and allows the father to approach a maintenance court soon and immediately, stipulating there has been a material change. The mother is not providing maintenance according to her means. Her means is much, much more. And also at the same time, it's not fair that I spend a third of my salary toward child maintenance, whereby the mother is extremely wealthy and she's paying much less. So under those circumstances, the father would have a case because there's a change of circumstances regarding the other parent. You will have to deal with the matter based on almost with the same situation. Let's say there is no maintenance order in place and the mother is super wealthy, the father is not so wealthy. Obviously, the court will make a reasonable order stipulating the father should pay a smaller amount. Therefore, when the father applies for deduction based upon the fact that the mother is earning much more money, the court will have to look at this matter again, rework out the mathematics and what is a fair amount. And at the same time, should a child attend a very expensive school, during primary school for argument's sake, till grade 7, a very expensive school, and the father is paying half the school fees, but not directly to the school, a monetary amount, which is a globular figure, which is towards the maintenance of the child's school fees, clothing, food, accommodation, etc. Now the child goes to high school and she gets a bursary, whatever the case may be. The result thereof is that the child's education expenses are extremely low. She must only pay the registration fee and a small monthly fee, and that's it, compared to what they paid previously while the child was in primary school. Under those circumstances, because there is a material change in the mathematics, in the expenditure of the child, that causes a father to make an application to court for a reduction in the globular figure of maintenance which he has to pay. I hope that answered that specific question. So there is no time limit on whether or not you can make an application for an increase or a reduction in child maintenance. Please note, if you have any questions, feel free to leave a comment and I will deal with that. I shall deal with it. The next question deals with child custody. It goes as follows. What do I do if my child does not want to visit the father? Okay, there are two scenarios. Number one would be there is no court order in place, no children's court order in place, no divorce court order in place, which allows or affords the father care and contact rights to the minor child. If there is no such court order in place, that becomes a bit difficult for the father side. But let me deal with the other scenario. The other scenario will obviously be where there is a court order in place, whereby the children's court or the divorce court specifically says that the father should have contact with the minor child every second weekend, half school holidays, birthdays, Father's Days, religious days, and so on. If there is no court order in place and the child does not want to visit the father, that is quite a concerning thing, because the question is, who's sitting in front of me? Is it the mother or the father? If it's a mother sitting in front of me, then I would advise the mother, please go to a professional person, a psychologist, a social worker, to determine why does the child not want to go to the father. Not based upon what the child is telling you. I do not want to go to dad, because whenever I go to dad, dad's other children are there, his stepmother is there, and I don't like them very much. I prefer to be at home playing PlayStation, being online, etc., because there's Wi-Fi and all the good stuff is here. But my dad is no swimming pool, and I prefer being here. Those could be the child's reasons. Are they good reasons? Are they long-term sufficient reasons for a child not to have any contact with her father? Because this is life. People move on with their lives. Or is the reason, no, I do not want to go to dad because whenever I'm a dad, they scold at me, they rude at me, etc. But that's what the child is saying. We need to get a professional person, a psychologist, social worker, to speak to the child and determine why does the child not want to go to the father? Are they cogent reasons? Are they good reasons? Are they the child acting up? Child playing against both parents? Is it silly reasons? That's what needs to be determined. So the expert will have to speak to the minor child, speak to the father, speak to the mother, and try to resolve the issue. What is in the child's best interest? Is it in the child's best interest to stay by the mom, watch TV games, screen time, and have no contact with the father, and 5 years down the line, when the child is older, she moved away from her dad, and they just became, estranged from each other? Is that in the child's best interest? Or is would it be in the child's best interest if the father tweaks some of his behavior, the mother tweaks some of her behavior, the child does the same, and they try to resolve this matter? So that's a scenario whereby the parents have no order in place. The expert will hopefully try to assist the parents in trying to resolve this matter. Why does the child not want to go there? That's now where the mother is in front of me. If the expert says, no, mom, I think it's best for the child not to visit the dad because of X, Y, and Z, and this is my report, and then that report needs to be seen to the father, and the father needs to come to terms with that. And hopefully the father will work towards the recommendations in the specific report. If the expert recommends, no, child, you need to go to the dad, there's nothing cogent in what you are saying, you're just being unreasonable, like any child might be under those circumstances, and then the mother should cooperate and work towards the father having contact. If the father is in front of me and he tells me the child does not want to have contact with me, then I would also follow that specific route and stipulating, get a third party on board to investigate, to speak to the minor child and find out what the reasons are. If the child does not, if the expert, who gets on board, states that it's best for the child not have contact, or contact should be limited, or contact should be this or that or that, the father needs to take note of that, and the father needs to work towards fixing things so that contact can